Welcome to the 2021 Municipal Advisor Outreach event. My name is Mark Stewart, and I'm an attorney in the Office of Municipal Securities here at the SEC. With me today is Sylvia Pilkington, Senior Business Analyst with the EDGAR Business Office. The first session that we have for you today is an EDGAR tutorial panel. Now, before we begin, I need to provide our standard disclaimer. The views that we express today are our own and do not necessarily reflect the views of the Commission, any of the commissioners, or any of our colleagues on the Commission staff. Now, this panel may serve as an introduction to some of you and a review of certain concepts for others. The focus of this panel is to review the process to complete and submit Form ID in order to gain access to submit EDGAR filings, and to review the process to submit the Form MA series of filings. Finally, we'll be discussing some common issues we want to help filers avoid, as well as identify tools available to assist filers in preparing their Form MA submissions. With that, let me start by welcoming Sylvia to discuss some of the technical aspects of submitting EDGAR filings. Sylvia.
Yep, good morning, Mark. Thank you. So let me share my presentation. Alrighty, so we can begin. As Mark said, I'm from the EDGAR Business Office, and I'm going to do an EDGAR demonstration for you today. So before we begin, let me give a little overview of what the EDGAR Business Office is. So we are comprised of everything EDGAR. We engage with our internal stakeholders to develop new requirements that make it easier for the staff to process submissions once they are received, and then also help to develop requirements for any new rulemakings. We also coordinate with our technology office and external stakeholders for any production issues that arise. We support our EDGAR contractors in completing the development work. And we are also comprised of our filer support teams. One is the filer technical support team that can help you with any technical issues that you encounter while you're trying to make your submissions. We also have the filer support office who can help you once your submission has been submitted. They also process our Form ID submissions for us. So today I'm going to walk through the Form ID submission and how to do your password update, and then give you an overview of what the Municipal Advisor submission forms look like in EDGAR. So for the Form ID, to access the Form ID, you have to go to the EDGAR Filer Management website, which is this link here. And then from that link, you'll get to that, or you press that link, you'll go to the screen and it'll say press here to continue. And then once you get to the main page on EDGAR, you'll click the link on the left-hand side that says Apply for EDGAR Access New. If you already have a CIK, you shouldn't use that link. You should use the Generate Access Codes New Replacement link to update your codes. So after you click the Apply for EDGAR Access link, you'll be taken to the main page for submitting the Form ID. Once you get there, you can click the Apply Application for EDGAR Access button, and then click the Next button to get to the Form ID itself. And then, or if you've already been here and have already done this process, there's also a Continue with the Save Submission. So if you saved your Form ID and need to come back to it, you would use that link. And then once you click the next button on to get the Form ID, you will fill out this form. And since you're a municipal advisor, you need to make sure that in the applicant type that you choose municipal advisor, and then fill out your form, and you'll have to get this notarized before you can submit it. So to do that, you would have to fill out all the fields that are required, and the required fields are marked with an asterisk beside them. And then once you do that, you can print the form, and it'll print with all your information included, including a notarization box at the bottom of the form. So once you get that notarized, then you can upload that as a PDF and then come back to this screen and do continue with your saved application. Open that up and then go to your Documents tab and attach that notarized document as a correspondence. And once you're done that, then you can submit your Form ID. And if you save your Form ID while you're working on it, it's in EDGAR, the form saves in a certain format, so you don't want to open that saved file in another application because it'll corrupt the file and you won't be able to use it. You'll lose all the information that you currently entered to if you do it that way. You can also, if you need to, attach a power of attorney, which should be attached as a correspondence if you need to also do that. And in your Form ID, there's a passphrase link. You would create a passphrase that you would use once you get your Form ID is accepted and your CIK is generated. You would use your CIK and that passphrase that you created to generate your access codes. Once you submit your Form ID, it takes our filer support office 24 to 48 hours to process it. But once you also submit, you will get an accession number. You would also want to take note of that, just in case you have any issues that you need to contact filer support. You'll be able to give them that accession number so they have some sort of reference to help you. Once you get your email that your Form ID has been accepted, and includes your CIK with it. So when you go back to generate your code, you'll go back to the filer management website. You'll click on the Generate Access Codes New Replacement link, and you'll get this screen where you'll enter your CIK and your passphrase. And then you'll click the Generate Access Codes button, and this button will generate all your codes that you need to file. It includes your password, your CCC, and a PMAC. So the CIK is your central index key. That number is unique to your entity. It's permanent and it never expires. The password is used to sign on to the EDGAR filing website. It expires 12 months after it was last created or changed. Your password shouldn't be provided to a filing agent. They don't need that in order to file on your behalf. The CCC is the CIK confirmation code. It's used in combination with your CIK so that EDGAR can authenticate that it's a legitimate CIK making a submission. The PMAC is the password modification authorization code, and that is used to change your password. So if you need to update your your password, then you would need to go back to the filer management site and click the Generate Access Codes and do that same process all over again. If you have a CIK, but you forgot your passphrase, you'll need to create a new one. In order to do that, you'll have to go back to the filer management site, click on the Update Passphrase link, where you'll get the Update Passphrase pop-up screen. And in there, you would click on the request a token link here, which would be, the token will be sent to the email that is on file for that CIK. If your email is incorrect for that filer, you would need to do the manual process. And in doing the manual process, which is this screen, you would have to enter some information, and it's like submitting another Form ID, and it takes 24 to 48 hours to process it that way. So once you have your CIK and your codes, you're now able to submit your municipal advisor forms. And to get to the MA forms, you would have to go to the EDGAR filing website and use your CIK and your CCC to sign in. Once you sign in, on the left-hand screen, on the left-hand menu, you'll see a link for the File Municipal Advisor forms. You would click that and it would take you to the main page for the Municipal Advisor forms. And so under here, you can choose the appropriate file that you need to submit. Under the MA heading, there's three choices. You have the initial form, the annual form, and the amendment. Under the Form MAI heading, you have two choices. One is the initial form, the amended form. There's also another box here that if you're submitting an amended form and you need to indicate that the individual is no longer an associated person of that municipal advisory firm or no longer engages in municipal advisory activities, you would check this box. Once you do that, then you click the next button, it will open up your form. There's also the Form MAW, which is your withdrawal form. You can also, if you have already been here and have saved your file, use the continued with the saved municipal advisor form. You would click that link and browse to where you saved your .EIS form and click the next button. And these are, the last two slides give you the MA submission types and what they look like. So for the MA forms, this is the initial form. And to submit this form, you would have to enter your CIK and your CCC. And then it also has different tabs here that you would click and fill out all the required forms that are needed. I mean, all the required fields and information that is needed. Once you fill out this form, you can attach documents to it. You can either save the form or print the form, or you can submit it. And then the last screen is our MAI form type and our MAW form type. Both also have tabs on the side that you can click in, or you can use your next button to scroll through. So with that, that concludes the demo, and thank you very much. And back to you, Mark.
All right. Thank you, Sylvia. Appreciate that. So now I want to walk through some common issues that we see that we'd like profilers to avoid, and also go through some questions that we typically receive. The first issue I want to discuss involves submitting the Form MA annual amendment for the incorrect fiscal year. Now, as a reminder, there's an annual requirement for municipal advisors to submit their Form MA annual amendment within 90 days of the end of the firm's fiscal year or calendar year in the case of sole proprietors. That's very important to ensure that the correct fiscal or calendar year is entered into the system. And basically, when you're going into EDGAR to submit the annual amendment, the first prompt that I believe that you're going to receive relates to entering the fiscal year in which the filing applies. And I want to note that the correct fiscal year is the year that recently ended and not the year in which the filing is being made. So for example, a filer with a fiscal year end of December 31st, 2020 would need to submit their Form MA annual amendment by March 31st of 2021. And in completing the MA annual amendment, the date for the fiscal year end should show December 31st, 2020, and not December 31st, 2021. So this is an issue I feel like we see a couple times or a few times each year, easy to avoid. But in summary, first and foremost, please submit your annual amendment, but please take your time in doing so. It will help you to avoid spending time to remedy the issue by submitting a subsequent filing. Now, the next issue I want to kind of go through involves an individual or natural person MA switching firms and then submitting the subsequent Form MAI disassociating amendment. Now, the proper procedure when an individual municipal advisor leaves one firm to join or become an associated person at a new firm is to file an amended Form MAI indicating the individual is no longer engaging in municipal advisory activities for the underlying or former employer MA firm. So filing this disassociating amendment is done by checking the box under type of filing under Part 1 of the Form MAI, which is actually located on just the very first page of the form. Also, a new Form MAI must then be submitted for the individual MA with regard to the new employer firm. So 2 steps there. Please do not file an amended Form MAI whereby the existing Form MAI on file for the individual MA is just amended to indicate a municipal advisor firm employer change. Right? That's the incorrect method to showcase this type of a change. Relatedly, an issue we see with municipal advisor firms withdrawing the registration and submitting the Form MAI disassociating amendments. It's important for the withdrawing firm to submit the Form MAI disassociating amendments prior to submitting the Form MAW. Otherwise, if the Form MAW is submitted first and accepted, it creates access authority issues with the ability of the firm to submit the subsequent Form MAI disassociating amendments, which just in turn requires extra time and work by the withdrawing firm to fix. Now, hopefully, no one attending this program is planning on filing a Form MAW in the near future, but important to know all the same. Also, I wanted to talk about the proper method to indicate an organizational change for a municipal advisor firm. I think this is something that we do see somewhat often. In the event of a municipal advisor changing its company organization structure, such as from an LLC to a corporation, there are a couple updates that need to be taken. First, the filer will need to complete, will need to update its organizational structure in EDGAR by filing what's known as a company update. And the instructions for completion of this company update are available on the Commission website within the EDGAR Information for Filers section. Second, the filer would need to file an amendment to their Form MA so that the form reflects the new organizational structure. So a couple steps there to keep in mind. However, and very importantly, I want to note that this process does not work when an organizational change being made is from an individual to an entity, and the CIK is actually in the name of the individual, because the CIK cannot switch from an individual person to an entity. So for example, if a sole proprietor whose CIK is under their personal name wants to change the organization form to an LLC, they will actually need to complete a new Form ID, a new Form MA, and then ultimately file a Form MAW for the old CIK once the new Form MA is accepted. So important to keep that in mind if you're looking to change organizational structure. So another issue that we actually also seem to see with some frequency deals with actually submitting the Form MAI through EDGAR when there's a gap in the individual's employment history. So one possible solution here, if you're having issues, is to complete the employment history section using all capital letters. It may also be helpful in order to complete 10 years worth of employment history to include time spent in school. Sometimes including employment that occurred more than 10 years prior causes an issue with being able to submit the Form MAI. And also when an overlap occurs within a specific time frame between multiple jobs, that can cause an issue that requires breaking up the jobs. So for example, if a person has one job lasting January through September of 2020, and another job lasting from June through December of 2020, you may need to list 3 entries on the Form MAI. One for January through May with the first job, one from June through September with both jobs, and then one from October through December with the second job. So these are some workarounds that we've come across, I think, over the last couple of years to just aid with getting the document submitted, but still providing the correct information. One question that we've been getting is, do you need to have a Chief Compliance Officer listed on the Form MA? Yes, and I'm going to direct you to MSRB Rule G44C, which provides that each municipal advisor is required to designate one individual to serve as its Chief Compliance Officer. However, I will point out that the instructions within the Form MA are not accurate, as the language within Item 1G actually gives the impression that listing a CCO is optional. The reason for this inconsistency is that the Form MA was actually adopted prior to the adoption of the requirement within G44. So please ensure that you have a Chief Compliance Officer listed within Item 1G. And I will also note that the CCO must also be listed on Schedule A of Form MA. Another question that we get is, can an individual have more than one Form MAI on file at the same time? Yes. Yes, an individual can have multiple Form MAIs on file at the same time. Some municipal advisors work part-time for multiple firms as an independent contractor or a consultant, so it would be correct in those cases for the individual to have an MAI for each firm that they work for. Another issue I think we hear about somewhat often deals with the order of filing acceptance. And basically when a firm submits multiple amended filings over a short period of time, the filer may not see the updated information. It's not necessarily showing up on the respective form. The reason for this is because the Form MA submission needs to be accepted by the commission before the updated information will be available to see within a subsequent Form MA submission. Further, I will note that when submitting an amended Form MA filing, there's no summary that's provided of the changes being made. So if you have a number of changes that are being made on any given form, it might be helpful to keep some sort of log or list of the changes that are being made, because filers can review each section of the form prior to submission. I believe when the form's up, you can actually choose on the select different sections of the form to go back to. So if you're keeping a list, you can easily double back to make sure all the information is entered correctly before you submit the form. But there's no blanket summary listing all the changes that are made for the filer to review. Prior Form MA submissions, though, are available for review on public-facing EDGAR website. Depending on how familiar you are with the public-facing EDGAR, it's a really easy tool to use. Generally using the CIK number or even an accession number, you should easily be able to look up, your firm's filings or a particular filing. However, when preparing an amended Form MA or Form MAI, the form is going to pre-fill, though, with the information from the most recently accepted version of the form. One set of questions I will say that we actually get quite frequently is regarding the time frame for submitting filings through EDGAR and the acceptance of those filings. Generally speaking, once you've filed a complete Form MA, including all the relevant Form MAIs, the Commission has 45 days to review your Form MA and accept the related Form MAIs. If the Commission does determine to grant your registration on Form MA, you will receive an email from the EDGAR system informing you that the filing's been accepted. You'll also receive a separate formal order through the mail. And then you can always check public-facing EDGAR to see if your registration's been accepted. The point being, though, we're not going to leave you in the dark about the status of your registration. If it gets accepted, we're going to make sure and find a way to let you know. But further, I'll note with the Form MAW that it's actually effective 60 days after filing. With regard to submissions, though, through EDGAR, the system, the EDGAR system is available for submissions Monday through Friday, except federal holidays, from 6 a.m. to 10 p.m. Eastern Time. So the system is not open 24/7 for submissions. Please keep that in mind as you plan any further filings you may have. The last question I'm going to touch upon today relates to what is an accession number. And this is a number that's generated to identify a specific EDGAR submission. It's a unique identifier assigned to an accepted EDGAR submission. It's actually comprised of 3 numbers: the CIK number of the entity submitting the filing, the last 2 digits of the year of submission, and a uniquely generated number. So the last piece I have for you today, I just wanted to go through some tools that are easily available to assist filers with any issues that you may have. The first document I want to talk about is called the Instructions for the Form MA Series. This document's readily available through the Office of Municipal Securities website. You can easily find it through any search online. But these instructions provide some basic information regarding the submission of each MA form. There are also some specific instructions regarding certain items within the forms that offer some good guidance to filers on areas that often cause issues. As you all may know, all of the Form MA series of forms are available online. They're available through the OMS website. So you can review those to understand what information you're going to need to provide when submitting your filings. Also, there are 2 volumes of the EDGAR Filer Manual that are available that provide general information for becoming an EDGAR filer and outline the process for submitting an EDGAR filing, as well as some other kind of ancillary, more technical aspects of EDGAR. They're a great resource. They're available. There's a link through the OMS website, and you can easily find them through sec.gov as well. And then finally, always feel free to reach out to the Office of Municipal Securities directly. We can help you with any questions that you have. I feel we're really prompt about responding to any questions that we receive. The phone number for the office is 202-551-5680. And our office email address is munis@sec.gov, munis@sec.gov. That information is available on the OMS website as well. And then finally, we actually have an EDGAR filer support number as well for any technical questions you may have about maybe a password reset or any EDGAR access issues you may have. That phone number is 202-551-8900. Again, that number is also available on the OMS website. So with that, this concludes the EDGAR tutorial panel. If you have any questions, please feel free to send us any follow-up questions that you may have. Thank you for joining us today. We will now have a short break until the official opening of the program begins at 11 a.m. Eastern. Thank you all.
Good morning and welcome to the 6th Annual Municipal Advisor Outreach Event. I'm thrilled you've all taken time out of your busy calendars to spend what I think will be some very quality time with us today. I realize this welcome is late for those of you who joined earlier this morning for the operational EDGAR tutorial. I am Rebecca Olson, the Director of the Office of Municipal Securities. I'm going to start out with a bit of housekeeping, the standard SEC disclaimer. The views expressed by members of the SEC staff today are their own and do not necessarily reflect the views of the Commission, any of the commissioners, or any other members of the Commission staff. Next, I would just like to take a moment to recognize all of the planning and hard work that went into today's event. Many thanks to the SEC staff and our colleagues and co-hosts at the MSRB and FINRA, as well as the industry members who are participating in the panels today. As you will see from your agenda, each panel is organized to provide you with a diversity of perspectives. Before we start, a few brief thoughts on the importance of regulatory collaboration and outreach, which I will preface with a quote from Lin-Manuel Miranda. The fun for me in collaboration is one, working with other people just makes you smarter. That's proven. As you all know, the municipal advisor regulatory regime is established by federal statutory provisions and rules, as well as a full suite of conduct rules that were developed and adopted by the MSRB. If you are a municipal advisor, you may be inspected or examined for compliance with the Commission and MSRB rules by the SEC's Division of Exams, or if you are a FINRA member, a FINRA examiner. Likewise, an enforcement proceeding relating to an alleged violation of a Commission or MSRB rule may be undertaken by the SEC or FINRA. In light of this regulatory structure, we in the Office of Municipal Securities regularly coordinate with our colleagues in exams and enforcement, as well as the MSRB and FINRA, to help promote fair and uniform application of the rules applicable to municipal advisors and provide interpretive guidance to those market participants who may be required to register as municipal advisors. I, for one, can certainly attest that the many years of regulatory coordination with my very thoughtful colleagues has certainly made me smarter. To take it to the next level and help make sure we regulators are all on the same page with you, we regularly host outreach events like today's to promote a greater understanding of and compliance with municipal advisor duties under Commission and MSRB rules. So we have a great panel lineup today, which I will briefly highlight for you. Panel 1 will be moderated by Celia Olgan, Director of Market Regulation at the MSRB, and will focus on practical considerations for municipal advisors managing conflict of interest disclosures. Panel 2 will be moderated by Bonnie Bose, Director of Fixed Income Regulation at FINRA, and focus on operational considerations for municipal advisors. Panel 3 will be moderated by Ernie Lanza, Senior Counsel in the Office of Municipal Securities, and discuss municipal advisors' obligations when participating in a new issue pricing. Panel 4 will be moderated by Cheryl Maddox, Managing Director, General Counsel, PFM, and provide insights on preparing for regulatory examination. In the final panel of the day, Panel 5 will be moderated by Bree Joyner, Director of Regulatory Compliance at the MSRB, and include discussion of SEC and FINRA examination processes and common observations, as well as relevant SEC and FINRA enforcement actions. Finally, I want to let everyone know that audience members can send questions to panelists in real time today by sending an email to 2021 maoutreach@sec.gov. That's 2021 maoutreach@sec.gov. In closing, I very much look forward to our panels today and our discussions of municipal advisory activities. And with that, I will turn it over to my colleague, John Police.
Thank you so much, Rebecca. Good morning, everyone. Let me add my good morning wishes and my thanks to the MSRB and FINRA for partnering with us to hold this event. Thank you also to the offices in the Division of Examinations, Office of Municipal Securities and Enforcement, who have been in collaboration with the staffs of FINRA and MSRB and worked to organize this entire event. Of course, thank you to the panelists for participating today. And finally, thank you to the AV and IT staff who have made this virtual program possible. I know I had trouble logging in and Nick was able to help me out. So thank you very much to everybody. As the National Associate of the Broker-Dealer Examination Program in the Division of Examinations, I'm hoping to give you a little insight into what exams does and what guides our program. Each year, exams publishes its priorities as a roadmap for the coming year, and I assure you that municipal advisors will continue to be a priority of the National Exam Program. The SEC has and continues to work hard to develop an appropriate regulatory framework for MAs, as we understand that rules impacting municipal advisors can often create major changes for the municipal advisor industry. We strive to tailor the framework to your unique roles in the marketplace. In order to do so, the SEC has constantly made it a priority to work with and cooperatively coordinate and collaborate with both the MSRB and FINRA in our approach to the industry. And this program today is an excellent example of that continued effort. Today's program is a good illustration of how we work together, especially in a growing and complex area with unique topics facing municipal advisors. Earlier this morning, the EDGAR tutorial provided some great tips and skills for filers. We'll hear discuss about the industry's obligations related to managing conflicts of interest under MSRB Rule finally, SEC and FINRA agents. I think this is a great chance for us to engage with you and for you to engage with us and to provide more information directly to MAs and firms just like yours. I hope that you enjoy the program, and thanks again to our co-hosts FINRA and MSRB, and hope you have a great day today.
Gail, you can start when you are ready.
Okay, great. Hello, everybody. This is Gail Marshall. I'll be moderating panel 1 rather than Celia today. So thank you for letting me step in. I am the Chief Regulatory Officer of the MSRB. And with me on this panel discussing managing conflicts of interest disclosures is Ashley McNulty, Vice President of Stevens Inc. I also have Ed Vieira, who is Senior Counsel at Bracewell. And I'm also joined by Tracy Palmer, General Counsel and Chief Compliance Officer at Post Oak Municipal Advisors. So thank you for tuning in. This panel will be discussing the conflicts of interest obligations under Rule G42, MSRB Rule G42. So before I start peppering, although I'm not, the panelists with questions, I want to discuss Rule G42 and the obligations thereunder. with respect to conflicts of interest. So a municipal advisor must, prior to or upon engaging in municipal advisory activities, provide to the municipal entity or obligated person client full and fair disclosure in writing of material conflicts of interest, as well as any legal or disciplinary event that is material to the client's evaluation of the municipal advisor firm or the integrity of its management or advisory personnel. If a municipal advisor concludes after reasonable diligence that they have no material conflicts of interest to disclose, then they must provide a statement to the municipal advisor client to that effect. So in either case, you're making a written disclosure to the municipal advisor client. Disclosures must be sufficiently detailed to inform the client of the nature, implications, and potential consequences of each conflict that you disclose, and must include an explanation of how the MA addresses or intends to manage or mitigate each conflict that is disclosed. Disclosable conflicts under Rule G42 include, but are not limited to, so this is a non-exhaustive list, affiliate, advice, service, or products directly related to the MA activities, payments made to obtain the municipal advisory business, payments received to enlist the MA's recommendation of a third party's services, transaction, or municipal financial product, any fee splitting arrangements, compensation related conflicts, and then any other actual potential conflicts that could reasonably be anticipated to impair the municipal advisor's ability to provide advice to or on behalf of the client in accordance with the standards of conduct under G42A, duty of loyalty and duty of care. So with that baseline understanding, I'd like to ask the panelists to provide some information. So this goes out to all panelists. What is your firm's general approach, or it's sort of his view as to the general approach to complying with the conflicts of interest and disciplinary event disclosure requirements?
Okay, good morning. I'll start. We have processes in place to make sure that required G42 conflict of interest disclosures are given with contracts, which would be at the beginning of the municipal advisory relationship, and then before any issuance of securities as well. We also have a review process to look for any new conflicts of interest that may have arisen that would require additional new G42 disclosures. We're doing this review by one of the two main things is looking at outside business activities and then revisiting our client list.
I would agree with Tracy. I think that was great input on what she's doing to manage her conflicts of interest. I think she probably also would agree that having a management commitment to making sure that all of your advisors are applying the best practices to all of your advisory engagements, being consistent. She's described having a process in place, a system that reminds you of what needs to be done and tracking those steps to make sure we all are in compliance with Rule G42. Our firm's made that commitment and is obviously trying to make sure we always are complying with those requirements.
I can jump in here after Ashley.
And Brian, my apologies for leaving you off the list of panelists. So
no need to. No need to. Thank you, though, Gail. We have a multifaceted approach, and I think one of the important is the regular monitoring and maintenance, along with annual disclosures. Similar to Tracy, each individual transaction receives its own disclosure, so there's an opportunity to update any potential conflicts at that point. We regularly require, and by regularly, probably not less than quarterly, updating of things like outside business activities, political contributions, other factors associated with potential conflicts, and try to do a fairly good job of orienting our licensed advisors around the concept that at any point something changes, you're required outside of the regular reporting structure to make compliance aware so that we can comport ourselves appropriately.
Yeah, and Gil, I would just add that, I think these are all great approaches. I'd probably just note that it's important for firms to ensure whatever approach they take that is consistent with their operations. And, as you know, conflicts of interest are present in many contexts, right? So there's no one size fits all framework here, and the way firms manage conflicts. So firms need to assess what approach is most effective given their particular circumstances. For example, a large BDMA shop may not be best suited for the approach that a smaller sole MA firm would take. Likewise, with regional differences in the market, you may see certain approaches taken in New York that are taken differently in Texas or something. So I would just keep that in mind when MA firms are analyzing their approach to compliance here.
Excellent point. Thank you. And with respect to G42, it's material conflicts of interest, and then disclosing disciplinary and legal actions that are material to the client's evaluation of the firm and integrity of its personnel. So for I guess I'll start with Brian. How do you what is the firm's analysis to go about determining what is material?
I suppose I would argue on the side of conservatism, and so our bent is to look at things in a fashion that if there's any question at all, we contemplate disclosing it, and then the mitigation efforts around that. If there's something that's in a very gray area, we may seek outside review and consideration and guidance by counsel, and those are largely things that may affect us across the entire firm, as well as see if we need to update documents and speak to particular conflicts that may have not existed previously. So we have a fairly robust system in place and try to attempt to stay on top of things as things proceed. We'd also have a change control process in place that allows us the ability to amend documents, et cetera, but be exhaustive in our approach so we don't overlook anything.
And would you say that's a different process or similar for disclosing material, legal, and disciplinary events?
I'm happy to say we have not had to do such a thing, so probably haven't thought about it too much. But we regularly, engage with our advisory personnel on those sorts of things. There are also, from time to time, litigation that is brought forth. I'm happy to say most of those get dismissed. Of course, we end up being a party to a suit when we're not the primary respondent. So, nothing outside of the ordinary. We regularly review those things, and like I said, there's always some wisdom in seeking outside guidance from qualified attorneys periodically too.
And Ashley, same question. How do you go about looking at what is material and rises to the level that needs to be disclosed?
So thank you, Gail. So in terms of material, is it important? Is it essential or relevant? Those are the type questions that we ask. In terms of legal or disciplinary, as your question asked, they tend to be a little more clear than some of the reporting on the conflicts of interest. I think on the legal or disciplinary, there's information that we're required to report, and we do provide that in our municipal engagement and also in the G10 information. And so we basically will say if we've had an adverse legal or disciplinary action taken against our firm, we disclose that. We also provide electronic links to information that will give them the most recent and up to date if there have been any changes in that information, to be sure they know where they can go and do their own independent research relative to any legal or disciplinary matters that may have occurred relative to our firm.
Thank you. Tracy, is there anything to add? Is there anything different or unique that Post Oak looks at in answering these questions?
Well, we're a small firm and we have not been in existence that long, so we don't have a lot of personal experience. Fortunately, we haven't had anything major come up at all. So I'm afraid I wouldn't have a lot of guidance that would be personal to share.
Yeah, Gail, I think I would add, the determination of materiality obviously is based on, the facts and circumstances. And as you look at conflicts of interest specifically, it's going to be a broader analysis, right? Because, and I think this goes to what the panelists were saying earlier about kind of referencing the Form MA and Form MAI, which already require legal and disciplinary events to be disclosed. That to me is, at least my understanding of the rule and of the forms is where a good starting point for the material, legal, or disciplinary events category. With respect to the conflicts of interest, I think, determining materiality, the one great thing about Rule G42 is it provides essentially like thresholds, right? Because there's identified events in G42 really focused around affiliates, compensation, and the impairment of the MA's ability to provide advice, which the MSRB essentially puts in the rule. So they're saying that those are material conflicts. So I think when you analyze any potential conflicts of interest, you should really keep in mind those examples in those areas of concern. The MSRB put them there for a reason. Obviously, those are areas that if you were at a firm, you'd probably give heightened scrutiny to, just because these are scenario areas where could be potential for material conflicts of interest. So this is, of course, in addition to any whatever general approach, it's good to keep in mind. And also, it's important to understand that at least the SEC here is being very aggressive in its enforcement interpretation of the MSRB's rules. So it's best to err on the side of caution here when determining materiality and simply provide disclosure to the client, as opposed to trying to convince an examiner or enforcement staff that it wasn't material after the fact. So, and that kind of goes in line with what's being said earlier. I just want to kind of highlight that, though.
And I think it's important to highlight that, in G42, we state that these, are examples of material conflicts of interest, and you pointed out that it's a non-exclusive list, so people have to continue to evaluate other issues that could impair the relationship, or could potentially impair the relationship, or be relevant to client's determination. So, so once a municipal advisor determines that a potential conflict rises to the level of materiality and needs to be disclosed, the rule requires disclosure plus an explanation of how the firm will address or mitigate or manage the conflict. If the conflict can't be mitigated, G42 expressly provides that firms are prohibited from engaging in that activity. So I guess I'll turn this to you, Ashley. Like, how do you go about determining whether a conflict can't be mitigated? And can you give any examples of issues that can't be mitigated that you'd be willing to share with the audience today?
Thank you, Gail. So Ed's given a good description of some of the conflicts of interest that the MSRB has said is particularly important that we disclose. And so I'll go through. Once you've made your evaluation, you've conducted your due diligence, you've determined that there is a conflict of interest, and you've evaluated the facts and circumstances. Once you've identified that conflict, I think you have to ask yourself, can the conflict be mitigated? And I think that's what you were alluding to, Gail. By dealing honestly with the utmost good faith with your clients, you owe them that responsibility. And so it's also a requirement under MSRB rule. So does your client understand the conflict or the potential conflict? Are they comfortable with how you have described what you feel mitigates that conflict? Some of the conflicts that I've seen, as Ed described earlier, that are regularly disclosed involve affiliate transactions such as investment services, arbitrage rebate, treasury management services. That are services that a particular firm may offer in addition to advisory services. So the mitigation offered in that case was that the affiliate departments operate separate or independently under their own set of regulatory requirements. Another potential conflict of interest is that may have competing client interests. So you may have a municipal advisory client that has competing interest from another municipal advisory client of yours, and some of the mitigation disclosure that I've seen refers directly to none of the other engagements or relationships would impair the firm's ability to fulfill its regulatory duties to the client. The other things we see, particularly as Ed described, fee splitting arrangements or consulting fees may be or may present potential conflicts of interest. There's some conflicts, as we've described, that just really can't be mitigated. And I think our firm's policy, I can share that in terms of in municipal advisor engagements, the firm may not engage in any activity if it cannot manage or mitigate any conflict arising from such activity in a manner that will permit it to act in the municipal entity's best interest. It's pretty straightforward, but I think that gets to the point that, you know, if you really can't reconcile your client's best interest with the conflict, then you may not want to continue with that advisory relationship. So one thing I would add, if you're very close to the client or have a very strong relationship or a long-term relationship and you run into a potential conflict, it may be helpful to bounce some of the conflict potentiality off of your compliance officer or a fellow advisor just to get their third-party assessment of if you're too close to the relationship. It may help to have a sounding board. They may have suggestions or ways to mitigate the conflict as well. And then, so the other thing I might add is that you want to be sure that in writing, you notify your client of the potential disclosure and if it can or cannot be mitigated. It's important to always document that.
Okay, thank you. Brian, anything to add that's unique or different that are you seeing some potential conflicts of interest or borderline conflicts of interest that you've had to analyze and determine that this rises to the level of disclosure?
You know, it's a rare occasion where we have a material conflict that can't be mitigated. I think to Ashley's point, disclosure is your friend at the earliest possible time, correct? So you may feel a certain way about a conflict and describe your mitigation efforts. But if the client feels that's not suitable, be afforded the latitude to make a decision that we appreciate your efforts, but that's just not enough for us. And so therefore, you know, we just don't feel we can engage you directly. We do have, you know, by our nature, we're almost entirely focused as a practice area on municipal entities, and we do have advisors who have related persons, whether it be familial, spousal, or partners that work in administrative aspects and decision makers with our clients. And so those are occasions where we don't feel it is of a nature where we can't mitigate, but certainly we describe to them how we're going to do so. Make sure that our advisor that has that relationship is not allowed to manage any aspect of that client relationship, but also make sure that our clients are comfortable, including, say, the governing body most specifically, because you may have a staff person and you don't necessarily want them making that decision, so you feel compelled to make the ultimate decision makers aware so that they can make their own decision with respect to our engagement. Beyond that, I thought Ashley did an excellent job of kind of the thought process and some of the things that need to be taken into consideration. But as I mentioned, it's a very rare occasion where we feel like there's an unmitigated conflict that we just cannot manage and then have to essentially walk away.
Thank you. And I want to remind people that they can send in questions for this panel to 2021 MA Outreach at sec.gov. We actually did receive a question. I will put this to Ed and then happily address as well. The question is, with respect to an investment firm affiliated with the MA, and the investment firm is going to acquire bonds in the offering and potentially pay market or higher, is this a prohibited conflict?
No, I don't think it is. I mean, I think that occurs, actually, I think that occurs often. And you'll notice disclosure in a lot of offering documents where underwriter will put in there, and I think this actually developed post 2012. I remember when I started seeing it, I was working at BAML for a little bit. So yeah, in the offering document, underwriters essentially say that they have affiliates that, you know, that conduct business in the municipal space, and at times they'll purchase securities, or at times they'll provide investment advice and things like that in other capacities. So the disclosure is provided to the issuer through the offering document as well provided to investors. So I think it's not prohibited, and I think it's something that it occurs more often than a lot of people think.
And I would agree with that, and I would say that the MA in its agreements would disclose, the potential that an affiliate may purchase at market, and that how it's mitigating that conflict is it's just a market participant buying from the underwriter.
Yeah, I think the only rub there is at what price. If they price it
well,
if
right,
it's market price, yeah, that works. If they're getting a better deal or something to that effect, or a worse deal for that matter, who knows? But that could be a issue down the road. But so long as the affiliate's buying at the same price as everyone else, I think they're in good shape.
Okay. So I think we've spoken about the process, and I think I heard it at the initial question, but I'll still throw this out here. The steps taking to not just ensure that the disclosures are made in a timely manner, prior to or upon engaging, but also the process of ensuring during the course of the engagement, and especially if, for example, there's an evergreen agreement, during the course of the engagement, updating as necessary those conflicts of interest to the extent there's something to update. So how does a firm stay on top of that, of making sure they make timely disclosures and then making sure they make timely updates when necessary? So Tracy,
hi Gail. Yes, I can start with that. All right. Well, we've already discussed this, but I make sure that G42 as well as G10 notices are given with the contract, which would be at the beginning of the municipal relationship, advisory relationship, and before any advisory activities have taken place. But also, we have a spreadsheet. We call it the deal tracker. We make sure that certain things are done prior to a new issuance for a client. And one of the items on this checklist is a G42 notice that's, going to be done specifically to that issue, and the acceptance or acknowledgement from a client. So that's one way we make sure that that is done timely. And then most or all of our client agreements are evergreen. So that does require you to continually evaluate the relationship for conflicts. This is why we are now, we're reviewing quarterly for new conflicts. Quarterly makes sense for us because we are asking associated persons about G37 contributions quarterly, and we were already asking about outside business activities at that time as well, which can be a potential conflict source. And with our G37 filing, we are revisiting our client list. So we're doing all those things already. So it just made sense to also start to do a quarterly conflict of interest review as well, since we have a lot of clients that continue to be clients, all the time.
thank you. And I suppose it's the same sort of question. What process do you have, staying on the topic of evergreen agreements? I'll shift slightly. You spoke, Tracy, about G10 compliance, and so the question: do the processes you implement for your G42 conflict disclosures and G10 that's where they intersect, and then the timely updates continue from there?
Well, I would say that they do intersect, because any issuer or client that I have an evergreen client not only needs to be monitored for conflicts on a continual basis, but that is the very same client that's going to need to get a G10 notice at the very least every year, an annual notice. So that is something that's true with evergreen. You've got to stay on top of both of those, G42 and G10, on an ongoing basis, continually.
Thank you. So, I think listening to all the answers, I think everybody sort of spoke to their process for addressing how to disclose, the conflicts, how to identify the conflicts, and how to disclose the conflicts, and how to stay on top of their obligation to amend and promptly identify new conflicts as well as, any, additional disclosures that might have happened on the Form MA or, the MAIs during the course of the engagement. But let's talk about WSPs for a while. I mean, under G44, MAs have an obligation to have reasonably designed procedures. Supervision is not one size fits all, and but it has to be tailored to their businesses. And I think Ed said earlier on, the procedures have to map to their operations. If they do it, it should be spoken of in the WSPs, and they can evidence doing it. And if it's in the WSPs that they do it, they should do it and not act inconsistent with what they've written down. Do you have any, things to share with the audience that could be helpful to them? As people that do this, to share with them considerations so they can sort of reflect on that, on how they consider their own approach to compliance and what their WSPs look like. Tracy, you're on the big screen. We'll start with you.
Okay, sorry, I don't want to monopolize. We basically, our WSPs mirror the rule that disclosure be given with every new contract and anytime a new event arises. Our WSPs also require the use of that deal tracker that I was speaking about earlier. It makes sure that we have a signed contract in place for each client, especially, that we're going through this every time we're working on a new deal. And that goes along with the contract would be the G42 disclosure. So we're keeping track of it that way. And our WSPs also talk about having this new disclosure, G42 disclosure for every issuance. And we mentioned that in our WSPs. But also our WSPs require pre-clearance for outside business activities. And I think that's a good thing to have in place also, because that can be a real source of a new conflict of interest.
Excellent. Okay. Brian, thoughts on helpful hints in the WSPs and potential documentation that you keep to evidence that the WSPs are followed, like Tracy had mentioned, the pre-clearance forms, or there's probably some documentation as to the fact that somebody's sought and received or was denied the pre-clearance of an OBA that could raise a conflict. Brian, any helpful hints on WSPs and documentation?
Yep. Similarly, we do also require pre-clearance for any OBAs. We've taken, I suppose, a belts and suspenders approach, which we hired somebody from the West Coast. They told me it was a very Midwestern term, but I thought I had heard people from the coast use that. But in any event, we use technology largely as a very strong tool in this regard. So we talked about annual disclosures, what I would call a more project specific or transactional disclosure. There are also occasions where you take on a new client, right? You are engaged or otherwise acquire a client and need to contemplate them receiving required disclosures as soon as possible. We also use exception reporting. So basically every Monday morning, as one of the firm's principals and supervising a team of advisors, I will get a physical report kicked out from our database that will, for any transactions that are kind of entered into our system that are going live or are out there a ways, I will get a physical report delivered to my inbox where I can see some of those clients where they either have or have not received the required disclosure documentation. And so therefore, I, as a supervisor, can immediately engage with that advisor to make certain that they, number one, receive what I would call our more generic annual disclosure, which would allow us to dispense advice and then contemplate what form of transactional disclosure they should receive. The suspenders aspect of that is if you want any deal documents generated, you are at a hard stop until such time as the client receives the required disclosure. So if you want your deal to move forward here and working with others in the firm, you will be prohibited essentially from generating documents. And this is built into the technology that we use from requesting those, producing those, et cetera. So you are essentially at a standstill until you get those required disclosures in front of that client.
Thank you. Thank you. Ashley, anything to add that's unique or that you could share?
I really don't. I think Brian and Tracy have given a real good description of the processes and procedures. As advisor, I don't get as involved on the WSP and then of course the deal tracking and all, but I do understand that our firm has those in place, and certainly it sounds like they're doing an excellent job, Tracy and Brian and the firms that they're handling that.
Okay, great. We received another question, so I want to ask how people are handling this. I have thoughts as well. When must a MA subcontractor to an MA prime contractor provide G42 notice to the issuer? And I guess in this situation, I will say, assume that you have been engaged as the MA, your firm, and you hire a subcontractor, municipal advisory firm, for that engagement, that transaction.
We haven't had this specific instance, but we've had something a little close. Maybe a little tangent here, but in Texas, we have a lot of co-FA situations, and that would be a lot more clear because you have two contracts, or maybe both people are listed in the contract as co-FAs, and then each person would provide their disclosure to the issuer. But we recently had a situation that I thought was more of a hybrid that looked a little more like a subcontractor. We have the evergreen contract with the issuer. The client wanted to do a co-FA situation for a specific issuance, and they approved the co-FA situation, but I think they didn't want to have two evergreen agreements. So the way it was done, even though it was approved by the issuer, we entered into an agreement with the co-FA. So really the agreement was between the two of us. It looked like we were more, say, the main co-FA. And that to me almost seemed subcontractorish because the agreement that was signed between the two of us was not signed by the issuer. In that situation, I believe clearly the intent of the law is to protect the issuer, make sure they have relevant information about the entity that's providing financial advice to them. And I think a subcontractor is providing advice. You could argue which way. It's not a direct contract, but we made sure that disclosures were made. So the disclosure was made to the issuer. We were copied on it, and we're saving it for the file, but we made sure that it was done. If it hadn't been done, I would have specifically asked for them to provide it, copying us, or to provide it to me, and I would have made sure that the issuer got it. But one way or the other, I think the issuer needs the disclosure for the sub and as well.
Excellent. I would 100% agree with you, Tracy. Yes, because under the rule, it's if you're providing municipal advisory activities, it doesn't say, isn't dependent upon the fact that you've entered into the agreement. And to your point, it is fine if you engage a subcontractor and you provide, you do the due diligence that you've made sure those conflicts of interest have been provided to the issuer client. So I will, I didn't want to precondition the market after agreeing with Tracy and then ask somebody to answer and have a different answer. But your views, Ed, what do you
I was just
think?
going to add that you guys included a FAQ on this in your compliance corner, which I saw came out yesterday. So it's aligned with what Tracy and you just said. So if anyone hasn't, you can take it for the listeners. There's FAQ on it. It's in the compliance corner.
I think it would be dangerous to ask if anybody disagrees because right now they're like, I'm going to keep quiet. So, but I see Ashley, you're chuckling. So do you have anything to add?
I just say what Gail and Tracy said.
Okay.
And Ed. Good answer.
Okay. So I have another question from the audience. And I want to thank everybody that signed up for today's MA outreach. I mean, it's been a tremendous registration. I think that it speaks volumes to how intent on compliance municipal advisors are and are wanting to engage with the regulators and hear from fellow MA. So that's just terrific. Question one relates to underwriters and municipal advisors that always work together on negotiated deals, or nearly always work. You'll see the same MA, the same underwriter, the same on a number of deals. And this could arise in two flavors. Either the underwriter recommends the issuer retain the MA, or the MA recommends the issuer retain the underwriter. In the panel's view, does this present any disclosable conflicts? And are they conflicts that can't be mitigated? And at what time in the relationship, like, the second time you work together, but, let's just, fast forward, you've worked together on, 5 deals, 10 deals. Is there a difference? So, Ashley, you happen to be on the big screen right now, so I will ask you.
Okay, thank you. Thank you, Gail. So, of course, I'm not aware of any instances this is occurring with our firm, but I think, in my opinion, it goes back to the materiality, and then can it also be mitigated? You have to ask those questions. When I was asked this question earlier in preparation for the panel, I am aware of some instances that are occurring in the markets. I think you really have to evaluate if a majority, or say a large majority of the transactions is an independent FA is handling would be for one particular underwriter, then begs the question, is the client being best served using one underwriter, or would they be better served through a competitive bid process, or a process that would be potentially using a number of underwriters? So to me, that would be the type of evaluation. Is it material? Can it be mitigated? Is the client aware of the situation? Has the client specifically requested to use one specific underwriter? If they have, is that something that you want to make sure that you document? That's my thoughts on it. Like I said, I don't have any instances directly, but I hope that's helpful.
Yes, thank you. Brian, your thoughts?
Sure. We work in a number of markets. We see both ways, frankly. So is there inherently anything wrong with what you described? No, but you should be substantiating your selection or your recommendation with respect to if you're the advisor negotiating that transaction with that particular underwriter. Maybe they do a fantastic job and they're far and away the best underwriter in your market. But you can't just say that, right? You must engage in some level of diligence, and you must show your work. As long as you're doing that, you're probably okay. You might be inviting some prying eyes in those circumstances, and in that case, you better be prepared to substantiate that argument. I would also say, from the perspective of those in a supervisory position, you're also putting yourself at risk if you're not requiring this of the advisors that you supervise. So I would say in our firm, anytime someone is looking to move forward with a recommendation on a purchaser, I shouldn't say anytime, the vast majority of times something comes in front of the principal of that particular team as supervisor. And so they're the ones that get to be the first cut at viewing that substantiation. And so it has to pass the smell test. Obviously, you don't want rogue actors within your organization doing things without the imprimatur of those supervising their activities. So certainly be very careful if this is the case. And I would argue the same thing. If you're consistently, there are some statutory requirements in certain states that advisors be attached to a negotiated transaction. Sometimes there are also more of a pricing opinion role. And maybe you're being tagged for that frequently, or almost every single time an underwriter is working on a transaction. Make sure you're putting together a package of work that objectively puts you in a position to substantiate your opinion in that regard. So if you're doing all of those things, you're probably fine, but you're also asking someone to focus a lens on your activities.
Thank you. Very good advice. And Ed or Tracy, anything?
Yes, sorry.
different to add? Yeah, that's right.
This is not happening at our firm, but I would say, in my opinion, on its face, this appears to be a conflict surely a conflict of interest. Of course, everything is fact specific, and maybe you can work your way back with facts and decide that it's not. But I would say, just on the face of it, I would start with the assumption that this is a conflict of interest, and perhaps, when teasing out the facts, it turns out to not be. But I would certainly start with the assumption that it's a problem.
And I think Brian gave some good tips on sort of to document, mitigation and your due diligence, and so that the perception that that was selected because you constantly do business together, but you routinely do your due diligence in making that recommendation, regardless of the fact that you have a prior history of working with that firm.
Right. I agree with Tracy, Brian, and Ashley here. I think all their points are really valid. Even though it may result in a conflict, doesn't mean it's not permissible, as you all know. As we've been going through, I also, the dealer has to worry about too the G17 knock-on effect here, right? Is this a fair practice? Is it deceptive? Is it honest? If it can't survive that test, which essentially the dealer applies to all persons, and that's similar to the MA, you also got to consider that. So, but I think it could occur, and it does in certain markets. It's just a matter of how you go about identifying, then disclosing, and mitigating if necessary.
So speaking of mitigating conflicts, I'll throw out a question. This may be get a lot of reaction, but in Rule G42, it does speak that disclosures must be sufficiently detailed, and that includes how it's going to be, any conflict that's disclosed is going to be addressed or mitigated. And Rule G42 already has, for, let's just say, municipal entity clients, we'll use that example, that the municipal advisor has a fiduciary duty, the duty of loyalty. The duty of loyalty includes the obligation to work in the best interest of the client. So question for the group is mitigation, is it adequate mitigation to simply say that you're mitigating it because you're going to act in their best interest because you're a fiduciary? Because you're starting from that premise, and making the disclosure and saying it's mitigated because you're a fiduciary, is that rather circular to the fact that you already you have that duty? That duty exists, and then the obligation to mitigate and disclosure mitigation is sort of separate and distinct. It would seem like the rule would eat itself if the mitigation was per se the fact that you're a fiduciary. You're on the big. Okay, go ahead.
Sorry. I would agree, because why would we even have a disclosure requirement if, hey, we have a duty and we're always gonna we are always supposed to follow this fiduciary duty? So that would make the conflicts of interest moot. We wouldn't need it because we're already following this fiduciary duty, which is going to cover everything. So I do believe that, of course, that is one mitigating factor, but it couldn't, in most conflicts, you would need a specific mitigation, I would believe, something beyond just the fiduciary duty.
Yeah, I would agree. I would agree with that.
Gail, I've seen the sorts of letters that you're generally describing, right? They'll enumerate a list of potential conflicts, and then the mitigation is, I'm a fiduciary. Okay, well, there are always, there's going to be a circumstance where your fiduciary status could or will be impaired, and that's your obligation, and then disclose that to the client and let them decide if your mitigation efforts are sufficient. That is the purpose of that disclosure. And then, similarly, and to a higher level, if it's material and you can't mitigate it, then you should be stepping away from the engagement. But in any event, you need to afford the party reading the document the ability to assess what your potential conflicts are and whether or not they feel they rise to a level that will put them in conflict with you as the advisor.
Thank you, Brian. I love that this is being taped today, because that might be the next FAQ and our next compliance corner.
There you go.
Ed, do you have things to add on that?
No, I think that was well said, and yeah, nothing to add there.
Excellent. I think we have another question that has come in. I think this one's it's a little challenging, so I'm gonna let whoever wants to take this question. But like in addition to the example I gave of the dealers and the MAs, somebody has raised the question that sometimes bond counsel themselves are recommending MA firms to issuers. And how should the MA firm that's been recommended by bond counsel, if it's, has that same fact pattern, how should they deal with that from a conflicts perspective? Like what is their obligation, in making a disclosure regarding that? So Ed, you're on the big screen. We could start with you.
Well, luckily bond counsel doesn't have any regulatory requirements here.
Right. So, but the MA that's been recommended, now it's been recommended, they've entered into agreement, an engagement, and they're making their G42 disclosures.
Yeah, I mean, look, I think it falls back on the same analysis we've been kind of walking through. And at the end of the day, if, you got to act in the best interest of the clients. And if this is a potential conflict that's disclosable, it reaches that level of materiality, then yes. But again, if it's bond counsel recommending someone that they know is, has the qualifications, generally works in that space, I mean, I find it hard to see that this would reach a level where it would be a material conflict. But then again, it's all based on facts and circumstances, and it could potentially. So I think you'd have to analyze the scenario, including all the facts, and make a determination.
I definitely agree that it's the consistency, the first recommendation, but the 12th time they, constantly that's their go-to firm. And I think somebody had said, I think Brian had said it, that, you document why that is,
I think playing defense here is probably the best thing. And that's probably consistent with the entire, the discussion we've been having is, I think we're in an environment right now where the SEC, I mean, they've come out with their first G42 enforcement action, and the fact that they're in the water and they're playing around, I think you got to play defense. You got to have you got to evidence what you're doing so you could, and hedge on the side of, on caution. At least I would recommend so you read what I'm reading coming out of the SEC.
I think that's good commentary, that if one to see what the SEC is looking at and seeing and identifying, and recognize that there's always that rebuttal. You don't have a choice. You can either document it today or be in a position to rebut the presumption that you did something wrong and trying to recreate and try to be defensive. Take the time to sort of identify and document earlier on, and a good time to sort of reevaluate your procedures to make sure or to assess whether they do that, because you don't, it's always better to be in that position.
Gail, can I expand on that point here for a moment, going back to one of our prior
absolutely
and being recommended by an underwriter as an advisor, right? So in the vein of what you just said, if you're doing the bare minimum every time you're recommended by this underwriter, I think that's consistency, but it's maybe in the wrong direction, right? So if you want to hold yourself out as meeting your obligations, I would recommend that you establish, you're being recommended by somebody that has an inherent conflict, right? So you want to do a good job, I'm sure, and you feel good about being recommended, but it's likely in your interest to establish either a meeting or a call with the issuer or the borrower at the outset to establish what your scope of work is going to be. You should not assume that you're just going to do X, Y, and Z. I've been in these situations, and oftentimes you find along the way that you have to take a bit of an adversarial position at some point, and maybe you don't know what your lane is to some degree. That's just a practical reality. So I would take the time at the earliest possible moment you make contact with the issuer or borrower to have a conversation about what is it that you want us to do exactly, so that we know how we can meet our obligations to you, and we don't just assume along the way that we're doing everything we need to. I think in those occasions, you're building a fact pattern if you're just making assumptions that isn't going to stand up to scrutiny.
And I might add just one small thing. I agree with all of that. I think you may also want to remind the issuer that they have the ability to choose who they prefer to use as bond counsel. So just remind them of that. And same with the underwriter. If they choose to use a different underwriter for any particular reason, then just be sure you document.
So, you know, we're closing in on our time for panel one. So I want to give everybody an opportunity to, you know, if 3 pieces of advice, or maybe, you know, 1 piece of good advice. And Brian, you had some terrific, everybody did that chimed in, but, you know, 1 takeaway for our audience today of something they should be thinking about, and, you know, when they were considering, you know, their conflict of interest disclosures, their, you know, updating them as well. The procedures, I think 2 people mentioned, looking at outside business activities is really important. You know, mitigation, disciplinary disclosures. So what is the 1 takeaway?
Well, I'll jump in if you'd like, Gail. Just a couple of things. I really appreciate the opportunity to serve on the panel and learn from the other panelists. It's been a really good, informative session. I think one thing that I would say, you know, since the G42 rule has been out there since, I guess, 2016, and as it's evolved and amended and changed over time, it's important to stay abreast of those changes and make sure that internally your compliance and also all the advisors that work with you and yourself are handling and making sure that you're on top of those changes. And I would just add, and just a plug for the various regulatory agencies that have online resources. Of course, you can go to msrb.org, sec.gov, finra.org. There's a number of resources for us as we see those changes occur. Chances are there have been disclosure documents or fact sheets put out about the particular situations that you may be dealing with, and I found those to be particularly helpful.
Tracy?
I would say that I think it's easy, at least maybe for me, it's easy to let it to maybe not stay on top of it. So it's good to have because you're doing a million things, right? So it's good to have a process where, you know, it doesn't have to be exactly like mine. It can be any way that you want to do it, but a process to kind of continually remind you and make sure that you're staying on top of your G42 disclosures, make sure that they're timely done and to the correct people, and that you're looking for new events that may trigger this. It's just good to have something in place that makes sure it's happening on a regular basis. And I would say, of course, like anything, it's better to overdo it than underdo it. So when in doubt, err on that side.
Excellent. Brian?
Sure. We have a bit of an advantage in the size of our firm, so we can invest in technology that we're able to leverage largely. But in any event, you need systems of control. And I'm sure you hear this from a lot of regulators, but a tone from the top, right? So the people who are in supervisory positions, if you're putting things to paper, you better be doing them because you're setting yourself up for some serious problems. And once anybody finds that one thing, you've invited them, right, to look for more and more. So you want to establish systems of control that still allow you to operate as an entity that aren't so cumbersome that you fall under the weight of it. And then you want to build supervisory procedures that put you in a position to monitor the activities of your regulated advisors to make sure that the firm is in good stead and that you can continue to operate even under the scrutiny of an examination. If I could just add one thing, going back to the discussion around affiliated entities and investing in, say, the securities of your clients, you know, that was largely a focus around maybe the BD activities, but I would also caution those MA firms that have affiliated RIA units. While there is no prohibition on, you know, that part of your company transacting in securities of your clients, understand that as an advisor, there will almost always be points in time where you possess material non-public information. And the notion of a Chinese wall, depending on the size of your organization, is probably a fallacy. So be extremely careful in what the activities of your investment advisor affiliate are and what you allow your advisors to do from their own personal transactional activity. And so if you're not able to effectively monitor that, an outright prohibition may be your best approach.
Excellent. And also a great plug for listening in on the panels regarding preparing for an exam and listening to what the examiners are identifying with their boots on the ground. But Brian, without recognizing it's not an endorsement, recognizing that it doesn't work for everybody in the size of Ellers, I mean, can you elaborate on some of the tools that you guys do use, the technology that you've been able to benefit from?
Sure. We have an interface that is kind of the backbone of our transactional structure, and we leverage that to a great degree to comport ourselves around a reliable and repeatable compliance system. But it also is built in a way that doesn't, or at least to the smallest degree possible, impede operational activity. So that allows us to do things like exception reporting, rather than have to manually track through things like spreadsheets and maybe a Word document with tables or whatever the case may be. We let technology be the tool that allows you to not forget or overlook, or at least make life easy for those in a supervisory position, as well as those around us that are advisors without supervisory status. So keep things moving along in a streamlined fashion, but also put in place roadblocks that would put us in trouble, right? So we also periodically, hold, whether people like it or not, we have little educational sessions on what they need to be thinking about. It's easy to comply when you make it easy for them, but also the things that are intermittent that a system may not be the best tool. I need you to come forth with this information and report it at the earliest possible time, just to make sure that's always in the back of their minds.
And I even a less, tech savvy, but, going into Outlook at the beginning of the year and putting in the reminders, you know what I mean? So all of a sudden it'll pop up and I'll be like, oh, I have to do my, A12 attestation. Oh, I have to, ask about G37, make my G37, like it'll pop up as a reminder. And it's not just written down in a manual that you have to remember the dates. So there's things that can be helpful there. We got in another question. And so I'm going to ask Ed to give his thoughts on this before I get other input. And it's, we talked about sub and prime relationships, but if I am the MA, I'm responding to an RFP and let's just say I'm engaged, and in my engagement agreement I talk about a third party that I'm using on that transaction, like a not another MA, but maybe economist or something, and what duties do I have with respect to my reasonable diligence of that firm, non-MA for a non-regulated firm, with respect to, for example, their political contributions or their conflicts.
Yeah, I mean, just on its face, I see, you obviously have perhaps a compensation issue, right? You got to think about payments. You got to think whether or not that relationship with a third party, whether that needs to be disclosed to the MA client. Again, it kind of falls back on what we've been discussing. You utilize that approach is, is there a conflict? Is it material? Should it be disclosed, and whether it could be mitigated? I mean, that's really what you're going to focus on. And I think it could be permissible. But again, it's one of those things. You got to take a look at the facts.
Right. I think somebody mentioned it earlier, you have to sort of, maybe I think you all did, that, what is the examiner going to ask? Like, what did you miss and didn't document? And I think political contributions could be a great example. If you're hiring somebody, even though you're the MA, but you're as a fiduciary to a municipal entity client and a regulated entity, I think if you're putting somebody on to not provide, advisory, participate in advisory activities on an unregistered basis, we're not talking about that, but you're having a firm and that, I think you should do some due diligence and know what they're, if they're making large political contributions and you're putting them, or in your RFP, for example, because that,
right,
as a favored firm. I mean, it's going to raise the presumption, it's going to raise a question and address it head on rather than have it be something that you have to explain later. and then rebut any presumption that was made about a potential conflict. So.
Yeah, I think that's right. I mean, you're going to have to play defense here. So if that type of activity is occurring, if that is your subcontractor, you better, be sure that you could survive, or not survive, but you could withstand an inquiry from the regulators. And that's just something that, when you have thorny issues, when you have
with all
things
due respect,
like this,
panel 5, right? Like, they're not scary. Stay tuned. Yes. Excellent. All right. I don't see that we've received any additional questions, and I want to thank everybody for contributing and give a few minutes back to people before panel 2 starts. So thank you guys, and thank you for letting me sub in for Celia today. And I really appreciate everybody. So thank you.
Thank you.
all right, thanks, Gail.
Thank you,
Thanks,
Gail.
everyone.
All right, as everyone's getting settled, let's kick off panel 2, Regulatory Obligations of Municipal Advisor Operations, by introducing our panelists. Emily Hanson-Santana, she's an attorney advisor at the SEC's Office of Municipal Securities. Joined by David Hodap, Director, Market Regulation at the MSRB. I'm your moderator, Bonnie Bose, Fixed Income Regulation at FINRA. And as a reminder, please send those questions into the email inbox, 2021 maoutreach@sec.gov. Emily, let's start with registration. It's the foundation of becoming a municipal advisor. But we can also talk a little bit about firms that aren't required to register.
Thank you, Bonnie. Good afternoon, good morning, everyone. Like you said, I want to start kind of with the foundations here. So a firm cannot participate in municipal advisory activities unless it's registered with the commission. What are municipal advisory activities? That's providing advice to or on behalf of a municipal entity or an obligated person with respect to municipal financial products or the issuance of municipal securities. It's also certain solicitations of municipal entity or obligated persons. And then I'm not going to go through all the exclusions and exemptions to registration, but I just want to point out a few that are some of the most common. The first one is the engineering exclusion. So engineers are excluded from the definition of municipal advisor only to the extent that they are providing engineering advice. So some considerations that come up a lot with engineering advice are rate studies and feasibility reports or studies. And I want to go into those in a little more detail. So with new projects, feasibility studies come up a lot. And in the adopting release for the municipal advisor registration rule, it talked about engineering feasibility studies. These studies might include projections that are based on considerations involving engineering of aspects of a project, and those are within the scope of the engineering exemption. A list of possible projections might be output capacity, utility rates, market demand, or projected revenues. However, when an engineer moves from those feasibility studies into advice on how to structure a related issuance of municipal securities, including maybe the timing in terms of debt service payments, then that constitutes municipal advisory activities, and that would be outside the scope of the engineering exclusion. And then on existing projects, engineers might provide advice on rates or whether a proposed rate structure is sufficient. They might recommend a rate increase to comply with an existing covenant, and that's all within the engineering exclusion. However, if an engineer begins to provide advice on how to structure a new issuance of municipal securities for a capital project, or maybe to restructure or refinance outstanding issuance of municipal securities to achieve compliance with a covenant, then that is outside the scope of the engineering exclusion, and that would constitute municipal advisory activities and would require the firm to register with the commission. And then there's the attorney exclusion. So if an attorney is offering legal advice or providing services that are of a traditional legal nature with respect to the issuance of municipal securities or municipal financial products, and the client is a municipal entity, an obligated person, or if they're another party to that transaction, that activity is excluded from the municipal advisory activities definition. Sometimes another participant in the transaction that's not a client of the attorney, they might receive that advice and they might act on that advice, but that wouldn't mean the attorney has to register as a municipal advisor. That attorney would still be considered to only be advising their clients. And lastly, I want to touch on the accountant exemption. So the term municipal advisor does not include an accountant to the extent that they're providing audit or attest services, preparing financial statements, or issuing letters for underwriting for or on behalf of municipal entity or obligated person. Sometimes there's a feasibility studies concerning the issuance of municipal securities or municipal financial products. And if the accountant is only providing audit or attest services, they wouldn't be required to register as municipal advisor. If a person's providing non-attest services, they would only be required to register as a municipal advisor to the extent that those services are within the scope of municipal advisory activities. So now that we know who needs to register and we know some of exemptions and exclusions, what do you do when you need to register? Well, you need to complete the Form MA in accordance with the instructions in the form. So the Form MA and asks for information about the municipal advisor and persons associated with the municipal advisor. Why is the commission asking for all this information? There's a few reasons. The commission uses it to manage its exam and regulatory programs. The commission also makes this information available to the MSRB to manage its regulatory programs. It helps the commission better understand the activities of its registrants. And then this information is also made available to the public. So it could be accessible by a municipal entity or obligated person that's evaluating whether or not to hire a municipal advisor. Investors could also use this information when they're determining whether or not they want to invest in municipal securities. So when is the firm actually registered with the commission? So the MA's registration is complete once the Form MA is accepted by the commission. Before it's accepted, it needs to be filed. The form is considered filed once it's been filled out completely and all additional required documents have been attached. And this includes any Form MAIs that need to be attached. And we'll talk about Form MAIs in detail a little later. So once it's been filed, the commission can either approve it or the commission can institute proceedings to determine whether it should be denied.
Well, Emily, we received a couple of questions from some of our underwriter firms as well. They're curious what they can do, or a firm that's helping a municipal entity or with investments or other operational issues. How would they determine whether or how the rule applies in their specific cases?
So I can speak to municipal advisor registration only, not any other registration regimes, and I'll talk about underwriters or broker-dealers specifically. So just like any other market participant, an underwriter will be considered a municipal advisor if they're providing advice to a municipal entity or obligated person with respect to a municipal financial product or the issuance of municipal securities, or if they're providing advice with respect to certain solicitations of a municipal entity or obligated person, unless an exclusion or exemption applies. So I'll point out a few exclusions and exemptions that might be applicable to the underwriters who ask these questions. First and foremost, there's the underwriter exclusion. So an underwriter may provide municipal advisory advice to a municipal entity or obligated person with respect to an issuance of municipal securities if it is serving as an underwriter with respect to that same issuance of municipal securities. So the important thing is that firm is serving as the underwriter, and then there is a relationship to a particular transaction. So one example to have a relationship with a particular transaction, they might have a contractual engagement with a municipal entity to serve as an underwriter on a planned issuance of municipal securities. Another exemption that might be used by underwriters is the IRMA exemption. So in this case, a broker-dealer would have to receive required disclosures and make required representations in order to perfect that exemption. So the exemption, it states that any person engaged in municipal advisory activities on behalf of a municipal entity or obligated person, and that municipal entity or obligated person is otherwise represented by an independent registered municipal advisor, or IRMA, with respect to the same aspects of a municipal financial product or an issuance of municipal securities, is exempt from municipal advisor registration if all the requirements of the exemption are met. It's kind of a long exemption, but it's important to look at all the aspects and to perfect the required disclosures and representations. So the representations, the person relying on the IRMA exemption, in this case, the broker-dealer, needs to receive a representation from the municipal entity or the obligated person that the municipal entity or obligated person is represented by and relying on the advice of a municipal advisor. So the person receiving that representation also needs a reasonable basis to rely on that representation. And then there's disclosures that need to be made. The person relying on the IRMA exemption, or the broker-dealer in this example, must disclose in writing to the municipal entity or the obligated person that it is not a municipal advisor with respect to that particular municipal financial product or that issuance of municipal securities. And then if the party that the broker-dealer is disclosing to is a municipal entity, they also need to state that they do not owe a fiduciary duty to that municipal entity. And in all cases, a copy of the disclosure needs to be provided to that IRMA. And note that these disclosures need to be made at a time and in a manner reasonably designed to allow the municipal entity or obligated person to assess the material incentives and potential conflicts of interest of that person relying on the exemption. Another exemption is RFP responses. So any person providing a response to requests for proposals or qualifications from a municipal entity or obligated person in connection with municipal financial products or the issuance of municipal securities is exempt from the definition of municipal advisor. And this is so long as that person doesn't receive a separate direct or indirect compensation for the advice as part of the response. So if a broker-dealer is responding to an RFP or request for qualifications, that advice is exempt from the definition of municipal advisor as long as that broker-dealer is not getting direct or indirect compensation for providing that response. And I know you mentioned, Bonnie, you mentioned some investments, so I just wanted to, as a reminder, there's an exemption for persons that are providing advice or investment strategies that are not plans or programs for the investment of proceeds of municipal securities or the recommendation of and brokerage of municipal escrow investments.
Well, Emily, that is a lot for, for folks to take in, but particularly with the underwriter exclusion. David, are there any MSRB requirements for firms that may want to rely on it? And David, you may need to unmute.
Thanks, Bonnie. I'll give Emily a chance to catch her breath here. So just two quick notes when we start to think about underwriter exclusion and their relation to the MSRB rules, right? So G23 comes to mind, which is the board's prohibition on role switching, going from advisor to underwriter. There's also G17, and actually there's an interesting interplay that the SEC staff's questions on the MA registration rule actually speak to G17, make a reference there. G17 is our general fair dealing rule. Don't lie, don't cheat, don't steal, as I like to say. But we have a specific interp underneath there that speaks to underwriters' obligations and the obligations they owe to issuers of municipal securities. And one of those obligations is a disclosure obligation, and effectively an obligation to disclose the fact that they want to serve as an underwriter, and then that's an arm's length commercial relationship. And that disclosure needs to be provided at or before the time of engagement. And so want to think that through as well as if you're trying to secure the underwriter exclusion, there's a reference there to the MSRB rule, and also just for compliance with the MSRB rule, you want to make sure that you're meeting your disclosure obligations under 17. But I think you might have caught the mute bug.
Ah, you're right. You're right. We're all being so cautious, perhaps. Thanks, David. Well, Emily, the firm has filed its Form MA. Is the municipal advisor all done with these forms?
No, Bonnie, they are not. There's a few amendments that can be made to Form MA, and one of them is an annual requirement. So the amendments are the annual update, and then there's a material event amendment. So like I said, the Form MA must be amended annually, and we call that form the Form MA/A, sorry, Form MA-A. So all registered municipal advisor firms must file this annual update within 90 days of the end of their fiscal year, or if the MA firm's a sole proprietor, they need to file it within 90 days after the end of the calendar year. And then there is the material event amendment. So that is the Form MA/A. An MA firm must amend its Form MA promptly whenever a material event has occurred that changes the information provided in the form. And the general instructions to the MA forms provide some detail on when a material event is deemed to have occurred. I'll list them off now. They are in the general instructions 8 to the MA forms. So that's when information provided in response to items 1, 2, or 9 become inaccurate in any way, or if the information provided in response to items 3, 7, or 8 become materially inaccurate. And I just do want to make a note that if a municipal advisor needs to change its main business address in EDGAR, that cannot be done via the MA forms. They need to file a company update in EDGAR.
Okay. Well, speaking of forms, tell us about Form MAI that you mentioned before. It pertains to individuals?
That's right, Bonnie. So this is information about individuals that are engaging in municipal advisory activities on behalf of the firm. And the form elicits additional information about natural persons associated with the firm, information that wouldn't otherwise be provided by the firm in the Form MA. So the Form MAI is filed by the firm when it's applying for registration, or after it's already registered as a municipal advisor. And like I said, this is filed for each natural person who is 1, associated with the municipal advisor, and 2, engaged in municipal advisory activities on behalf of that municipal advisor. And the term associated with the municipal advisor or associated person of a municipal advisor is actually defined in the Exchange Act. And that is a partner, director, or branch manager of a municipal advisor, or an employee engaged in management, direction, and supervision of the municipal advisor, or an employee performing any activities related to the provision of advice on behalf of municipal entity or obligated person with respect to municipal financial products or the issuance of municipal securities. And just to note that if you're a sole proprietor municipal advisor, you must file both the Form MA and MAI. And then you need to amend the MAI promptly when any information contained in the form becomes inaccurate for any reason.
David, I think there's a possibility that Form A12 would need to be updated as well.
Yeah, thanks for making that connection. So the MSRB rule on registration, Rule A12, also speaks to registration and updates. And one of the obligations that's listed there in A12 is that anytime your A12 becomes out of date, you've got 30 days to update it and update it with us. And so if there's organizational changes or perhaps personnel changes where somebody drops off as a regulatory contact, those are items that not only do you want to think through about the MAI and the MA, but you also want to think through what you might owe to the MSRB as well.
Emily, we've got a question that came out of FINRA's exam program. What are the Form MAI requirements if you've got an individual who's not on the municipal advisor side of the business, but they may be an analyst in the organization or work on the underwriting or trading desk? They're providing critical information or advice to the individuals who are actually speaking directly to the municipal entity. What would be the requirements there?
So Bonnie, in this situation, what I would do personally, my suggestion would be to look at that second prong, who is engaged in municipal advisory activities. So consider who's engaging in MA activities at the firm, but also consider firm personnel that may be providing municipal advisory advice directly or indirectly to a municipal entity or obligated person. So one example might be, there might be an individual who's working on matters related to the structure, timing, or terms of the issuance of municipal securities. They don't necessarily need to interact directly with the issuer to be an associated person engaged in municipal advisory activities.
And David, any thoughts on
Yeah.
what would be required? I had asked about Form MAI. I didn't even think about the Series 50.
Right. So I think this is sort of interesting and an example of how sort of the advice standard that's promulgated and interpreted by the SEC sets the sort of boundaries for our rules. And so if that domino starts to fall with the SEC advice, it's going to hit our rules as well. So specific to anyone that's doing municipal advisory activities, that would make them a municipal advisor rep. And there are sort of interesting ramifications there, but you brought up one that hits right off the bat, Bonnie, which is the Series 50. So if someone was doing municipal advisory activities prior to doing that, our qualification requirements say that they need to pass the Series 50.
We received a question from our audience. We talked a lot about those that might be a municipal advisor or might not. And so the audience member asks us if they're involved in a transaction and they think that another party to the transaction is acting as an unregistered MA, do they have to do something about it? File a reg tip, or what's required?
I'm happy to jump in here. We obviously care a lot about registration. We care a lot about the folks that are representing themselves as MAs and are out there providing advice to issuers, that they're meeting their regulatory obligations. The folks that are participating today care a lot about this, spend a lot of time and effort and money meeting those obligations. And so if folks are coming across a firm or an individual that looks like it might be doing something that isn't looks like advice and is not meeting all the requirements that they need to meet, we are happy to take those referrals. The MSRB isn't the enforcement agency for those. SEC and FINRA, we would refer those to, but we are happy to take those referrals and are happy to superintend, right, the registration field and make sure that everyone that should be registered is doing what they need to be registered.
Emily, would you think it would be required though, or David? I'm not hearing that.
So I think there can be a lot of facts and circumstances on whether it would, you know, as to why someone, you know, it may be as simple as a late update to an A12 that doesn't flow through to our website, right? So if you're looking at someone who looks like they should be registered, and then you're doing a little bit of diligence to say, hey, they're not showing up on the MSRB website, there could be more benign explanations than just simply that you know that they're out there totally in the Wild West and not doing any of their regulatory due diligence. But I wouldn't put like an honor code obligation on someone to report for all those reasons, right? I mean, there could be good explanations as to why someone is providing advice and maybe not showing up on our website or et cetera. So I wouldn't go so far as to say there's, you know, if it's the honor code, and if you see someone cheating, you got to report them. But I could definitely, if I'm an MA out there and I'm doing all the right things and taking the time and effort to do all the right things, I could see why I would have an interest in letting the MSRB know that, hey, looks like somebody's out there and is providing advice, and they're not doing all the things that I have to do. So again, happy to take those referrals, but no, I don't think there's sort of like an honor code obligation to do that.
And I would add, you can also file a tip complaint or referral with the SEC known as a TCR.
Right. Well, we also received a question that both of you can answer, actually. Comes from a broker-dealer municipal advisor. There's an employee at the BDMA who holds the Series 50 and the Series 54, but is not on the MA side of the business. Is the firm required to file a Form MAI in EDGAR, or can that professional qualification just be held on their Form U4 at FINRA?
So as far as the MAI, you know, I would ask, is this person actually engaging in MA activities from time to time? If they are, then you do need to file the Form MAI. But if they're not really ever intending or thinking that they're going to engage in MA activities, then you don't need to have a Form MAI on file. And it's kind of like relatedly, I would say sometimes the question of the MAI comes up when you talk about supervisors. So just a reminder that associated persons of a firm include supervisors. And then is the supervisor engaging in MA activities is the second prong of that test. Sometimes there's somebody that's purely in compliance and they're not engaged or supervising or overseeing MA activities. So most likely that person doesn't need to file a Form MAI. That's just a thought.
Yeah, and I would just jump in and say, echo everything that Emily said with a little bit of nuance here for the MSRB rules. I would be very intentional and have a very documented reason if somebody was sitting with a Series 50 or a 54, but they weren't engaging in those activities. Now, naturally, anyone could walk in off the street and take a 50 or 54, and it could be totally unrelated to their job responsibilities. Not how I would want to spend my weekend hobby time. But if they have a 50 and a 54, you know, I think there's sort of an idea that they might be providing this sort of advice. They might be engaging in municipal advisory activities. And relatedly, you know, Emily is really talking about this sort of engage concept, which I think is the right way to think about a lot of this. But the other thing I would point out, just in terms of MSRB rules, is related to G3, and happy to go into this later, Bonnie, but the requirements around continuing education are really about holding the qualification And if you hold the qualification at the firm in some sort of official capacity, right, then the firm needs to incorporate that person into its training plans for continuing education. So like I said, I'd just be very intentional, and I'd be very documented as to whether that person is engaging in the advice, whether they're officially holding that qualification, or whether this is just sort of a, you know, a side endeavor that they're having fun, and, you know, do the diligence there and make sure that you know the answers to those questions.
Well, and as we, you know, as the question came in from one of our broker-dealer municipal advisors, it sounds like what you were describing would apply whether or not you're a broker-dealer, would apply to all municipal advisors, essentially. I was looking for a nod or a yes.
Oh.
From whom?
Yes, I would say on my, yeah, from my perspective, yes.
Great. Well, sorry, Emily, go ahead.
Oh, I was just gonna, you know, remind people listening out there that when you decide that someone is going to engage, an associated person is going to engage in MA activities on behalf of your firm, you might want to consider the time it takes to actually complete, fill out, and submit that form with the commission, because you have to complete the form, you have to file a completed form MAI with the commission. So you might want to consider the time it takes to do that as well.
We've gotten a few questions. I'm going to start with a question about the IRMA exemption. And the questioner asks, if the underwriter has gone through the steps to obtain the IRMA exemption appropriately, but then as time goes on is not sharing all of the advisory material with the municipal advisor, is there, what thoughts do you have on what may be required? Is the underwriter required to continue sharing the material with the municipal advisor, the IRMA? And you know, what thoughts for our questioner?
Yeah, so I would look at this, if somebody's an underwriter to a transaction, then they're really filing under the underwriter exclusion. If we're talking about a party that's not the underwriter to issuance of municipal securities or with respect to municipal financial product, they could be a broker-dealer, they could be another type of firm. So this person is communicating with the municipal entity or obligated person, and basically not CCing the IRMA on the email. Well, I would just say that the exemption, you know, is really requiring you to let the municipal entity or obligated person know that you are not a municipal advisor. If it's a municipal entity, you don't have a fiduciary duty. You're also needing to provide that disclosure to the independent registered municipal advisor. And then you need to receive a representation from the municipal entity or obligated person that you're relying on the advice and you're represented by a municipal advisor. So if you've perfected all those steps, then the municipal advisor does know that you are involved and you are around. So I would think, you know, you're not necessarily, you've already perfected the exemption, and you're on notice that there's a municipal advisor, and the municipal advisor is on notice that you're involved. So I think once you've perfected it, you've done what you need to do. There's nothing specific in the rule that says you need to CC the MA on all the emails.
Thanks, Emily. It was a nuanced question. I think we'll take one more question before we go on to some of the MSRB registration requirements. And a good one, a good follow-up to the question we asked about unregistered staff. Can unregistered staff, members of a municipal advisor firm assist with, various aspects of the municipal advisory engagement? The questioner asks about the development of a I'll just say POS, but it could be a broad question about what unregistered staff can do, and it might be a good chance to pitch some good websites you all have.
Yeah, so I'll give Emily a break again and jump in first on the MSRB side. So this previews a little bit of what we were going to talk about later, but the definition of municipal advisor rep, right? And under our rules, there's a specific exclusion for clerical, administrative, support or similar functions. So the rule acknowledges that there are all kinds of, there's all kinds of work going on at that MA firm, and some of that's going to be unrelated to advice, and it's going to be more of a clerical support nature. But fundamentally, I would initially think about this in terms of whether that advice is happening, and then think about whether it meets one of those, those other clerical administrative if it doesn't constitute advice.
Right.
Yeah,
Good.
and I would echo that if this individual's, just performing clerical or ministerial services that aren't municipal advisory advice, then we wouldn't require them to have the Form MAI on file, and they'd be allowed to do that. But I do, like Bonnie said, I wanted to give a pitch to the OMS website. It's sec.gov/municipal, and then we have a complete section on municipal advisors where we have links to the final municipal advisor registration rule and the adopting release that has a lot of good material in there. And then we have some staff FAQs on that website. And then there's also instructions to the Form MA series. I think I mentioned those instructions in early response as well.
And some FAQs that are really on point to, the advice standard. David,
exactly.
We've taken a close look at the SEC's filing requirements and the Municipal Advisor Registration Rule. Why don't you share some information about the MSRB's registration process?
Yeah, so I think just to start back to basics, this may not be the most scintillating part of the panels today, but I think this is where we actually do hear a lot of footfalls. And so just want to go through the basic structure, which actually I think we've already previewed with some of the questions that we've gotten. G2 and G3 set out the framework under MSRB rules for professional qualifications. G2 sets out that
it looks like we may have lost David's internet. Emily, are you seeing the same thing?
Yeah, I think we lost David.
Okay.
I think I might be back. Can you hear me now?
Okay.
I went to the office for this very reason, but work through this with me here. So right, so there's G2, which is the basic standard, which says that no municipal advisor shall engage in municipal advisory activities unless such municipal advisor is qualified in accordance with the rules of the board. So that's a pretty summary statement. You need to be qualified. And then G3 sets out some of the specifics about what it means to be qualified. And again, there's sort of two classes of individuals under this MA framework, the municipal advisor rep and the municipal advisor principal. We laid out a little bit of this and with the question that was posed to us, right? Municipal advisor rep, natural person performing municipal advisory activities, excluding clerical, administrative, or similar support functions. And again, just to reemphasize there, the most important part I see in that definition is that the Series 50 needs to be taken, and the Series 50 needs to be taken prior to the engaging in those municipal advisory activities. So if you're going to hire somebody to go out and provide advice for the firm, then you need to make sure that that person has taken the Series 50 before they start providing that advice. And then the municipal advisor principal, just to give the definition there, municipal advisor principal means a natural person associated with a firm who directly engages in the management, direction, or supervision of the municipal advisor activities of the municipal advisor and associated person. So supervisory concept there. And in relation to those municipal advisor reps, they have to pass the Series 50. And as of this new compliance date, this new test, the Series 54, which is the municipal advisor rep test. And Bonnie, I just give a pitch on that if I could, because that is a new requirement.
Absolutely.
So the Series 54 is a new test, relatively new test. I hope it's not new to the folks that are listening to this panel. The compliance date actually has been extended a couple times because of COVID. The compliance date is November 30th, 2021. So every firm needs to have a municipal advisor principal in accordance with G3 by November 30th, 2021. I'm going to try and say that one more time because I think it's 3 times that everybody hears it. And so the other point I was going to make is that the Series 54, in light of COVID and the challenges of COVID, has been made available for online test taking. And that online test will be available until November 30th, 2021, until that compliance date kicks in. So again, that Series 54 and the Series 54 principle is new concept. Bonnie, I think I hit it 3, right?
Absolutely, and I'm going to echo it. November 30th is going to be here pretty soon. What happens if a firm doesn't have a qualified municipal advisor principal on December 1st?
Well, everybody heard November 30th a bunch. We hope that everyone's going to meet their compliance date. And I would say, right, there's some pretty summary statements that I've referenced before in G2 and G3 about being qualified and being able to engage in municipal advisory activities, and the firm having a principal, at least one principal there and appropriately designated at the firm. So I think I'd rather just say, let's not find out. Everybody make sure that someone at the organization has taken the test and has been appropriately designated by that date on December 1. Everybody's got one.
Well, and as FINRA is the test administrator, under our rules, if someone doesn't pass the test, they have to wait 30 days to take it again. So keep that in mind as you all are getting ready for December 1st. And I'm sure many of you already are. All right, we covered professional qualifications. Let's swing back over to continuing education, David.
Yeah, so as I mentioned before, there are continuing education requirements. Those continuing education requirements are enumerated in G3. And we've gotten some questions about, is there a specific number of hours? Is there specific courses that folks need to take? G3 calls out specifically fiduciary duty, fiduciary obligations as one thing that must be covered in a training program, and the other is regulatory obligations. And so there's flexibility there in terms of, we know different firms do different things, and so as a baseline, you've got to cover the fiduciary duty, you've got to cover the other regulatory obligations, but we don't go into more specifics as to what the training program must be, and that specifically we let the firm look at their activities, look at their reps, and figure out where they want to do the training and how they want to do the training, and so it gives you the flexibility to do that.
All right, thank you. You know, we're receiving a lot of questions about some of the topics that we covered on who needs to register, who's giving advice, who doesn't. Let's see if we can summarize a couple of those. First, we're receiving some good specific questions about exactly what staff are doing, some that we really can't get into in depth here on the panel. So Emily, what kind of advice, sorry, little, what might we say to some of our questioners who have specific concerns and have heard us talk about, hey, pay attention, that person who's not speaking directly to the municipal entity or obligor may be acting as a municipal advisor rep. What sort of resources might we point them to or things to think about?
Yeah, I mean, first I would just go back to what we started with, the foundations, that we're talking about advice to municipal entity or obligated person. It needs to be with respect to the municipal financial product or the issuance of municipal securities. And that includes the structure, timing, terms, or other similar matters concerning those financial products or those issuances. Or if they're providing advice with respect to certain solicitations of a municipal entity or obligated person. Also, I would point them, like I said, to our FAQs, the staff FAQs on our OMS website. It talks about the advice standard, and MA advice does exclude provision of general information, and that is really fleshed out in the FAQs. I know that the adopting release to the final rules is hundreds and hundreds of pages, but you know, there is a lot of good content there. And I would familiarize myself with the different exclusions and exemptions to the municipal advisor definition. I know I couldn't talk about them all today because it would probably be just me reciting rules for the whole panel. But I would look to those as well.
And I can certainly make a pitch toward how often we in fixed income regulation at FINRA or our exam staff go back to the adopting release and the FAQs. They really are very helpful. David, we received a question that may apply to a few folks out there. Someone who's in a supervisory role, but may not be supervising, you know, municipal advisor reps or municipal advisor activity. And you had mentioned perhaps compliance or supervising operations. Can you talk a little bit more about who needs to be a municipal advisor principal?
Yeah, so I would go back and think through this in a couple layers. I'd start with the strict definition that we've included in G3 of municipal advisor principal. And so just to restate that, natural person associated with a municipal advisor who is directly engaged in the management, direction, or supervision of the municipal advisory activities of the municipal advisor and its associated persons. So again, as I read that, I look and see this turning on municipal advisory activities and the supervision of those municipal advisory activities. And so to the degree that you're not supervising someone who's not providing municipal advisory activities, then I would see that falling outside of the municipal advisory principal definition. Mm-hmm. Not sure if that was too many layers there, Bonnie.
No, I think it really gives people a lot to think about and really focuses on the municipal advisory activity. We've gotten a couple of other questions that I think our panelists are sort of looking through right now to see what these are just terrific questions. Actually, I'm going to swing over, Emily, to you to talk a little bit about subcontractors. Now, panel one, you know, Gail and the panelists talked about the G42 obligations and the disclosure of conflicts, but it might be a good idea to cover the statutory fiduciary requirements. So let's set up that same example. We've got a prime municipal advisor, sort of the main municipal advisor, who has brought in a subcontractor to assist with the engagement, or perhaps even the issuer has assigned a subcontractor. Who has that statutory fiduciary obligation to the municipal entity?
So if you have a prime that's a registered municipal advisor and you have a subcontractor that's a municipal advisor, and they are advising a municipal entity client. They both have that statutory fiduciary duty to that municipal entity.
Okay, great, thanks.
And Bonnie, I could fill in. I know there was a reference to our compliance corner. So that is available up on our website. And just to give you the readout there, we have if a municipal advisor has been engaged by a municipal entity client and hires another municipal advisor to perform some of the municipal advisor activities outlined in the scope of services, would obligations under MSRB Rule G42 apply to the subcontracted MA? And it's a pretty flat yes with an explanation there. And the way I read what we provided is that G42 obligation, those duties flow regardless of the relationship. And so great for both parties to be thinking through, prime or sub, what their G42 obligations are and what sort of disclosures need to be provided. And I actually thought Tracy did an excellent job, could not say it better than she did on the prior panel about putting myself in the shoes of the issuer and thinking through my duty of care and my duty of loyalty under 42, and thinking through what if I'm the issuer, what would I want to know in relation to some of these prime and sub relationships.
David, we received a question from the audience about G37, switching gears a little bit from what is advice and what isn't advice. The questioner is asking, in filing the forms, the municipal advisor may be engaged, but there isn't a transaction that quarter. Can you give a little bit of help on what they need to put when they're filing the Form G37 listing out the clients?
Yeah, so this is an excellent question. It's actually a question that we've gotten enough that it's actually in our manual for Form G37. Can't quote you the page, but I can give you what it effectively says, which is to say, for municipal advisory services, you need to indicate on the form the calendar quarter in which an agreement is reached to provide those services. And then on an ongoing basis, list any municipal advisory business engagement for a calendar quarter in which you as the MA actually engaged in municipal advisory activities. So as I read that, think through when the agreement is reached, and then if you've provided any advice in the calendar quarter that is the subject of the filing on Form G37.
We've talked a lot about municipal entities and duties and obligations to municipal entities. We received a question, and some of our colleagues participating today may be working with obligated persons or conduit issuers. Where might they go to see how the rules apply to them and understand their specific business? I want to start with Emily.
Thanks, Bonnie. So I would, again, I'd point people to the staff frequently asked questions. We do have specific FAQ on obligated persons, and the adopting release to the final rules also a really good resource on questions about obligated persons in general.
Yeah, and Bonnie, I would pitch both going to our electronic rulebook, which has separate tabs. It's got the text of the actual rule, but then it also has links to recent amendments and also has compliance resources. So that's always a great place to start. That's where I start when we start getting questions. The other place that I would go as well is our compliance resource tab. That's under a separate tab than our rules, but it's organized by MAs and dealers, and then has compliance resources under each of those. And one of those compliance resources related to G42, and that's where I would go to start thinking through the question that the person asked.
Okay, great, thanks. Let's put one more question out to our panelists, and it actually comes from one of our underwriters who's concerned that when engaged to underwrite an issue and there's a municipal advisor, there seems to be some difference of opinion or dispute about whether the underwriter can contact the issuer directly or what's the MA's involvement. Is there any rule governing whether an MA can prevent this? Any thoughts there?
So I'll jump in because I think the answer where I would start thinking this through would be related to G17 and the general fair dealing obligation. Right. So again, my quick restatement there: don't lie, don't cheat, don't steal. Right. If there's a nefarious purpose as to why you're excluding the MA from,
or excluding the underwriter, actually,
or vice versa.
Either
right.
one, I guess.
Right. I think that would naturally raise some questions.
Right.
And particularly if MA, I could see situations if the issuer is comfortable where the MA is trying to direct the traffic and so is requested certain communications go to them, and I would go back to that basic concept of fair dealing and not trying to evade anyone against their wishes.
And perhaps a kind of a bottom line is, or the questioner also asks, how would the underwriter be able to conduct due diligence without contacting the issuer? And I think that's an obligation on the underwriter under 15C212 and otherwise. So something else to think about as well. Emily.
Yeah, I was just going to say, I can see a municipal advisor that wants to manage the relationship. They want to know everything that's going on with the deal, with the municipal entity client, so they can fulfill their statutory fiduciary duty. So on its face, I don't see a problem with a municipal advisor that wants to be involved in maybe emails and calls that are had with different participants in the transaction.
All right, and then lastly, I think we can make a pitch for our regulatory tip and other lines. We do have someone who wrote in, and we hear this, and I know the MSRB and the SEC hear this, that they see entities acting perhaps in an unregistered fashion and appear to be giving advice, and appreciate the person who wrote in and is giving some specifics about the types of information. Emily covered a lot of the exclusions for accountants and engineers and et cetera. But in the end, if you're aware of something and want to provide that information to us, David, you had mentioned going to the MSRB, and how might they make a referral there?
Yeah, so we have a help desk line. I hesitate to give the number. I think you can call a general number, which I think is 202-838-1500. You call there and they'll connect you to someone at our help desk, and essentially they'll route that from there. So oftentimes there's a question, they can handle it themselves. If the question needs to be escalated to somebody over in market regulation, one of the attorneys or someone else, they'll handle it that way. So wouldn't say we get these tips all the time, but it's not unheard of for us to hear that someone might be providing advice and they aren't registered. So again, happy to take those referrals.
And Emily, how would you file a TCR? Go ahead, Leah.
Yeah, so one way you could go to the OMS webpage, sec.gov/municipal, and on there we have a link. It says submit a tip or complaint. So you can do it that way online. You can contact our office. It's 202-551-5680.
Okay, great. Well, with that, I'm going to thank everyone for joining panel 2. And stick around for panel 3. Gail Marshall will be back moderating municipal advisor activities related to new issue pricing. Thanks, everyone.
Thanks, bye.
Thank you.
program. Welcome back to the program. This is panel 3, municipal advisor activities related to new issue pricing. As the title indicates, we're going to now narrow our focus to a particular area that lots of people have paid attention to, which is, what activities does an MA need to undertake or can undertake in the process of pricing a new issue. I want to welcome our panelists for this particular program. We have 2 long tenure industry participants joining us. We have Jeff Smith, president of OmniCap Group, LLC, who is a registered municipal advisor and investment advisor. And we have Brian Leffler, managing director at Robert Baird, who also serves in roles as municipal advisor, underwriter, or placement agents. And if my math is correct, each of them have tenures that run to 30+ years doing this business. So there's certainly folks who know and have been very active in this area for quite a long time. And then we have pulling double duty, and hopefully she's not talked out from her earlier role today, Gail Marshall, Chief Regulatory Officer at the MSRB. So, we wanted to kind of go through a couple of quick preliminaries. We do have listed on the website where the agenda is also a set of resources that are available to you that touch on some of the things that we talked about. In particular, we do have a link to the just published earlier this week request for comment by the MSRB on draft compliance resources for dealers and MAs for new issue pricing. And we will have Gail talk about that a little bit later in the program. You also have kind of the full biographies of each of the panelists there as well. We will be able to receive questions from the audience, but you can send them to 2021 MA Outreach, 2021 MA Outreach at sec.gov. And as we have time, we will try to cover the various questions that come in either during the conversation or at the end if time permits. So just wanted to kind of, we're first going to spend a little bit of time talking about what is the pricing process, to give kind of a good groundwork for what we're talking about when we say does MA have any duties, or are there things that they can do during the pricing process. And we'll have a conversation with Jeff and Brian to kind of walk through what they see in the marketplace today, what are the various types of activities, behaviors that occur. Then we will turn to Gail primarily to talk about the recent requests for comment on compliance tools, and to go through kind of the existing rules and requirements that could apply to when an MA gets involved in the pricing process. After that, we will bring Jeff and Brian back to kind of take a very focused view on kind of 2 critical pieces. One is, when am I, as an MA, actually potentially obligated to provide advice on pricing? And then number 2, if I do in fact have a duty to take part in providing advice on pricing, how do I go about fulfilling that duty? Then we'll also touch somewhat briefly on questions of supervision and record keeping in connection with those particular aspects of MA activities. So let's go ahead and dive into kind of talking about the pricing process in general. Pricing is really a process. It's not just a matter of kind of getting the scales and seeing if the price is right or not. But there is lots that goes into it. There's lots of activities that occurs on the day of the pricing, but there's also lots of kind of work that happens before you get to that pricing date that really makes a difference in terms of how you go about getting to the price for a particular transaction. So let's start going through that process. So let me ask kind of the basic question. When an issuer, when a deal is being priced, what is an issuer actually looking for? What's the thing that they really want out of the pricing process? I don't know if Brian or Jeff want to talk about that.
Sure. Thank you. What an issuer is looking for from an underwriter is essentially them to purchase the bonds and then essentially selling those bonds to investors. However, on the other side, the municipal advisor is essentially advising the issuer on that process and on those prices based on some conditions that we'll talk about a little bit later, but we're not executing the transaction. And so from the perspective of an issuer, again, they're looking based on the criteria of what their goals may be. They would like to say have the highest price, lowest interest rate based on the structure, and then based on the price that an investor is willing to pay for that is what essentially the municipal advisor is going to react to and give the advice to the issuer.
Yeah, Brian, that's an excellent overview. And, you know, we just wanted to add, we agree that you know, we're talking mainly negotiated transactions here. You know, we view the underwriter should offer the best debt structure to meet the client goals at the lowest cost. And then they should be there to support the transaction, including underwriting at reasonable levels if that's necessary. And then as an advisor, you know, we're there to make sure that the structure being suggested or offered by the underwriter does in fact meet the client goals, the issuer's goals. It's in the best interest of the client, it's viable, and once we agree upon the structure, that it's executed efficiently and at the lowest cost for the client. So.
Certainly, clearly, we're looking to, the issuer's looking to get kind of the best pricing as one of their core objectives. How does the interest of the investor feed into this? Particularly, I think it's of relevance from the underwriter side.
It depends upon the structure. So from the investor's perspective, it's going to be primarily based upon the tenure of what is being offered. The couponing that may be offered or acceptable to an issuer for their overall structure or their overall debt portfolio, whether it's siloed or with a portfolio of debt. So it does matter with what an investor is, their goals may be, but more importantly on the municipal advisor side, we're going to have to take that into consideration and keep essentially the issuer's goals first and primary in selling the obligation.
Now, what other goals can an issuer have besides that best price? Are there other factors that they're thinking about when they are thinking of going to market above and beyond, or in addition to the pricing they get on the new deal? And that those other factors can have impact on what that pricing ultimately is.
Sure, a couple things I can think of. One is the optional redemption feature. What is the how does that single issue fit inside their portfolio of other outstanding debt in terms of their long-term goals of having optionality in the future? And then also couponing can have an impact in terms of what is the annual debt service, and that may, how much interest is being paid, plus if there's a requirement of how much principal has to be paid by, say, a statutory requirement at the state level. So those are two examples of where an issuer is looking to, having to look at other features in terms of the pre-pricing process.
Yeah, and I agree with that, Brian. And you know, from an issuer perspective, you know, do they care what an investor thinks about the rate they get? Well, you know, one of the goals of most issuers is making sure they have a diverse investor base. So, yeah, they do care to a certain degree, and I agree with Brian. You know, our kind of main goal is to make sure our client gets the lowest cost of financing, and we're not overpaying for the debt being issued. You know, but there are also other parameters that come up beyond, you know, the couponing, the call features certainly are big ones, and those are pretty complex things to figure out sometimes. But there are other things like debt service coverage ratios. You know, coupons might impact that. You know, are there any rating parameters that we want to make sure we're keeping in mind? And then there's certain types of structures or debt programs, like, say, for example, you know, is this a bond bank? And they have to make sure they have debt service coverage with what they're doing with the proceeds. They may loan them out to small municipalities need to make sure that they can repay the debt with the loan repayments coming in, let's say student loan bonds or something like that. So there's a lot of factors that can go into what an issuer is thinking of and what their goals are that are beyond just, the absolute yield that can impact yield.
Yeah, absolutely. And I think we noted already that primarily our discussion here will be focused around negotiated transactions. I do want to touch a little bit on competitive transactions, both in terms of to what extent is kind of decision between negotiated versus competitive right on questions of pricing, and if decisions made to go competitive, what in particular can MA do to kind of make that the best, most competitive process to get the best pricing possible? Any thoughts on that?
Yes, on a competitive transaction, there may be pro forma analyses on what is the coupon to be needed so that you can actually set the parameters for the sale of a bond to competitive via a notice of sale. It says that the dollar price cannot exceed, say, 120. Is that going to actually allow investors the flexibility that they need to reoffer the bonds? In other words, having a large number of investors bid on that. So we would be looking at that type of structure. The other thing too is in the notice of sale, an issuer may give notice to potential purchasers that they would want to be able to move principal around to meet their overall goal. And there are parameters of how much principal can they move in any year, which would essentially impact the price or the yield or the coupon that may be offered by a prospective bidder. Then also the issue of even the settlement date. I mean, how quickly is a transaction going to settle versus, say, a 30-day settlement? All of those things are going to go into play. And the last thing is under a notice of sale is whether or not an issuer can immediately make the decision to accept a bid, or there have to be action by a governing board within the next 2 or 3 hours or in that afternoon. So that may also impact how we set up a transaction.
Yeah, and kind of focusing on one of the earlier points Brian made is that, things that go into that notice of sale become very important for the advisor to advise the issuer, like, is there a range of coupons that they're comfortable with, but the call features and stuff like that can greatly impact the pricing in a competitive transaction.
I would say one last thing is also with, if you have a serial bond structure that you would allow a purchaser to term up some maturities as long as the serial redemptions were equal to a mandatory redemption. So that may execute at a better price.
Great, thanks. Yes, so I think got a sense now that there is some kind of core early structural decision making that occurs that may not be formally part of the pricing process, but certainly will have an impact on pricing. So let's roll into kind of what we call kind of the core pricing activities. So, typically the formal process begins with a POS and going out to the marketplace. Before you can get to that POS, not the marketplace, how does the underwriter and an MA being involved in providing advice on it, come to developing that preliminary pricing scale? And what kind of things do you look at before you even kind of go out with a formal scale out to potential investors?
With that, there's a couple of things, either information received from an underwriter, or in this case, the municipal advisor may obtain information looking at, say, recent trades of that issuer, what were historical spreads to some index that was used for an issuer. The other thing is, also their rating and the impact on that pricing. But more importantly is, especially whether or not it's a tax exempt or a taxable or a geo type issuer, we're going to go to the appropriate indices and see who is there, even if there's a peer transaction. But more importantly, is really what's in the marketplace very recently. When I say that, it's if there's something in the last 30 days of a comparable transaction or structure would be very helpful in giving that advice.
Yeah, and I think the advisor really needs to independently prepare and do their due diligence in this case. And you know, starting with a macro level, looking at general market dynamics, you know, what are inflationary scenarios, economic indicators, Fed interest rate policy that can greatly impact, you know, the current market you're in. So in certain cases, and we've seen, you know, going through a pandemic in the last year and a half, you know, there's been a lot of changes from Fed stimulus monies coming in to, you know, high investor demand that has really changed market dynamics from, you know, 1 week or from a couple of weeks to the next couple of weeks. You know, what is getting down to the more micro level, what are the supply and demand, looking at those in the, you know, again, in the environment you're in when you're going to market. And then what's the interest rate environment? What are taxes in versus taxable ratios? What are the AAA benchmarks versus treasury rates? What's the shape of the yield curve? You know, is it steep? Is it flat? Those are all factors that I think every advisor needs to prepare the due diligence on their own leading into every pricing. And I wish there was just a simple template that we could say, hey, let's update this on every deal. The fact is a lot has changed, a lot changes from deal to deal, even when they're, you know, a week or two away.
Mm-hmm. I also think supply is really a factor too, even on a competitive market, having notice of understanding that forward calendar, seeing what is going to be coming, and then also how does on a competitive sale establishing that time, and then also understanding the public economic markets or news informations that could actually influence the pricing.
Great, thanks. Yeah. And so it sounds to me that although certainly you are, as an MA, consuming some of the information and data that's available from the underwriter, but it sounds like both of you felt it was important to really have an independent process to be able to assess data, information, other transactions, and so on, that is not necessarily sourced, you know, exclusively from the underwriter when possible.
Yeah, I agree with that. I think also too is that process may begin even before the POS. I mean, having things ready so that's kind of at a measured pace, making sure that the MA is prepared with what is going to be necessary to, you know, provide that as eventually advice when it gets to pricing.
Sure, absolutely. Now, once they actually you go into the market, and so you're actually, the underwriter is talking to investors. If you can talk, either one of you can talk a little bit about kind of the different dynamics depending on the investor base that you're looking at, you know, institutional versus, you know, retail, broad distribution versus narrow distribution, or different types of markets and different types of issuers or types of issues, what the dynamic is there. And then I guess the second step is to what extent are MAs brought into, not necessarily, certainly not having direct conversations with the investors, but how does that information flow back to the issuer and the issuer advisor as those conversations are being had with potential investors?
You know, we and so obviously this is an area where, you know, most likely the underwriter has a lot more information available to them than we have, but there's still ways to prepare due diligence. There's a lot of platforms out there you can look at to the extent it's disclosed publicly who are current investors. You know, who are the typical investors looking back over the last few deals, if this is a regular issuer, who typically puts in orders. The systems out there that are made available to us during pricing, they're not automatic. I think they're pay for the systems, but they allow us to get a lot of information. And so we encourage using those systems so we can look at the different types of orders. Are we getting some retail? Are we getting institutional? Are we getting professional retail? All different types of orders. So you know, retail orders may be more sticky, or you're doing a different retail order period. You know, these are all things that can help learn more about the investor base And then we can use that information and work with the underwriter and really communicate with the underwriter in their desk as far as the feedback they're getting once, say, an investor presentation is put out there, and looking at which calls are they getting, who's looking at the investor presentation, and who's, what kind of feedback do they have, and making sure we're asking that leading into the pricing, not just waiting to, put it all on the underwriter and not asking them for their feedback.
I agree with Jeff. I think it's getting that information on a timely basis from an underwriter, but also having systems in place to obtain that information if it's not readily available.
And what's the nature of the opportunity that you have as an MA to, once you've seen where the orders are coming in, seeing where kind of the scale that the underwriter is proposing to be kind of the final scale, what's your opportunity to kind of sit and spend a little bit of time with your client to kind of parse through that, think about whether that's acceptable or not, or maybe push back. We'll talk a little bit about pushback momentarily. But is this thing happening kind of split second? Is there time for contemplation and doing a little bit more research? How does that? And I know it's a different deal, but what do you typically see happening?
Usually prior to on a negotiated, you can definitely see the trend, and you can see if there's going to either be possibly a repricing. In other words, demand is greater than supply, or the reciprocal is that the way that the quote order book looks is that there may actually be a increase in yields or a changing of the structure or the coupon, and let alone even to the point we're asking for a bifurcation of sometimes of some of these maturities. The feedback that we may receive as or an MA may receive is really the underwriter already looking for ways to sell the obligation or the bonds, given the fact that there is it's an all or none type of underwriting approach. So I think they're looking they're going to be communicating different options for consideration. The timing is going to be fair and reasonable. I think usually is about an hour or so, maybe even two, based on, and that may be before the order period is over. So we'll start seeing trends and kind of and reach out.
Yeah, and to answer kind of the timing, like how much time do you have when a final scale is proposed before accepting it or asking for adjustments? We make it a standard practice of having a game plan with our client going into the pricing. So before you step in that room or you get on a call in this last year and a half, let's make sure we all agree we're going to set aside. Let's set aside some time, have a sidebar call, with just us and the client, without the underwriter in the room or on the call. Even if it's something that we're probably all going to agree upon, that things are looking pretty good and there probably won't be any adjustments made, but it's just good practice because there may be other things that you need to discuss. But that gives you an opportunity, and they're typically fairly short calls because you are prepared leading into the pricing, and having done the due diligence, everybody knows somewhat what to expect. And I think it's also important leading into that pricing that you're really getting feedback from the underwriter in their desk and how confident they are in the proposed scale that they're going out with. So then when you're in that discussion of trying to finalize the pricing, where you can push, or where if you're oversubscribed, you may be asking for some adjustments. And if you're undersubscribed, you may be asking them to underwrite, and you kind of know whether you need to ask for some adjustments or not, based on how confident they were going into that pricing.
Yeah. So and in a situation where you kind of have, for example, a significant oversubscription, how much back and forth can there be? Is there a cost, not necessarily dollar price, but cost to going back and seeking new pricing? That's something that's relatively routine. Is it relatively easy to be able to move the final pricing when you see something like that, coming back from the pricing process?
I think there's always room to continue to keep going back and forth if it warrants and it can be justified, with the concern of not losing orders and essentially having unsold balances. But at the same time, though, too, one of the things we also look at is really not only you have your lead underwriter, your book running manager, we're also looking at where did the orders come in from, if there's a co-managing underwriter, and how deep is that book of business in terms of who essentially which underwriters were selling it. It does allow, and how, as Jeff said, is how diverse is the order book, rather than having 2 orders for the same maturity versus 12 orders for the same maturity. There's going to be some ability to negotiate that.
Yeah, I completely agree. And there's situations, you need to look at, is it 1 or 2 maturities that are oversubscribed? Is it the entire issue that's oversubscribed? Do you have, sort of an anchor order on some of the maturities where if that anchor order pulls, you're not going to be oversubscribed? So there's a lot of factors that go into whether you can ask and push to make some adjustments that are favorable for your clients. But also a lot of things like what's happening during that day in the market. Is the market solid? Is it volatile? What's the supply and demand that day as well? And so there are a lot of factors, and we've been fortunate that we've had a lot of lower supply and high demand in the last year and a half, and so a lot of times we are asking for favorable adjustments for the client, and it's not, you don't always get agreement. But I think the important thing is, you need a basis for what you're asking for. You're not just pounding your fist on the table saying, I just want a better price because that's my job. You're really forming a basis for asking for an adjustment, and being reasonable. Sometimes you can get that, and sometimes there's reasons why it doesn't make sense, but you need to be reasonable on those points.
That does tie back to our original comment about understanding where other transactions have sold similar comps. I mean, so kind of giving, as I think Jeff said, there's got to be a basis of asking for something and being fair and reasonable on that request.
Sure, no, that's great. I've got a couple of questions that bear on some of the things that you've been talking about, and we'll hit those real quickly, and then we'll turn it over to the lawyer perspective of things. That's been very helpful to get that core understanding of how things are done. And I think you've addressed one. So one question was, what is the benefit of a diverse investor base opposed to single investor? And I think you just touched on it. It gives you more ability to potentially push back if you know that there's a variety of investors available potentially to talk to. I don't know if there's anything else that sticks out on the question of a diverse versus a single investor. And number 2, is there anything kind of worth highlighting in terms of you're seeing pricing kind of a large frequent issuer like New York City versus kind of a one-off project finance for a lesser known issuer? Are there a couple of things you can kind of touch on that can have an impact on your ability to kind of do pricing or provide advice on pricing?
I think if it's an infrequent issuer, even if it's a large issuer with a unique transaction, I think sometimes it's that marketing, the investor roadshow that is going to help with that type of feedback. But I think that's going to be very key in terms of trying to, for that pricing process of being, I view it as being measured and smooth, hopefully. But I think relying on, as I think Jeff has really said it a couple of times, and so have I, is really getting that flow of information from, i.e. from the investors to the underwriters, to us and the issuer at the same time, so that we can both have a reaction to it.
Yeah, and there are cases where, infrequent issuers or more challenging, a type of issue that has fewer, smaller investor base, where you really need to work with the underwriter leading into that transaction, again, forming the basis of expectations on orders, who's going to be interested, because there are deals, if you're New York City, you're going to get a ton of interest, big issuer like that. But we have certain deals where, you might have 4, 5, 6 investors that typically invest in that type of deal. So you have to really make sure that you are prepared in advance for what to expect. That's working really closely with the underwriter on those expectations.
I would say the last thing on an infrequent issuer is if they're new hardly to the market and they have a rating report, giving the investor base opportunities to review the documents and also the rating, just the report that is going to be provided.
That's great. So we're going to give you guys a little bit of rest here. Gail, I think you're probably eager to talk about the request for comments, so I will give you the floor to just kind of walk through that with the audience.
Okay, so the underwriter obligations, really, as we outlined in the RFC that you mentioned, there's G17 fair dealing. It speaks to, general, fair pricing. It speaks to the basic fair dealing. It speaks to, this is all under G17, disproportionate nature of underwriting related, services and excessive compensation. And also, we talk about G27, obviously, WSPs and, the obligation to have reasonable supervision over municipal securities activities that the firm conducts to comply with, MSRB rules and other securities regulations. And as we do know, that hand in hand with supervision goes documentation. And so, in looking at firms' procedures, they should look to what they are, documenting to evidence their policies, procedures, and WSPs are being complied with. And one thing, and then I'll move on to, because I don't want to spend too much time on the underwriter obligations and a little bit more time on the MA obligations for today's panel. But I think before I go forward, I really want to talk about what the request for comment doesn't do and what it does do. And what it doesn't do is it's not establishing new rules or regulations. It is not proposing a, one practice for all firms. It is really designed to be a tool that firms can use, and if it makes sense for them. And we ask a number of, we have some frequently asked questions. We outline the regulatory requirements, and then we ask questions that firms can sort of ask themselves, in considering the WSPs that they do have, and whether, in their view, they need to be enhanced, or that's a good question. I never thought about that. And so, that's, what they're intended to be at the end of the day, is a tool and resource that MAs and underwriters can use in their practice. And so we recognize that one size does not fit all. And we also recognize that, as we've just heard, there is a lot that goes into this process, and it's not an exact science, and it's a lot of things happening, day of. So that was the reason we went out for comment, to sort of ask regulated entities and other market participants, are we asking the right questions? Are we thinking about the right considerations? And, we put a 90-day comment period on here. So comments are not due until January 4th to give firms and others, and stakeholders an opportunity to really digest the two draft compliance resources, and, provide, some great feedback that, will help us enhance these to be actually, so that we reach the goal of having these be useful tools for regulated entities. So with that, soapbox speech of what this is and isn't, I want to talk about the MA obligations. And as noted, in the compliance resource, we start with those obligations and we outline them. So it's, G42, you have the duty of care, and with the municipal entity client, the duty of loyalty. You have obligations to have relationship documentation, and that is to be specific as to the scope of services and what is not being offered. So if, and then there is that concern that what you put in the scope of services, if you, for example, don't speak to pricing, but then your conduct and the conduct of your services, and this is covered in supplementary material, I believe 0.04 of G42, you know, your conduct, you know, is also at play here. So if you are actually providing pricing advice and you didn't, you know, put that in your scope of services, you're still providing pricing advice. So the scope of services can be expanded by the conduct, and the relationship documentation is not one, doesn't have to be one document. So if you, for example, respond to a request for proposal saying that you would provide pricing advice and then it's not in your scope of services, then there's going to be that gap. Are you providing it? Is it an expectation from the issuer that you are providing it? And so, I think firms really should take a look at their scope of services. And I think this was covered in the first panel on G42. If you take the time at the beginning to have the documentation, then you can save time on the other end and trying to rebut the presumption or the confusion of what you did or did not provide. So in addition to, the G42 obligations, obviously, MAs also have fair dealing obligations under Rule G17. And similarly to dealers, that does relate to excessive compensation, which in and of itself is also identified in Rule G42. And there's some, I believe, supplementary material 0.11 talks about some of the factors to consider. And for municipal advisors, there's G44, and that's their obligation to have supervisory procedures and controls that are reasonably designed to achieve compliance. And as I said, and I think this, deserves repeating, I'll do something that David did. I'll repeat something 3 times. Documentation, and I'm not suggesting that it's even possible or required to document the processes, all of the processes that were previously discussed, the synapses in the brain being connected in making these real-time decisions. But with respect to, and that's questions that we've asked in the request for comment, and what kind of documentation exists that's routine that could evidence the process that the firm is taking. So that's the regulatory framework regarding that.
Okay, great. So are there any other main points you wanted to kind of touch on before we jump into kind of the bigger discussion around what's in scope, and then if it's in scope, how does one kind of go ahead and meet your obligations?
On scope of services, certainly.
Well, no, just in general. Before, because we're going to have a kind of a bit of discussion now about kind of going into that. Anything outside of the scope of services that are it's worth highlighting from the request for comment. Otherwise, we'll jump into that.
Well, I think we outlined not only the G42 obligations, but I think the supervision and is a key component, and the WSPs, again, not one size fits all, but WSPs are to be tailored to the municipal advisory activities that the firm provides. So if the firm is routinely providing pricing advice, it should speak to that.
Great.
And what is it that they, what factors do they look at, or what will evidence that it was reviewed to make sure that the factors that they say they're going to look at were looked at, and if there's a differential in services between negotiated and competitive, do the WSPs speak to that? And these are things for them to to consider, and we're asking questions about this. Is that what people are seeing? Is that what people are doing?
Very good. Yeah, that's really helpful. Let's go ahead and then jump into kind of the two things. Am I on the hook to do something? And then if I am on the hook to do something, how do I do it? And so I start off with talking about, again, the scope of services. And I think you touched on, and I think the previous guidance, as well as I think the request for comment, touched on the fact that there is no one way to write your scope of services, and so you can have a relatively broad description of what you're going to be doing. So, for example, you can say, I'm the MA on this deal. I'm going to be the person providing advice for whatever you need on this deal, and it can be a pretty short, pithy description of your scope of services versus other scope of services that can be very detailed oriented, providing a number of here's different pieces of the transaction that I'll provide advice on, and in some cases even here are individualized tasks that we'll do in connection with that. And there's everything in between. And I guess the question becomes, within that range, and that will be some discussion for everyone. Within that range, one, what did Jeff and Brian see out in the marketplace in terms of how pricing fits into these different models? What they see people saying explicitly or not explicitly about pricing as part of their duties. What do you see out there? And then let's talk a little bit about what that means in terms of what the obligation is. So maybe Jeff and Brian, I don't know if you have any comments about how you see the documentation of scope playing out in the marketplace from different MAs that you work with or work across across the table from, and specifically as far as pricing is concerned. Do you see all different models of scopes out there?
Yeah, we do, Ernie, and the first thing is a lot of the contracts, engagements can be on different forms. It could be on our form, it could be on the issuer's form, or the client's form. So you see a lot of different formats used for the scope of services. And then it really depends, is this a broad engagement where you're just their financial advisor and you take care of everything? Or is it specific? And we do have engagements specific to just pricing, so there may be another advisor on the deal, say a special structuring like student loan structuring. There may be an advisor that has all the special software for that stuff, and then they ask us to be the pricing advisor when they go to issue the bonds. And so we've, so the description of the scope of services can vary. And then we kind of start off from our internal compliance checking with a checklist that NAMA put together. Susan Gaffney, very helpful in helping us get started on how do we document this stuff? What should we be looking for? And so that has a provision in there to say, is there a limited scope here or a specific scope? And so we document it that way. And then in our G42 disclosure at the beginning of the transaction, that'll reference the scope of services as well.
I don't know, Brian, if you have anything to add to that or not, that's fine.
I was just going to say there is a broad range of different type of engagement. I call it engagement letters and things like that, even to the point where the scope actually may even incorporate the scope of work defined in an RFP that one may respond to. So just by reference, you're already, if the issuer is expecting that, it's already incorporated in that's there. But at the same time, though, too, is you're correct in saying the word, if you're going to advise on pricing or the sale of the bonds, that's a very large term and what does that really mean? So it should really be defined.
Yeah, absolutely. Now, given the reality in the marketplace, I guess you mentioned the range of things. So I guess starting from what I'll call the easiest to the hardest case, if you have a scope of services that says we're going to be involved in the pricing process, and it may even say we're going to look at comparables, we're going to look at benchmarks, or whatever we're going to do, we're going to negotiate with the underwriter. I think that makes it fairly easy to understand what it is that an MA has put themselves on the hook to do, what the issuer's expectations are, and that those are things that now are clearly in scope, and you're going to do those things. Are there any nuances when it comes to kind of that kind of a contract in having an understanding between the issuer, client, and the MA as to what they're going to be doing? And I'll mention one thing. For example, I've seen a number of them, and you see that specific listing, but you also sometimes will have the lead-in which says they may do these things, or as appropriate, or at the direction of the issuer? And how does that kind of tie into the understanding of what it is you're on the hook to do or not to do? And just thoughts, and obviously you're not the legal decision on that, but just thoughts on that.
Yeah, I think I'll even give you one more to add to that. This is that the engagement letter may or shall list all these items, and then the last thing is that the issuer may request in the engagement letter that we would like you to do something else that may not be listed, whereas the MA needs to acknowledge that in the future. And I think that was in previous panels, is that, or even here, is that it's not a static document, your engagement letter in that case. So that's where, managing that process, not only in terms of the pricing, but managing your engagement to make sure that you're definitely doing that, doing what is necessary for pricing. And I think what we're seeing over time is that pricing a transaction is not formulaic. It may change. And so to be dynamic and responsive to an issuer, we kind of have to build in that flexibility, but let alone if there is that change, we'll talk about this later if we want to, is how you document what you do. So it's just so that we're always on the right path.
Yeah, and I would add to that the may be included in an engagement letter just means, well, you're going to do it if we end up doing that transaction. You're going to advise on the pricing. So and I would say the majority of the engagement letters, like Brian said, either refer back to scope of services and an RFP if you're engaged that way. But a lot of times they can be very just vague and broad and have that kind of language. So, we're just prepared that, we're documenting what we're doing if that's the case for G42.
Great.
I would add that G42 does have a requirement to amend or supplement, and very, point taken. This is a living, breathing, document to if there are material changes or addition to the agreed upon scope of services, that they would be, the documentation would be amended or supplemented. And, and I think, Jeff, you mentioned, what are you getting paid to do? And what's the meeting of the minds if it's the scope of services is very vague as to what are you getting paid to do and what have they agreed, what are their expectations? So.
Well, that's a good point. I'll just one more quick point. There are master agreements as well with your clients, and then for specific projects or tasks, you'll have an actual agreement on the scope of services for that'll define exactly what you're doing on specific transaction or task or something like that. So that's also how some of our clients operate.
Mm-hmm. I would say similarly, also like for an evergreen agreement, it might be an ongoing relationship, but for different issuances, to your point, you would have supplemental material that speaks to that transaction.
Agreed.
Yeah, and Gail, and one of the last things you said, I think it goes into the kind of the other scenario, which is when you do come in with this very general statement of what your duties are. I'm going to be your MA on the deal, and I think you one of the things you said was very much to the point, which is the meeting of the minds. And I think when you have that kind of generalized engagement letter, I will posit that an MA needs to put themselves in the shoe of their client and say, what does my client now expect of me, given that I said I'm going to be your MA for this transaction, and a core part of the transaction may very well be pricing. Even if you haven't said that you're going explicitly said you're going to engage in pricing, do you now have an agreement where your counterparty expects that you're going to be there at the table in pricing, again, without the word pricing appearing anywhere in the document? I don't know if it's a conclusive answer on this, but I think one would have to keep that in mind when you're kind of providing that generalized statement that unless, I think Gail mentioned that part of G42 talks about establishing limitations on your scope. When you're coming in with kind of a general statement of your scope, I think it's particularly important, I would think, and Gail, correct me, that you want to use the limitation aspects when you're going to say, hey, I need to carve out things that one would naturally view as I'm going to be covering based on how I've described the relationship. So I think you can't just look at it from the scope of I'm the MA and these are the things I want to do, but what is my counterparty think I'm agreeing to do? And I want to be clear between the two of us as far as that.
Right. And as noted, I mean, if the engagement is silent on pricing, it doesn't mean that you're not providing pricing. I mean, your conduct and throughout the engagement is indicative as well. But if you mentioned, if you specifically were not planning to provide pricing and you didn't document that as outside the scope of services, that could be troubling, because then if the client was expecting that to be within scope of services, to find out later that it's outside but wasn't specified in the relationship documentation.
Yeah, and I think your reference to the conduct is also extremely important, because regardless of what it says in the contract, you are an MA engaging in MA advisory activities if you engage in the activity. So if you're silent about pricing, or even if I think, now I'll posit this, even if you kind of limit it and say, I'm not going to do pricing, but then you go ahead and engage in pricing advice, you are now engaging in pricing advice. And you can't wiggle away the fiduciary duty and other duties by saying, well, I don't mean it, but I'm going to give you the advice anyways. So I think that's something else to keep in mind. And I think that's good that you raised that particular point. Unless anything else, I do want to kind of spend the last few minutes talking about kind of how one goes about, okay, let's say you are providing advice on pricing. I think during our first discussion, there was a lot of discussion around some of the tools you use to go about doing it. And I know in particular, there is one concern that we've heard expressed from time to time is that some of these tools are not cheap. They're not generally available to everyone in the marketplace. Is there one way to slice this bread when you're looking at comparables, looking at curves, looking at having a way to kind of test whether the pricing that's coming back from an underwriter is appropriate given the marketplace? What are the different ways that people can kind of try to get at this type of just get to either get access to tools or to provide good advice that may not be reliant on the most high-priced set of vendor tools?
I'll start out by saying that, yeah, there's even the benchmarks, typically you have to, there's subscription to pay for benchmarks. So that's very expensive. And there's not just one, AAA benchmarks, but you need the data, and there is information, let's say, on Emma that's available, but they are a day old. And even though, benchmarks, AAA benchmarks aren't exactly, you don't see intraday movements per se. Even with those that say they have intraday movements, there's still reads and things like that, and there's still the underlying market that are going to impact them. So you need to have subscriptions, that right now they are subscription based, to have real-time information to be able to advise your clients. You can get comps, and that could be data based on historical information. But I think to really advise on a pricing, you need some tools, unfortunately, that are paid for to be able to have the information at hand to really advise your client.
Yeah, and I think both of you touched on this in passing in previous comments, but for example, if you're looking at comparables, and we talked about it early in the process when you're structuring and trying to develop the scales, is it fair to say that you got to make sure you're not looking at comparables from 30 days ago when you're actually at the day of the pricing to do it and have some kind of currency versus kind of, well, I looked at the prices one time 2 weeks ago, and so I'm setting. So there's a certain degree of diligence, I guess, in the process, regardless of what tools you use. Is anything? Can you speak to that? What you see, or where you see people who may not be quite up to snuff?
I think if there's anything, they're looking for a trend primarily. I mean, rather than a point in time. If it's a frequent issuer, you can actually look at trade data. That's going to be very helpful. Or if there's posting of, in this case, competitive sales, if they become public information right away before a final official statement is available. So if there's the posting of who the winning bidder may be, and that hopefully information can get between what was the coupon and what was the yield. But you're correct. I mean, in terms of, you really have to be in the market at that time, because as you know, there could be other it could be economic information or other political things that happen that could actually cause a change in price.
And I'll just add real quickly, I know we're getting close on time. I just want to add, tie this in with something, Gail hopefully will be impressed with, and hopefully Ernie's team won't come knocking on my door soon. But, it really comes down to duty of care. And that really means comps from a year ago could be extremely helpful. Comps from a week ago may not be useful at all. So you just have to kind of have that knowledge to know when they're good and helpful, and when they just really don't matter because the market's just totally changed. So.
Fair enough. I think we're going to end up on the discussion of supervision and record keeping. I think, Gail, you touched on a lot of that. I will kind of maybe amplify the idea that record keeping does have the two aspects. One is, what are the minimum requirements? And number two, what are the things that help you do your job well? And that will help you be able to document what you do, whether you met your obligations in a way that is, helpful to you and helpful when the examiner's knock on the door. And so just urge you not to look at record keeping as a narrow scope of what are the minimum I need in order to meet the checklist requirements. Did have a question that came in, I think, at the tail end of our initial discussion, but I'll go ahead and ask the question in terms of process. And it does tie a little bit to how one fulfills that scope of duties. For example, how can an MA do a good job in challenging an underwriter's observations and market tone during a negotiated sale? Any thoughts on that?
At times, actually having comments or conversation with other underwriters and other underwriting desks, other than the underwriter that's maybe leading the transaction, can actually help with that.
Yeah, and I'll add, it can be very challenging, but I think it comes down to preparation leading into the pricing.
Okay, great. Any final thoughts from any of the panelists? Okay, sorry. Please go ahead, Gail.
Yeah, I would like to, a final thought on documentation, and I like that you identified, the minimum requirements, and sometimes it's important to focus on those as well. But reasonably designed WSPs, it should, the rules are specific on what you have to keep, because what you have to keep is tailored to your WSPs, which is tailored to your firm. But if you say you're doing X, Y, and Z, the WSP should speak to who's doing it, when do they do it, as necessary with it, and then how do they document it? It could be, a closing memorandum or some other post-closing record that they've reviewed and initialed and dated. But, there is, an expectation that show me your work, like show me that you did supervise this, show me that you followed this procedure, that you wrote, that you tailored to your business. So I think they should always be thinking of record keeping hand in hand with WSPs.
Great. Well, I wanted to thank the panelists. I think it was a very, very good conversation, lots of good thoughts. I hope the audience found it very useful. Gail, you can go rest now from your double duty, I think, unless you have a later panel. And so we will call this panel. We'll call this panel a wrap, and I'll hand it back over to the people in charge. Take care.
Thank you all.
Thank you.
Okay, great. Well, hello, and thank you for attending this panel, panel number 4, where we will discuss preparing for a municipal advisor exam. My name is Cheryl Maddox, and I'm the General Counsel and the Managing Director with PFM Financial Advisors, LLC, lead the firm's legal function and support the firm's municipal advisory compliance efforts. And I will be the moderator for this panel today. I'm joined by 4 panelists, and we'll give you a brief introduction. You can find more information about all speakers and additional resources for this session, as well as others, on the SEC's website under the resource list for this 2021 Compliance Outreach Program. Also, as a programming note, if you have any questions for the panelists during this session, you can submit them through 2021 MA Outreach at sec.gov. So with us today, we have William Downey, who's a specialist manager on FINRA's fixed income specialist team within member supervision. Bill leads a dedicated specialist team focused on examining the fixed income business lines at member firms to ensure compliance with relevant MSRB, FINRA, and SEC rules. We also have Robert Lewis III, who joined PMA Securities in February 2006 and is responsible for managing PMA's Public Finance Department, which is active in Illinois, Wisconsin, and Minnesota. And Bob also works as a senior municipal advisor to cities and villages, parks districts, school districts, libraries, and other municipal entities in Illinois. And then we also have David Martin, who is the Securities Compliance Examiner in the New York Regional Office Division of Examinations for the SEC. Dave has been a member of the New York Regional Office's broker-dealer exchange program since 2012, where he has conducted complex examinations of broker-dealers and municipal advisors. And rounding out our panel, we have Julianne Gemenden Graham. Julianne serves as president of Oakdale Municipal Advisors and has more than 20 years of experience advising Tennessee governmental entities on the structure and sale of municipal bonds, most recently as a vice president in the Municipal Bond Department of Wiley Brothers, Aintree Capital. Thank you, panel, for being here. Looking forward to a great discussion. So let's start from the beginning with an overview of the exam process. Bill and Dave, perhaps you can walk us through the life cycle of an examination.
Sure, thanks, Cheryl. I'll start from the FINRA side. For us, it all begins with the exam planning process. So firms that we're going to review in the following year are identified at the end of the previous year through a process where we review internal data and internal knowledge to decide which firms we're going to examine in a given year. Then after selections are made, when the time comes for the exam to begin, generally risk monitoring will conduct an announcement call to let the firm know that the exam is going to start. At that point, the exam side will take over, start making some initial document requests, generally through our electronic gateway, and scheduling a business activity call during which we discuss the firm's business lines. Kind of throughout that process, we're doing a risk scoping process. We're putting kind of our knowledge of the firm together and deciding what areas specifically we want to focus on during that exam. We do this as part of a risk-based process. So we don't look at everything. We kind of look at what we feel like are the riskiest areas and business lines of the firm and decide what we'll look at based upon that. In service of the risk reviews, we'll make further document requests, potentially over a couple of rounds. We'll have meetings with firms, discussions with the firm to kind of flesh out the business and as we pursue our reviews. Once we've finished the reviews, we issue a preliminary findings report, at which point the firm can also opt to have a meeting with us to kind of discuss it. This is issued prior to management review, so things might change a little bit somewhat after that point. Then we have the formal communication of any findings to the examination report. Then we have the firm's response and issuance of the disposition letter, followed finally by an internal process when we close out the exam, which is mostly administrative. I don't think the firms really need to know too much about that.
Okay, and Dave, do you have, is there anything that distinguishes sort of the SEC examination process from FINRA's examination process?
Well, I know this was mentioned at the beginning of the program, but I also want to note here the views expressed are my own and not necessarily reflect the views of the SEC, its commissioners, or other members of SEC staff. But yes, there are a few differences. I guess it's a very similar process in terms of pre-exam and going through records requests. And I know we'll talk about a lot of these pieces later. But in our situation, we will have the exam team will actually make the announcement call, as opposed to someone other than that. I think as FINRA does it. But we do a lot of the very same steps through announcement, through records requests, and a review and analysis. We will communicate our findings throughout the exam, as well as through a preliminary exit, as well as a formalized exit. leading through to a deficiency letter and a firm response. I know we'll cover a lot of those areas. There's a very similar process to FINRA.
And then, so
Sorry, I
how?
think the big difference is between FINRA and the SEC. FINRA, of course, is only reviewing FINRA membership, so BDMAs only, whereas the SEC might review, some of the municipal advisor only firms. I think also we use a gateway, whereas the SEC tends to use emails for its requests, and we have kind of our exam planning process that works a little bit differently from how the SEC selects its examinations.
Yeah, our exam selection process does have a number of factors that we consider. Generally, we do not make that public with the firm. We don't explain why they were selected for exam, but it could be any number of reasons through risk scoping or otherwise. We will, again, not public information or to be really discussing with the firm as to why they were selected.
And Bill, you mentioned use of gateway versus email. So how would a municipal advisor, how do they get notified that they're going to, that they're being scheduled for an examination?
We don't tend to alert firms that they're being scheduled for an exam in a given year. Like, for instance, by the end of this year, we'll probably have a pretty good idea of what firms we're going to review next year. But we don't let the firms know until the exam is beginning in general. We don't conduct unannounced exams in general. We can and do that, but that's rare, only in cases of suspected fraud. I'm not aware of any MA exams that we've ever done in that way. But really, the way that the MA or the firm will know we're coming in for an exam is when the risk monitoring analyst makes the announcement call to let them know that we're about to come in and begin making some document requests.
And so you mentioned, is that through a phone call first, or is there an email that goes out first, or what can a municipal advisor expect to receive or expect to get as far as a communication, that first communication that they're going to be examined?
Sure, the first communication is a phone call from the risk monitoring department. Generally, it's just the risk monitoring analyst who's on that. It's a quick phone call just to say, hi, the exam is going to begin. And then more detail kind of comes out later on. The exam area generally sends shortly after the exam announcement call an exam contact list that lists the different teams who are going to be involved in the exam and the key contact points here at FINRA.
On our side, I'll say that we also have we make the phone call is usually the first contact from the exam team. The first phone call we usually just confirm address, email address, and contact personnel, which we're going to forward an information request to. We include in the information request a couple of required SEC forms, 1661 and 2389, to explain to the registrant who was going to be examined some more detailed information about the exam process. We don't use the gateway. It's all done through secure mail initially, and ultimately, I know we'll discuss this later, we'll receive documents through a secure mail or secure website called Kiteworks.
Great. And just to stay with this just for a minute again, just as to give folks an idea of sort of what the process is to get to the point of being ready for an examination. In determining the scope of a risk-based exam, what types of factors are considered? Dave and Bill, if you can maybe add some information around that.
Sure, yeah. We take a risk-based approach to firm examinations. I can't really give up all the secret sauce here, and it'll kind of vary from firm to firm depending on the size of the business and what parts of the business the advisor is doing. But in general, size of business, the nature of the engagements, the quality of procedures, and any regulatory knowledge we have of the firm related to like prior findings or culture of compliance, those things all kind of go into helping us determine what the scope of the exam will be.
That is the same on our side as well. There is a risk profile, and we may have other regulatory intelligence through tips or complaints that we would use to scope the exam, as well as the decision-making process that's a to do an exam.
Okay, let's bring the practitioners into the discussion here. Bob, Julianne, any additional experiences or information that you can provide from your perspectives?
Well, For the examination, our point of contact for that is our general counsel and chief of compliance. And those communications usually begin with a phone call, as the regulators mentioned. And then the formal communication coming through email from the SEC or the gateway for FINRA. Just a word of caution, make sure your advisors in your departments are aware of those processes, because as everything else in life, the spammers, the phishers are getting more sophisticated, and we've had fake FINRA emails coming to us, making document requests, wanting us to click on links to upload things. And we knew that shouldn't be coming through email, it should be coming through the portal. So just a word of caution for those of you that are getting the requests.
Great, thank you. And as an aside, I'm going to gather that we should, if someone gets something like that, they should alert FINRA as well, just to let them know that those types of things are coming through.
Yes.
How often should firms expect to be examined? Is there, sort of a time frame that folks should have in their mind as to how often they can expect to receive a notification that they're going to be examined?
Yeah, at FINRA, we deal only with the BDMAs, and there's not as many of them. In terms of the total universe, it's a much smaller subset of the total universe of MA firms than the SEC is necessarily dealing with. So we have an internal policy where all BDMAs are reviewed on a 4-year cycle. So FINRA will review every BDMA's municipal advisor business at minimum once every 4 years, though it may be more frequent depending on the risk we see at the firm through the exam planning process.
On our side, I don't believe we have any standard requirement to review every 4 years, as they do at FINRA. We, again, previously stated, we have an exam scoping and analysis process we go through to determine who to examine and when.
And for municipal advisors that are subject to FINRA examination, is there any type of regulatory coordination that occurs between SEC and FINRA?
Yes. Oh, go ahead. Take it.
Generally, yes. There are we do make efforts to, during the exam planning process, we make efforts to coordinate to ensure regulatory efforts are not being duplicated to avoid overlap. There are situations where that may be unavoidable, but yeah, there is a process through which we try to coordinate to avoid such duplication. Any concerns in this area from the firm should be discussed with the exam staff.
Just exactly what Dave said. There have been cases where we've had a firm teed up and it's turned out that the SEC is going to be going in or is in there already. And so we've kind of either had a call to discuss what the scope of the SEC exam is and maybe edit ours accordingly, or even to wait until a later date to do our exam.
And for Julianne and Bob, maybe you can speak to who typically serves as your point of contact, maybe from the practitioner side.
Yeah, our point of contact initially is the general counsel or chief of compliance. And when they're contacted, they immediately get in contact with me to let me know that an examination is about to occur and that we should be expecting to get a request letter shortly. And then we'll talk about vacation schedules and things like that to see if there's any concerns we have about being able to produce the document request once it comes.
And I might just note I'm on maybe the other end of the spectrum as far as firm size goes. Our firm has a single registered employee, and so I would be the point of contact with the examiners. And I might just take an opportunity here, though, to encourage smaller firms not to be too intimidated by the process, because if you're a smaller firm and you don't have a large or need for a large compliance department, these folks really are trying to ask specific questions about specific deals and procedures. So folks who are really the practitioners on a day-to-day basis might actually be, the very best people to be able to truthfully respond to these requests.
Just on that point, Julianne, for Dave and Bill, is there a difference in the exam process when examining a small firm versus a larger firm or even a medium-sized firm? And I'm not sure how you set those tiers, but can you speak to that maybe?
Yes.
Go ahead, Bill.
Yes and no. So yes, for a bigger firm with many engagements and a lot of municipal advisor professionals, our approach will be somewhat different. You know, we may have to sample a subset of the engagement they're involved with, or look at a subset of the individual registered persons rather than looking at everything, right? As a smaller firm that's only got a few engagements or a couple of MAPs, we can probably look at everything versus at a larger firm with a lot, we have to sample down. That said, firms of all sizes still have to be compliant with the rules. There's like a baseline level. So there's not that much different in our approach.
Same for us. It's a very size and scope of the firm, personnel and business is taken into account at actually several stages of the exam in terms of how the exam proceeds forward. Back to the point of contact question, from our point of view, we see different approaches taken by firms. We will have a conversation in the beginning of the exam to set up a protocol, so to speak, who we are sending requests to, and how we're going to work through the request and response phase, and who will we report findings and concerns with, request interviews. So we'll kind of talk that out at the beginning of the exam to understand the best way to move forward efficiently with the firm.
Any insight as to who, or anecdotal information even, as to who you may or who may have been point of contact, who you've seen, the level, title of the person who for different firms you may see?
Yeah, it tends to be really dependent heavily on the firm. For smaller firms, you might be dealing directly with the C-suite, or as Julianne mentioned, you might be dealing directly with just the people who are involved in the business right there. For larger firms, it tends to be a compliance liaison, perhaps, or for those firms who engage an outside compliance person, oftentimes they're our point of contact. But honestly, it depends on the firm, and it really is going to be up to the firms to decide what kind of structure works best for them when it comes to dealing with the regulator. I will say Julianne's point about smaller firms, or I like when we deal with some smaller firms where we're kind of talking directly to the practitioners. I find that it goes a little bit more efficiently as opposed to larger firms. Sometimes you're talking to somebody in compliance who then has to go turn around and ask questions of somebody else. So her point was a good one there.
Bob, maybe you can talk through getting into some of the finer points as to regarding maintaining of records and retrieving the documents. And so how do you go about gathering that information? So they've made the point of contact, and now it's time for you to start providing the information that was requested.
Yeah, so when it comes to gathering information, the key thing is how you maintain those records to begin with, so that you can easily retrieve them. Our physical records are kept on site, for the requisite period of time that is required, and we also keep many of our important documents that we produce throughout the transactions, like the checklists that we create, the final numbers, official statement data, etc., electronically in a file. We call it our compliance file. And then we also have a separate file where we maintain key documents, presentations, usually to support the recommendations that we may have made. Although we've noticed in practice that the examiners, when they make a data request for specific financing, so they usually want all the documents, not just the ones that we've set aside as being important. And then in our customer relationship manager, whenever we have a new financing, we make an entry for tracking the numerous data points that we may be requested to produce in a blotter. That's a lesson we've learned over the years, is try to think broadly about the data points that you may be requested to have, because going back after the fact to try to create the data by pulling up each individual deal or querying all the advisors to ask them questions. Like, for example, one of them I remember from a prior examination was the underwriter on a negotiated sale selected via an RFP or not. We had not been tracking that one, the blotter. Now, after the examination, we added that to it. So having that data prepared ahead of time makes it very easy then to respond to the request when it comes. And so after we receive that request, we schedule a meeting between our general counsel, chief of compliance, and other members of the compliance department. And then that group will meet with myself, and then we have a regulatory coordinator in our public finance department, disclosure and regulatory coordinator. And we get together to review the request and determine who will be responsible for gathering the various items that are requested. And then we also will look through it very carefully to make sure we understand the request, because the nomenclature may be a little bit different from what we may use. So we'll make sure that we're all in agreement with what's being requested. And if we're not certain, and then it's, we'll reach out to clarify and ensure that we're producing the data that the regulator wants. And encourage the folks that if it's a data point where you might be quite what they're asking for, just let them know you've tracked that instead of tracking what they've asked for, and that might satisfy them, so you don't have to go back and recreate something else. The important thing is to have a constant dialogue with them during that document request time, gathering time, to make sure that they know that you're doing it, and then and to clarify any questions that you may have. And then lastly, before we submit it, we will sit down again, that same group of people, review what we've produced, and discuss any questions that compliance may have for us, because most of those documents are coming from the public finance department. And then if we satisfied all their questions, then somebody from the compliance department will go ahead and submit it through the portal.
Thank you. And Julianne, anything to add there as far as the records, books and records part of it, and making it easy to retrieve?
I would just say that our process mirrors Bob's to a large degree. Obviously, I have fewer transactions to look at, and so and then in addition to that, you've got the hard copy file in addition to the digital file. I found that OneNote even to be a good tool to use as far as being able to document particular decisions that are made or particular advice that's given, and we maintain that in addition throughout the process of the deal. And then because there are so few deals, at any given time, we can pretty much put our hands on the hard copy of really frequently requested items like, engagement letters and things like that, because we're able to keep all the files in a single location with us, even well beyond the required period.
Great, thanks. So for Bill and for Dave, maybe you can speak to this question first, and then we can get back into the practitioners. What type of information is typically requested as part of a document request letter? What can folks expect to see as, the typical types of stuff that they need to be able to retrieve quickly to give to the examiners?
I'll start. The document request letter, it will vary depending on the firm, the exam, and what's being looked at. But in general, just to start off with an initial letter to a firm maybe who's never been examined, typically you're going to see a lot of background information being requested. Tell us about the firm, the business lines, your clients, activities performed for those types of clients, transactions involved in. We'll generate a list of questions and document requests to really come together and figure out get a better idea of what the firm does, how they do it, who they're working with, to help better kind of, efficiently move through our exam. Generally, you're going to have a request for written supervisory procedures. You have some more specific examples. You want to see how the firm is being supervised. Written supervisory procedures or something that will usually be requested at some point. First letter, generally. Any other documentation may be required under MSRB or SEC rules. Is required books and records is also obviously things that could be requests. I'm not going to go through the entire list, but you know, examples like the general ledger. So it varies by exam, but for a first request of a newly first-time examined firm, we would get a lot of background information to help us work through the request, and the subsequent request would follow to then ask more detailed, specific questions along with interviews and other personnel and otherwise.
For FINRA, it's more or less the same. What we're asking for depends a bit on where we're at in the process, but just as with the SEC, early on where we ask for basics, what's the list of engagements? Who are you municipal advisor professionals? Can we see your procedures? Are there training docs that you guys have? You know, can we see the general ledger? Later on, we'll get into more specifics where we're going to ask, you know, drill down into documentation of the relationships. We want to see the documentation of the advice that was given and the documentation of the supervision of the business. That's generally what we're going to be looking at. I want to touch also, Bob made a really good point earlier. Communication is key, and it's a two-way street. It's not just the firm communicating with us to make sure that they understand our document request. It's us communicating with the firm on what we see and working with the firm to kind of ensure that we're being as clear as we can when we make a document request so that they don't have a question later on. And then, you know, if we have concerns or any items that we think may rise to the level of an exception or something, we're going to raise that as soon as we can in the process so that there's kind of no surprises as we go along with the examination.
Yeah, I would agree with that. Communication throughout the exam is something that is very important, whether it be the phrasing of a question or a document request or a response, you know, to it. If something looks to be, you know, either confusing or just, you know, you think we're really looking for something else. If there's another document by a different name, ongoing dialogue during the exam is really important to make sure we move through it efficiently.
And how long does a firm have to respond and provide information that is subject of the document request? How should the information be submitted to the examining staff?
For FINRA, we generally provide 2 weeks for a response, but we have flexibility depending on what we're asking for. So when we ask for things that firms have close at hand or we think the firm want to have close at hand, like WSPs, we'd probably shorten the time frame. I would say we'd give a couple days to a week for something like WSPs. When we ask for items that are more complex or voluminous, we'd probably provide more than 2 weeks. So like when we ask for emails or copies of electronic communications, we know there's a lot more that goes into it. You know, there's a privilege review, and you know, there's working with vendors to try and get the things in the first place. So, you know, we go with over 2 weeks for that. In general, though, we're willing to listen to firms and work with firms if they feel like more time is needed. We'll allow for rolling production if that's something that's more useful for the firm. We try and take into account holidays and vacation time. You know, holidays we know about, vacation time, if we know that some key contact is going to be out for a little while, we'll try and take that into consideration as well. We can alter requests sometimes. So for example, there's some information we need it, and that's kind of the end of it. But sometimes we can scale back on the scope of a request. So maybe we initially ask for a quarter or a year's worth of information, but the firm comes back and explains to us, hey, to do that would be, you know, really onerous upon us. Is there any way that we can change what you're asking for? We may be able to work with a shorter period of time, right? So that the firm doesn't have quite the same burden on it to come back and provide records.
I agree with all that as well. In regards to timeframes, it really depends on the situation and records being asked for. I think Bill hit on the rolling production. That's what, you know, the expectation is that good faith efforts are made. If there's a long request list and not everything can be produced within a day or two, or the things that can be, as they're ready, you know, we would hope that it would be produced. We can work with the firm in regards to a lot of different situations, especially some of the NA onlys that are only, you know, 1 to 2 people. We understand people have vacations, holidays, and we work through that. But the rolling production is really a key thing here. If you, as Bill mentioned, supervisory procedures, that's something we expect probably shouldn't take 2 weeks to get to us. So that's the main point. But anyway, we're ready to work with the firms on timeframes depending on the requests being made.
Oh, great, thanks, Dave. And have there been any some differences or some considerations that have had to be made with respect to the COVID-19 pandemic? And how have you or what have you seen with respect to that? And are there any trends that came out of that that may endure post-pandemic?
Well, I'll say for our point of view, obviously, we are not conducting, as far as COVID-19 goes, we are moved to conducting exams through correspondence. So where we may have otherwise visited firms, we are not doing that. And obviously, we move forward sensitive in issues that have arisen with firms with regards to the pandemic. Again, the important thing is communication. Sure, as long as the firms let us know what's happening, we try to do our best efforts to work through. Obviously, we have a job to do, and requests need to be fulfilled and whatnot. But obviously, things certainly like COVID-19 are taken into consideration, but need to be communicated promptly. And at the same time, the issues tend to arise when if a firm just doesn't respond at all, doesn't get back, something's going on, let us know. But then you just hear nothing. That's when things start to become an issue. But yeah, so we moved to a correspondence exam with regards to COVID-19, and obviously make adjustments where we need to if something's happened.
Yeah, same as FINRA. We haven't been on site to any firms since, I assume, March of 2020. Early on, I think we had a 2-week pause in March or April of 2020, and we kind of stopped all work to allow some firms to get their feedback on them and everything and kind of plan out what they were going to be doing. There were a number of examinations that I think we pushed off later in the year in order to accommodate firms who are having a lot of issues around logistics and whatnot. Those are kind of one-off things. At this point, I think a lot of that has been resolved. Firms have kind of gotten their feet under them, but it's still a case-by-case basis. Still some firms rely more heavily on paper records, which poses challenges, particularly, we talked about early in the pandemic again, when people couldn't visit offices and go to warehouses, it was difficult or sometimes impossible to obtain certain records depending on where they were housed. So we would work with firms on that type of thing.
And for Bob or Julianne, any changes to your processes of making sure that documentation is that might be requested is easily retrievable in light of COVID? Anything that needed to change for that?
Yeah, well, we were already storing a lot of it electronically. I think, like everybody else, you got more reliant on doing things electronically. It's amazing what you're able to do without a printer that you always thought you would need a printer to do. And when we actually were examined not too long ago, and some of the documents that we had to produce were physically located on site. So that took a little bit more coordination, having people go into the office. We communicated that to FINRA, and as they said, to maintain that communication, provide what you can right away. But for the most part, we've been doing a lot of things electronically anyhow, so it wasn't that much more challenging.
I would echo the same, that really as far as process, that things have remained basically the same as far as documentation and process and being able to put our hands on things. I would say, and I'm sure this is the subject for a different panel, but a great deal of effort though on our part has been put toward helping our clients in disclosure and those type of things, which we might be reviewed for. And so you can't really talk about COVID from a municipal advisory standpoint without at least acknowledging that there have been some changes that would need to be made.
Thank you. So just thinking along again the life cycle of the examination process. Once the examination is sort of concluded, one question came into the chat room here is there a practice to provide closeout letter to municipal advisors once it's completed, whether or not there are findings?
I'll start.
Yeah.
You want to start?
You can go ahead.
Okay. As far as findings are concerned, I think the communication of what areas of concern, issue, or findings are, in our case, generally we try to bring that up as they arise during the exam. So, but to answer the question more specifically, yes, there will be a closeout letter either way, whether they're findings or not. But as far as communication of findings otherwise, I don't know if you want to move into that area, but the we tend to try to communicate findings as we go along so there are no real surprises. Ultimately, when we are finished with our analysis and review, we will have also an exit call with the firm to discuss findings more formally. We'll do a preliminary one to make sure all findings have kind of been raised to the firm. Then we'll have a formal exit call followed by the deficiency letter.
Yeah, very similar to FINRA. If there are no exceptions at the end of the process, I don't believe we issue a preliminary findings report because there are no findings. We do still issue an examination report, which will state that there are no exceptions. And then there will be no disposition letter because there's nothing to dispose of.
For Bob, if there are if there's findings, typically 30 days to respond on our side.
And are deficiency letters made public?
No.
For FINRA, the only ones that are made public, I believe, are formal actions that lead to an AWC. Regular exam reports that have that are either blank or that have or that have no exceptions, or that have things like cautionary findings, no further actions on them. Those are not published individually. Although FINRA does publish a yearly report that details findings in areas where we find patterns. So if we have the same or a similar finding in a number of our examinations, that will probably find its way onto the yearly report, but we don't specifically call out any particular firms on it.
For Bob, for post-exam closeout, what steps does your firm take to address noted deficiencies, and how does the firm document that the deficiencies, have been addressed?
Yeah, so with my experience with the examinations we've had, there's, as the guys have communicated, if there's things that come up, they communicate them throughout the process, but sometimes those things don't rise to the level of getting into the deficiency letter. Sometimes there's suggestions made that which I find valuable, where they give you an idea. Maybe they saw some other firm doing. An example was we have these checklists for all the steps that have to be completed. They recommended that we had the department head sign off on those checklists, just to make sure the team completed everything that was required on that financing. But if there was a deficiency letter, once it's received, we would have all the parties, pretty much the same parties that we had gathered together at the beginning, to discuss and review and talk about what changes need to be implemented. And then those changes would be implemented. And as was said in FINRA's case, you have to get the reply back within 30 days about what changes you may have made as a result of that deficiency letter.
Thanks. In 2017, SEC's Examination Division published a letter addressing the examination of new municipal advisors, and they identified 7 examination areas. Are those areas still in focus for municipal advisors who have yet to be examined? Also, is there an annual priorities list? I think that you meant that there was mention of that. And then, while not exhaustive, what are some of the resources that can provide a roadmap for municipal advisors on the areas that may be focused on for the examination?
Okay, I'll start. Yeah, the letter that you're referring to is from 2017, as well as the examination initiative announcement letter, I think was from 2014. I think are both included in the materials for the panel here. They're a good starting point. And certainly the areas noted in plus a few: registration, fiduciary duty, disclosure, supervision, books and records, training qualifications, fair dealing. Well, same them all actually, but there's still areas of review, of course. But to your point, it is a starting point. we have since new rules, we have new guidance issued. SEC.gov has information. MSRB, there's information there. We have some of the stuff in the materials in regards to areas of potential review. Obviously, there are newer rules as well that come out that the firm should also be looking at. So these letters that are in materials are a good starting point as a roadmap for very broad overview of what's looked at, and they're still relevant today. But yeah, it's not by any means a complete list. Things have changed since those letters were sent. And yes, there are annual priorities issued by SEC, which we'll touch on. Municipal advisors and what the priorities are.
FINRA also has some internal priorities. I don't think we publish them any longer. I can talk about it briefly. The areas that they discussed are kind of the main areas, right, that you can look at for a municipal advisor business. We'll probably look at things next year, including municipal advisor advertising, compliance with G42. That's sort of, as always, looking at conflicts of interest, scope of services in particular. That's something we always look at. Form filings, that's always generally on there. I would say though that if there's an area that we see that's not specifically under a priority like that, we'll still review it if we feel like there's risk there. It all kind of depends on the facts and circumstances of when we go into the firm, start examining the business, what we see there.
Thank you. And just a reminder for the participants that a copy of the 2017 letter and other resources can be found on the SEC's website under the resource list for this 2021 compliance outreach program. For those municipal advisors that have been examined previously, how does an initial exam differ from subsequent exams? Maybe Bill or Dave, you can speak to that.
Okay, yeah, I can start that off. When we're looking at first exam versus when firms that have been examined previously, we'll obviously have more information about a firm that's already been examined. So we may already have an exam file to look through. So we will be in a position where we will know more about the firm. Questions would arise in a follow-up exam with regards to any changes in the business areas or the way the firm does business or with whom. So that'll be a follow-up conversation. Obviously, depending on the results of the first exam, there will be questions about any deficiencies that were followed up on and how they were dealt with by the firm since the previous exam. But the two points where that would be different than the initial. A lot of stuff will be the same. It'll be a lot of risk review and see where the exam will be kind of where we will direct our questions. But previous exams, obviously, findings would be something of concern to us to go through follow-up exam.
More or less the same at FINRA. The only difference is the knowledge we have going in. If we reviewed her in the past and found the business was compliant, that supervision was strong, we'd probably double check to make sure that everything was still as we found it the last time. We may consider narrowing the scope if we felt like that was appropriate based on the risk profile of the firm. If we had findings in the previous exam or we felt like the supervision or cultural compliance wasn't as strong, we'd follow up on exceptions if there were any to review for corrective action. And we'd complete, a similar review as we did the time before. It really depends on where we find the risk at the firm.
And then maybe Bob and Julianne, from your perspectives, how has the examination process been different for you from the initial MA exam to a subsequent one?
Now, there's a lot of overlap between the examinations. Once there's general stuff that is the same. What tends to vary is what is the topic that is of concern at that point in time in the industry. For example, our last FINRA exam was at the beginning of this year, and so there's a lot of focus on the temporary SEC exemption for placements and do we use it? How do we implement our procedures or change our procedures as a result of that? Did we comply with all the requirements? So there always seems to be something that's of interest that they're focusing on that year that's changed from the last examination because it had something else that was in focus. But a lot of it is the same stuff as before. They want your procedures. They want to look at a certain amount of email. They want to look at sample some of your deals and go through those and talk through them with you. So it just generally changes with the important topics of that day.
And I just note that our firm is still anticipating our first exam. And so we're preparing for it to be exhaustive and hopefully ready.
So for a precautionary measure for all of the MAs out there, what happens if a deficiency is not resolved prior to the next examination? Maybe someone can step us through the process there, one of our panelists.
It'll depend on facts and circumstances as usual, but the first time around, we may have taken a look at it and said, okay, maybe that's another finding or an observation, right? Or maybe a no further action, something that either doesn't appear in the exam report or appears on the exam report, but we take no further action on it. If it's been highlighted to the firm and we come back around and it's still an issue, we may consider it bumping up to, okay, last time it wasn't on the exam report, now it is. We consider a cautionary action, or depending on the scope of the finding and the issues that we find, it could go up to and including formal action and referral to enforcement.
Yeah, I think facts and circumstances is the right way to put it. Depends on the issue, depends on the severity. But yes, obviously repeat findings, cause concern if they're not corrected, So yeah, that's the facts and circumstances in terms of severity. But yes, I agree with what Bill said.
In addition to, certainly focusing on and correcting, taking remedial action with respect to any findings, what other measures would you suggest that an MA might want to consider taking in between examinations to ensure compliances and practices are up to date with their current business activities?
That's very facts and circumstances. I would say keeping abreast of any rule changes and guidance that comes out, very important. And then testing the firm's processes and procedures against that, I think would probably be useful, right? If there's new guidance, if there's a new rule that comes out to say, okay, how will that impact our business, right? And then is our supervisory regime adequately positioned to be, ensuring compliance with it?
Yeah, I think review of supervisory procedures, taking into account changes in the environment in which you operate, is no replacement for a really strong, to maintain and enforce strong procedures. And if you are constantly, if you're evaluating as things change in the workplace, then you'll be in a good position.
Yeah, I was gonna say, I'll echo what those guys are saying. Is you really have to make sure the procedures are updated and they apply to your business model, and then your advisors are following them, they're familiar with them. You just can't rely upon the annual compliance meeting to go over those and feed it to them in a fire hose. You have to have frequent review and discussion with the advisors to go over those. And so we'll oftentimes, we meet once a week with the advisors, probably 3 times a month. There's always a day that we don't have it each month, to talk about things that we're seeing in the news. Like, for example, this week we saw the MSRB's request for information on their new release, and so we'll be talking about that. And if you're not having those frequent discussions with their advisors, they will tend to forget what's in the procedures, and obviously you don't want to have that happen, so that the next time exam comes around, you find out you have 1 or 2 people that weren't following the process.
Okay, and so earlier you talked, the panelists talked about some differences in the examination process, or maybe what would be requested for a smaller firm versus a larger firm. More specifically, are there different metrics of evaluation of the WSPs for larger firms with lots of registered employees to supervise versus small firms with a few registered employees to supervise?
I don't think there's a different metric. The metric of evaluation is whether or not the procedures is written and the supervisor system is reasonable in the context of the firm's business, right? And so what's reasonable is going to change depending on the size of the firm. FINRA member firms run the gamut in terms of the breadth of their business, and what's reasonable for a BDMA that has a lot of engagements and an underwriting business and secondary trading business, it's going to be different from a BDMA that's only got a couple, or maybe that's only registered out of an abundance of caution. So what really matters is, are the procedures, is the supervision reasonable in the context of the firm's business?
I agree with the size and scope of the firm will help determine the reasonableness. Obviously, a one-man sole MA would have different procedures in place, but needs to have them in place, a rule. So, but that would be different than someone 10 or 12 or 15 MAs. Obviously, supervision would definitely change depending on how large your firm is, what business areas you're involved in, or what type of activities you're engaging in. And the supervisory procedure should be tailored to that fact. It shouldn't be, oh, I'll just throw everything in here, and just have, I'm covered. It should be tailored. It should be if you want to maintain and enforce. So if you're not going to enforce what you put in your procedures, that could be a problem. So you need to, if you put a procedure together, it's reasonable and enforceable and workable for your firm. I think that's that when we talk about reasonableness, that's what we're looking for. Something where it's the firm has thought about its business and generated a procedure, created a procedure, is ready to enforce a procedure. It'll be reasonable for the activities they're engaging in.
Julianne or Bob, any thoughts from the practitioner side?
I might just say, I think that there are challenges and maybe pros for each type of firm. And so each one is unique. It might be easier for a small firm like mine to implement changes, but it also might be difficult to show accurately or efficiently show supervisory procedures for a single person. And so and Bob might be able to speak to the larger firm, but those are I certainly see that there are unique strengths and challenges to each side of that.
Yeah, with the larger firm, you have to make sure that those procedures, like I mentioned earlier, are understood and that they are easy to follow and they match your business model, and that you're testing those procedures. There technology's there to help you do testing within your systems, and whether people are completing their checklists or people are getting their documentation out in time, et cetera. And you don't want to find out just before the examination is going to occur that those things have not been followed. So it really is, incumbent, especially if you're a supervisor, that you're not just trusting people to do what they're expected to do. You have to really test and communicate with them regularly to make sure that they're following the process.
Thank you. So I'm checking the time and we're coming close, but I do want to just remind listeners that if you have any questions, please send them to 2021 maoutreach@sec.gov. In the meantime, I want to thank the panelists for sharing insights and experiences. I know one of the discussion points that seems to be a key takeaway for consideration is the importance, of preparation. That is, maintaining books and records readily accessible and retrievable as an important start to the process of the exam. Before or as we're waiting for some questions to come in, panelists, perhaps you can share the top one or two things to consider in preparation for an exam as a takeaway from this session, and I'll check for questions in the meantime.
I can go first. One or two things I think we've talked about quite a bit is procedures. maintain and enforce strong procedures, relevant, tailored to your business. When I say, and be prepared to amend as the environment changes, or something changes, something that may be not relevant to you today, a rule that may not apply to you, and now it does. One minute it doesn't, one minute it does, and you want to amend and change and cover that area. As far as my number two would be prepared to communicate with the exam staff. Be prepared to ask questions where requests are made, that if you need clarification, and just the more communication that we have with the firms, the more efficient the exam will go, and will potentially even have less burden on the firm if things are explained to us in a way that makes us understand that we can ask for something different, get same information, and as Bill said earlier, it may be something we need this and that's it, but on the same token, it may be, oh well, if you have this document, that would give us the same information, we can work with that. So communication and again procedures, that are relevant and important to your firm's business to ensure compliance with all the rules that you're subject to, depending on the activities you're conducting.
Yeah, I'll just piggyback on that and say, with the procedures, one of the things to remember is you have to be able to produce all the versions of your procedures between examinations. So don't get rid of the update that the prior version when you just updated it, because the regulators may want to see what's changed and may want to know why you changed that. And the other is suggestion I have is to continually try to stay in touch with your industry colleagues and trade organizations to see what's being talked about, what people are learning in their examinations. There's the National Society of Compliance Professionals, and our compliance department participates on their regular calls. I think they're quarterly, and comes away with some information that is being shared amongst industry practitioners. One tip I have from those calls, when it comes to OBAs and political contributions, we rely upon our employees to certify whether what their OBAs are, what political contributions they may have made. But there seems to be this expectation that's developing that you're not just relying on certifications. The technology is there to go out and do your own independent research and make sure that your employees are disclosing all those activities. So, just a tip there to try to use the different resources that are available beyond just what information you're getting from your employees.
Thanks. Maybe Julianne, if you have a tip or two that you can give, and then I'd like to wrap up with a question that has come in from the audience.
Sure. I think, the other folks have said basically be ready. Be aware of what your obligations are for rule compliance. Be aware of current regulatory focus areas. Keep good, complete files between examinations. Obviously, periodically review policies. Bob was talking about, be ready to amend and prove that, why changes were made. And then finally, I think maybe maintain perspective. Look at the exam process as an opportunity to improve. While probably it's nothing to necessarily look forward to, it does provide us all a chance to evolve and ultimately better serve our clients, which I think is everybody's goal. So completing an exam can be affirmational as well, that you're doing some things right and you're doing a good job serving your clients. And maybe if we all approach the process with big picture perspective, that would be a takeaway too.
Thank you. That's very informational. Just in the last few seconds, I think that we have Bill and Dave, maybe if you could just reiterate the closeout process, so as when a firm would know that the exam has been closed.
For FINRA, essentially, once you've received the disposition letter, which is where we issue the exam report that lists any exceptions that we found, assuming that there are no formal actions or that we're not referring to enforcement, once you receive the disposition letter that says, okay, for exception 1, 2, and 3, there's going to be a cautionary action. For exception 4, there's no further action. That's essentially the end of what the firm needs to take away from that point. Aside from, of course, any corrective action that we think the firm might need to take in the interim between examinations. But really, the exam is over from the firm's perspective once they get the disposition letter. There's some other stuff that we do internally to close out the exam, but that's mostly just making sure we've got all the documents in place and all that kind of thing.
On our side, I'd say, you know, the response to the deficiency letter will be evaluated and reviewed when it comes in for corrective actions to be taken or already taken. If there's issues or deficiencies that are still in dispute, there may be a follow-up letter sent out by the commission staff. But you work through the firm with that. But generally speaking, the response to the deficiency letter, if deemed adequate, would be it. But there could be a follow-up conversation if there's still disputed areas.
Well, again, I just want to give a big thanks to the panelists, Julianne, Dave, Bob, Bill. Thanks so much for the information and for preparing for today.
Absolutely.
Thank you, Cheryl.
You're welcome. Thank you.
Thank you all for joining us for our last panel of the day and for sticking with us. We will be covering SEC and FINRA examination and enforcement topics. So these things are things that's hot off the press, and this is always a really interesting panel for our regulated entities, municipal advisors. I am Bree Joyner. I'm the Director of Regulatory Compliance here at the MSRB. I'm going to turn it to my esteemed colleagues and let them also introduce themselves. Starting off with Michael. Michael, you may be muted.
Sorry about the technical difficulties there. My name is Michael Nuri. I work at FINRA in our fixed income regulation department. Thanks, Bree.
Thank you. Carla? Carla, you're muted, sorry.
I was just trying to make Michael look good. So Carla Cerna from the Securities and Exchange Commission. I work in the Chicago broker-dealer office.
Thank you. Mark.
Hello, everyone. I am Mark Zahner. I am also with the SEC. I am Deputy Chief of the Public Finance Abuse Unit in the Division of Enforcement.
Thank you. And this panel will not be what it is going to be with our industry practitioners. So first, Jerry.
I am Jerry Ford, and I'm with Ford & Associates in Tampa, Florida.
Scott.
Hi, Scott Koya, Deputy Chief Compliance Officer for D.A. Davidson's Capital Markets and Operations area.
All right. Thank you all. Thank you all. Well, we have a full agenda, so we will go ahead and get started. Of course, examination practices and observations are always one of those areas that is top of mind for firms as to when I'm going to be examined, what would be looked for. The last panel gave a great setup for preparing for an exam. Now we'll kind of pivot and talk about examination practices and what are some of those deficiencies and observations that have been noted. So I will turn it to Carla to ask you, Carla, specifically, what are some of those common deficiencies and the findings that basically teams are noting on exams of municipal advisors?
Sure, thanks, Bree. So I think just some topic areas are books and records. It's always kind of a big one for us. And I want to talk a little bit about some travel and entertainment, which I know might not be super applicable in our world, pandemic world today, but it has been in the past and probably will be in the future. And then I want to pivot a little bit to the service contracts. So for books and records, that's something that we definitely review for accuracy and retention of books and retention of records in our exams. And it covers a broad category of things. So I just want to touch on some of the ones that have come up recently and come up frequently in our exam as problem areas. The first one being written communication. So we know municipal advisors are required to keep their originals and copies of all written communications, including written correspondence that's paper and as well as electronic communications. So two of the areas that we've noted recently where firms have been struggling to be compliant is retaining their communication for deleted messages and text messages. So for deleted messages, those are required records as well. So those should be archived and in order to be compliant with the rule. So I would suggest checking your third-party provider or your cloud server to make sure that they're set up to capture that deleted folder or any messages that are deleted and then are wiped off the system after a certain amount of days to make sure that they're being retained in accordance with the rules and regulations. The same goes for text messaging. If you're allowing personnel to use text to conduct business, those messages are a record of the firm and should be retained. If the use of text messaging is prohibited by your firm based on your policies and procedures, you should have a process in place to determine if your personnel are adhering to your policy. So, I mean, you know your business best, you know your reps best. We know that the art of dealing with clients, it's a very conversation-intensive business. So if you're reviewing emails and you're seeing very limited email traffic between your rep and your clients, then you need to ask yourself how your rep is conducting that business and use a little bit of skepticism and try and determine, is that communication happening in a medium that you may not be capturing? And if it's a text message, it is considered a written communication, and therefore that mode of communication needs to be captured and retained. And sort of on the same topic of written communications, we are noticing that firms are not retaining those communications for the required retention period, which is 5 years. So again, that's just something you need to review with your third-party provider, make sure it's in the contract, sort of determine how long those communications are going to be retained by your provider, and then how you can access those records when you need to, say when the SEC comes knocking and asking for those records. So that's just kind of one of the big areas that we've noted recently and have been for a while, is the written communication retention there. So just want to pause in case there's any follow-up questions there. Okay.
Hey, Carla, if I could jump in.
Yes.
So if your firm, if a firm has an indication that you have a registered rep conducting business outside of the firm's approved systems, how would the firm, aside from discipline matters, right? How would the firm, or what are expectations that the regulators have around how that firm might remedy that situation?
Well, I guess I guess it would depend on the scope, right? So if you have, one rep who's sending an occasional text, you might prohibit the use of that cell phone, or if you have, someone who's using a personal email account, you might have to loop that email account into the retention system. I know that there are third-party providers who can capture text messaging if you list the number or something. I really am not tech savvy enough to know how to answer how that happens, or whether that's a cost-effective method for a firm. But there are services out there that can capture text messaging, and then the email retention. I think that's a little bit more common in our industry. Global Relay, Smarsh, those are kind of the big ones that come to mind. And I'm sure that they have a way to retain those deleted messages. But again, I don't know the how that happens on their end.
Thank you.
Sure. So another record that we request during exams that we've also noted that firms are not retaining are the written consents to service of process for personnel who are engaged in activities for the municipal advisor. This appears to be something that's sort of slipping through the cracks for firms. We've noted it in a couple instances as recidivist findings. So, firms should be incorporating a review for consents to service to make sure that they're compliant, whether it's part of the onboarding process when you bring on new reps, or if it's part of some sort of internal inspection, just verifying that that record is in place for each registered person who's conducting business on your behalf. Let's see what else here. The needs analysis and written training plans, we've requested those items a couple of times, and we've found that firms are not retaining, or firms don't have those records, right? So those are records that are required by MSRB rules. And then we've also found sort of in that respect that firms' procedures sometimes fail to incorporate a process for developing and maintaining those records. So we've also cited supervision violations in addition to a books and record violation in those cases. So the last thing I want to touch on as far as books and records is the ever famous general ledger. I know you guys are familiar with that record. It's sort of one of the records that provides a wealth of information for us about your firm. So it's something that should be kept accurate and complete. We've noticed inaccuracies in the general ledger that sort of range from minor to severe, right? You get the minor infractions where somebody enters the incorrect amount or transposes a number, something that is going to raise a red flag and when we can't tie it out. And then you get the more egregious violations where the general ledger is just not properly reflecting either certain expenses or certain liabilities. There's revenue that's not being accounted for. Those kind of violations are, skew the firm's business a little bit in respect to how we can review it. So it's just important to keep a very accurate and complete general ledger so that it reflects your business practices fully.
Well, I think that's a great point. I think during our practice sections, someone actually communicated that this really shows how you're doing business, right? The general ledger. And I just wanted to kind of ask our industry folks, if I can put you on the spot quickly. Scott, you're at a firm that basically is a broker-dealer municipal advisor. Can you just maybe talk to how the general ledger information related to the MA business and the deals are kind of kept separate to the extent they are and how easily accessible? What has Davidson put in place to make sure that the general ledger information related to the MA business could be produced to Carla?
I'd have to say it's a bit of a softball because since DA Davidson is a broker-dealer / MA dual registrant, we obviously have the luxury of already having the general ledger in place for our underwriting and public finance business. So we essentially do, we essentially have an identical process, whether it's T&E, whether it's expenses, cost of issuance. We try to keep it as itemized as possible, which I would actually kind of relay a question back to the examiners and the regulatory staff on this panel. How detailed should that itemization be? Because I've seen it in different manners. So I guess my question is, how detailed should our general ledger be, and how detailed should our expenses and disclosure be to issuers when we have the ability to expense items?
That's a good question, Scott. So I'm going to put that to Michael because Michael will be the person who's knocking on your door asking for this. But any general thoughts, Michael?
Yeah, I mean, without too much specificity, I think I haven't heard much through the grapevine in terms of the general ledgers themselves lacking specificity. I think, Scott, you're aware that if there are questions, they'll be asked, and I like to think that people are reasonable on the FINRA side, and that if something needs to be articulated, that can be taken care of. In terms of disclosures to the issuers and itemization of expenses or other costs associated with the issuance or compensation, I think that's something that firms can decipher themselves, and be reasonable. And I think it's fair to say the regulators will try to hone in on that and understand, where all the dollars are coming from and going to. I don't know if I have much more than that. I don't know. Anyone else care to weigh in?
I think that's good. I'm just going to turn to Jerry. Jerry, any thoughts about the detailing of general ledger or how your firm go about making sure that you are ticking and tying all of that information with respect to revenue expenses? Because I know you had a great story to share about being asked to kind of track down information related to it. You're laughing, right? To a $75 check. So just your general thoughts about general ledgers.
Sure, I will say that once I got the explanation for why this occurred, it made a lot of sense to me. Prior to that time, we were shaking our head. But when we had our exam several years ago, the exam team was very, very thorough, very fair. But they wanted our check registers, they wanted all individual expenses, but they particularly wanted to see any income that we had received. And so when we keep our general ledgers, obviously it's by client, by transaction, within client. If there's a purchase order there, if we have expenses, it'll identify them as to whether or not they're reimbursable or non-reimbursable. And we were asked, one of the things that we were asked for was to provide substantiation for a $75 check that we had received. You know, what was the source of this income? Was this legitimate? It was for a workman's comp insurance overpayment that we had made, and it was reimbursement from the insurance company. But that was sort of the level of detail that we needed to be able to provide. And in talking with the examiners later, it's simply that they take a random sampling of what's out there in those things, and they look at that, and if that if that income comes up in that random sampling, size really doesn't matter at that point. You're going to need to substantiate it. So your general ledger needs to enable you to do that.
Thank you for that, Jerry. Carla, we'll turn it back to you to continue to talk about some observations. Thank you, guys.
Yeah, thanks. Okay, I just want to follow up on the whole general ledger. I know 75 seems like a really small amount, but if you see a consistent amount of transactions for like, you know, general same amounts, then you see this outlier that's like $75. That's like a quirky number. And like with an accounting background, that is really hard for me to let go. So I don't know that I would have asked for that level of detail on $75, but I certainly would have asked like, hey, this seems a little odd. Why is it on here? But yeah. Okay, so the next area that I wanted to touch on is, again, the travel entertainment expenses. And again, I know it's been a little bit limited in the last year and a half or so because of the pandemic, but it's one of the areas that we review and one of the areas that comes up frequently with findings for us. So the big issue that we know in this area has to do with the firm's ability to review for compliance with Rule G20, which you know, is the gifts and gratuity rule. And the language in there, I think it's in one of the notes to the rule, says that the gifts, let's see here, need to be not frequent and not so excessive as to raise a question of propriety, right? So we found that the way firms are tracking these expenses falls short of allowing them to be in full compliance with the rule. So tracking the expenses needs to be done in a way to allow the firm to aggregate on a per recipient basis. Without that kind of tracking, it sort of renders the firm unable to reasonably supervise the entertainment expenses. If you can't determine the totality of travel, entertainment, gifts in an aggregate basis on a, you know, for each recipient, then how can you determine if it's frequent or excessive, right? If you can't make this determination with the way that you're keeping your records, then you may not be able to comply with G20. And again, that's probably going to depend on the size of the firm, right? Smaller firms can probably tell you ballpark how much they're spending on a per client basis. Larger firms, unless you're tracking it, it might be a little bit more difficult. And that's not to say that the amount that you're spending to entertain clients is it's unreasonable. It may very well be reasonable on a one-off basis, but taken as a whole, it might lead to some issues as far as validity under G20. By extension, how can you be conducting adequate supervision of your personnel in this respect if you don't have a system in place to make the determinations regarding frequency and excessiveness, right? This is, again, something that came up a while back for several firms. And I anticipate once we start being able to travel more consistently and entertaining more consistently, that'll probably resurface again. So.
Yeah, Carla, I think that's a great point to mention because some of our rules actually have within it, embedded in it, the books and records requirements, and there are other rules with G8 is what you refer to for the books and record requirements. So, but G8 does specifically talk about the records that must be made and maintained of the gifts that meet that threshold limit of $100. And to your point, how can you actually, so it's a requirement under G8 already that you have that information, but when you're talking about aggregation, there's no way to really be able to aggregate that information unless you're keeping that information of the $100, those that are subject to the $100 limit.
Right, yeah. And I think it's important to note too, you know, some of the arguments that we get with respect to the entertainment and gifts and gratuities is, you know, like firms make it available to all their clients, right? They send out a blanket invitation or they send out the gifts and, you know, it just happens client A seems to show up a lot. And that's fine, right? That's how you want to conduct your business. But when an auditor or regulator comes in, it's going to be you who has to justify that aggregate total, not the client who's been receiving the gifts, right? So, so just, be aware if there's a way for you to track it on a per recipient basis, then you might be able to see a pattern or a trend, which is probably what we're going to be looking for. Okay, so the only other thing here that I want to talk about is the engagement contract, and I know that Michael is also going to talk a little bit about the municipal advisory services, but this is one where we get a lot of findings in our reviews. So the engagement letter should be reflecting the services being provided and the compensation for those services. They should be disclosing any expenses associated with the advisory relationship and for the activities being performed. We've had a few instances where firms are charging clients some consistent expenses, right? Some expenses that are sort of part of their general services performed for every offering. Typical things like computing and structuring, phone delivery, copy services, drafting services, things of that nature that come up almost on every offering. But those expenses, those services, they're not being disclosed on the contract. Habitual costs like that come up and are known probably should be included in your contract. Another thing too, with respect to the costs and expenses, we've also seen a failure by firms to have a system in place to review for potential reimbursement of excess costs. So for instance, we cited a firm who failed to properly reimburse clients for excess cost of issuance funds. So when there's residual funds left over after paying out cost of issuance on the offering, those funds should be returned to the client. So in this case, the clients did receive their refunds, but it was months after the offering closed, right? So the MA didn't have a way to sort of review those costs to see where the excess funds should have been returned. Now, in the case of this particular firm, they actually had procedures in place that would prohibit them from handling, holding, or investing client funds. So we were able to tack on a supervision violation in that respect because they held those funds for a few months before returning them to clients. And the only other thing I want to mention on the engagement letters is making sure that you are including services in your contract that you are providing to your clients. So basically, if you're doing it in practice, it should be something that's included in your contract, right? In this case, we've had a firm who would accept good faith deposits into an escrow account and then return them to the client at the end of the offering, right? This is a service that they provided on every offering. It was something that we noted consistently for all the offerings that we selected for review, and none of the contracts had this service in the written contract, basically. So if it's something that you're doing in practice as part of servicing your client, you should make sure that it's included in your contract. So.
And so I will pause there because we had a pretty lively discussion about this particular issue about the municipal advisory relationship and how much information or detail around the scope of services and the limitation on the scope of services. But before I say that, I will agree with you. We've always said, whatever your WSP says that you're going to be doing in practice, make sure you are going to be doing it to carrying out to meet the obligation. But Carla, thinking about that, I mean, we touched on this issue about not everything necessarily, I mean, this is under 42, but not every single thing needs to be documented as part of the scope of services. But I think where the group landed is those things that are routine that the municipal advisor is performing under contract are those likely things that make sense you should be including as part of the municipal advisor relationship. I want to turn to Scott and to Jerry first, just thoughts about this, because part of that conversation was, you all deciding the balancing act between how much information to include in your municipal advisory engagement letter. Just general thoughts, Jerry?
Our engagement letters, for the most part, are relatively detailed. We have gone back and forth on this issue. We've used outside compliance counsel to review our engagement letters. And every time we try to make it a little bit tighter, they want to expand it back out. So it includes all of those things that we normally do, and then it includes those things that may come up on a semi-regular basis in an issue. And then they include a general services clause. But they also include language that in regard to specific non-transactional projects that a client would like us to take on and specifies that we have to come to an agreement on pricing in advance of those services and have a separate written request for those on top of that. So fairly broad to begin with, and then leads us down a path that says if it falls in this area, you have to have additional documentation.
Thank you, Jerry. Scott, additional thoughts?
Yeah, that's a tough topic, and I would agree with Jerry. I think a lot of firms in the industry have gone to some kind of counsel to review, including us, to review our scope of services. And the more we try to scale it back, I believe the larger the scope of services, or the larger the letter became, because there are a lot of details that are involved in what a lot of municipal advisors do. And again, every transaction, every agreement is going to be different. Every issuance and every issuer has a different need. Sometimes, we go as detailed as putting in 10 board and council meetings. And, there are MAs that I know of that they're there till 9:30 at night, just making sure the I's are dotted or the T's are crossed. And we're trying to capture those things in the letters. I can't, Brady, I'll be honest, I can't say that we get it all the time. But I think what's important there for firms to realize that is, if you put something in the letter that you state that you're going to be performing routinely, that you likely should have some evidence that you did it. Because I have noted some FINRA examiners asking us about that based on the scope of services. Can you show us that you've done this work? Which is, I know that's a tough one, especially for folks that are just, grinding it out. But we've gotten the question, so our expectation is set a little differently now because of that.
Great, thank you. Oh, Jerry, back to you.
Yeah. One of the big challenges is smaller FA firms don't have a Scott on board. They don't have somebody who spends full time doing this. So you have an advisor who is working 10 plus hours a day, frequently working on weekends, just responding to client needs. And it's trying to find a regimen and a process in there that allows them to do their work and allows them to remain compliant at the same time. And it's a tough challenge. It can be extremely taxing, and you never know if you've hit it right, because as Scott said, every time they try to tighten it up, it gets longer. So it is not an easy job.
Thank you for that. Carla, let's basically, I think there was maybe one other issue that you were going to touch on.
Yeah, I just want to mention, I know you guys covered it in an earlier panel, but reviewing pricing related advice, that's an area that we look at frequently, and it's one that always probably yields some really good findings for us. So it's just something to think about at your firms, especially in cases where you're a duly registered BDMA, which could create some unique conflicts between your bond trading desk and your municipal advisor. So just something to be aware of for the future. And I did want to point out that the source link that you sent out with like the production for the panelists, one of the earlier panelists put out a risk alert that came from the SEC regarding examination findings. I think it was issued in 2017, so it is a little dated, but just about everything that I covered is on that release from 2017. So it is like these are findings that are consistent and frequent and that we find often. So just something to think about.
Perfect. And Carla, I want to pull that thread a little bit more, because you mentioned pricing, and then you said that there's some of these areas that generally lends itself to some findings. I'm sure some MAs are wondering, since we just basically issued our request for input, there was an entire panel on pricing. Can you drill down a little bit more when you're saying there's generally yielding some findings there?
Sure. So and I think Mark is probably going to talk a little bit about some of the issues with his enforcement cases. But the trading activity that's happening on the bond trading desk and the BD side, and whether or not your municipal advisor advised on that offering, when those trades happen, were they at discounted prices? Do you have policies and procedures in place to sort of mitigate any of those conflicts that might arise? Are you taking a more conservative approach where you're waiting a day, a week to be able to trade those bonds, or are you going right at the free to trade wire? issues like that have cropped up for us. And again, I think Mark will probably cover some aspect of those enforcement cases.
Yep, that's perfect. I know Mark is waiting in the wings to kind of carry us through some of those hot off the press enforcement cases, and some of those that basically just good for lessons learned. Okay, so before we actually pivot and switch to Michael, I just wanted to kind of just reiterate a couple of things that Carla mentioned. Just be aware that it's SEC Rule 15 Cap BA 1-8 that covers your books and records obligations, and also MSB Rule G8 as well. Just go through that. We always hear that this is a common deficiency with respect to the books and records and making sure that you're maintaining all of those enumerated items. So just wanted to make another plug, as Carla did, regarding books and records. And also too, when Carla was talking about travel and entertainment expenses, what perked up for me was I thought about G20 and G20E specifically on the prohibition of the use of bond proceeds for entertainment expenses and being reimbursed for that from the bond proceeds. So I can imagine that part of, once we get back to the normal world, when you're looking very closely at the travel and entertainment expenses and looking for, the revenues in those expenses, you're also likely, looking to make sure there wasn't that violation of Rule G20E on the reimbursement for bond proceeds. So just be mindful of that as well. Thinking about not just basically meeting the other obligations under G20, but specifically thinking through that prohibition on bond proceeds being used for entertainment expenses. Okay, now I'm going to turn to Michael, who has been patiently waiting for Michael to talk about some of FINRA examination practices. And Michael also is going to give us some of those thoughts on future priorities. I guess that FINRA has been diligently working through that process, so he'll give us a glimpse into what can be expected next year for exam priorities as well.
Thanks, Bree. I guess I'll start kind of with the simple items. One of the key findings that we frequently run into is the timeliness and accuracy of various form filings. Now, I know Mark here can, calculate net present value in his head on an advance refunding, but most regulators aren't that good, but they can do simple arithmetic, right? And so Form MA filings that aren't filed within 90 days after the fiscal year end, or A12 annual affirmations, which I believe, Bree, don't put me on the spot, 17 business days after January 1st. That's just low-hanging fruit, easy pickings for the regulators. And then it just leads to possibly more questions. Similarly, with the accuracy of the form filings, we're not just limited to the arithmetic. So one plug is we've run into a couple times with Form G37 filings. Municipal advisors are required to disclose their engagements, regardless of the sale method type, whether the offering was competitive or negotiated. That's something that's different than on the underwriting side, and with our dual registrants, sometimes they might trip up over that. Another one that maybe for the non-dealers in the audience might sound more complex than I think it really is, but it's related to Form BD on CRD, and it's just a reminder for the dual registrants. And hopefully this isn't too complicated, because if you go into the system, I think it's straightforward. But if you check other on item 12, and then type in MA business as a business activity in Schedule D, just so that the CRD registration reflects that. Another thing, just in terms of A12, making sure that all the information that's applicable is provided. I've seen multiple firms that haven't put in firm websites, even though that's a requirement and they've had a website for a number of years. And again, this is, and Bree, if you want to jump in, please do, but this is again more for the FINRA members, but on Form A12, they are required to have a principal as their regulatory contact, both primary and optional, if they want to have an optional. And firms run into this a lot, and might have their president or a compliance person without a principal registration. And, I don't want to ruffle any feathers, right? Because that requirement at this time, at the very least at this time, isn't the same for the upcoming Series 54, but just for the dealers in the audience, I wanted to bring that point out.
Yeah, Michael, that is correct. That 812 specifically requires that the regulatory contact is a principal, but that obligation is not an obligation that we have amended 812 to say that the regulatory contact for municipal advisor principal for an MA has to be a principal. So that is not the current obligation. That is correct.
So just moving on to another area, advertising. This is something that FINRA has been focusing on with its municipal advisor exams. And I think, Bree, you said this to me, and I liked how it was worded, but some firms sometimes forget that their websites fall under that purview of advertising. And I'm not saying that this is every firm out there, but we've seen at times firms incorrectly state or imply that associated individuals are municipal advisors when neither the individual nor the firm is registered or qualified to act in that capacity. And then again, this isn't frequent, but just thinking about false or misleading statements on whether it's hard print advertising or on your website. Just be cognizant of what you're saying. Those grandiose statements should be factual, not hyperbolic. Think about retaining supporting documentation for being a top 5 municipal advisor, doing X billions of dollars in engagements. You can even footnote those on the statements. So that's another area that FINRA has been focusing on and is continuing to focus on. I'll pause if there's anything, Bree or anyone, if you wanted to jump in.
Michael, I think maybe keep going. I do have some questions that I'm going to put to Jerry and Scott in a bit.
Okay.
I'm circling back to advertising, but we'll let you get through some of the rest of the observations.
So travel and entertainment, I think Carla really hit a lot of that on the head. I imagine there's going to be this increase in a desire to entertain and interact with clients as the pandemic, fingers crossed, recedes, goes away. So I don't want to re-emphasize, but I will say, and I didn't even think about this earlier, but Carla, the aggregation piece is something that we run into quite a bit, and something that I think is asked on virtually every FINRA exam. So just making sure you have the right ways of maintaining gifts and gratuities and entertainment for aggregation and supervisory review. The only thing I'd add is that just as a best practice, it's probably a good idea to not only be familiar with the requirements under the SEC, FINRA, MSRB regulations, but also state-specific restrictions on gifts, gratuities, entertainment for government officials. With regard to books and records, put me on the spot with the general ledger and the cost of issuance, Scott, but I think Scott, you're probably aware that a lot of firms that are dual registrants, it might be hard to siphon out the MA activities on the general ledger. I think FINRA examiners would typically take the approach of, in terms of reviewing deals or activities, requesting the detailed cost of issuance, and reviewing to see if there were remittances for miscellaneous fees that are going back to the firm. If we see OS printing cost 20 grand, we might ask about that versus something smaller. So I think that's kind of how we would hone in on, concerns with the financial records. Sticking with books and records and kind of supervision of books and records, I'll just agree with a lot of what Carla was talking about in that regard. But in short, like you can't just start retaining all these records and then just put them in a file cabinet and never look at them again. That's not really an effective supervisory system. So like written communications, just taking those and putting them somewhere isn't an effective supervisory procedure. As an example of a best practice, I've seen some firms that have their bankers summarize on a quarterly basis the interactions verbal that they had with their MA relationship over that quarter. I'm not saying that that's necessarily mandatory or anything, and I'm cognizant of the varying sizes of the municipal advisors out in the industry, but just something to think about and sort of noodle on. Finally, I think the kind of the area that we're always looking at and we're running into things and is conflicts, right? And I think that is one of the key underpinnings of the whole municipal advisor regime. And it's just important for firms to think about, and I think we talk about this every year, right? But it's just so important, right? So it is important for firms to think about and develop a process for identifying conflicts. You know, we've had some dual registrants with poor pipelines of communication between their MA business and their other business units. And I think Scott, when we were talking before, brought up some good points, and I can be sympathetic. I understand, right? Because in a lot of ways, you're trying to create information barriers between your different business lines, but at the same time, that MA business unit needs to stay abreast of conflicts that might arise with their engagements over the course of that engagement. Now, it's not just at the beginning, one stop, and then it's done. You got to keep an active, proactive approach on that. And I'll just bring up that with the blanket or evergreen agreements, that's really where this can come into play. And, you know, maintaining when you have that long-standing engagement over a number of issues, you know, looking and verifying that if there are new conflicts and disclosing those, you know, promptly after they arise. Just checking my notes here. I think that really that's the main things. I believe, Bree, that in the sort of the links to enforcement actions, there is the Emeritus case, which I think ties into the evergreen agreements and, you know, role switching, which is, I think, really a sort of a example of a conflict and something that firms need to be aware of. And when you have those evergreen arrangements or longstanding relationships with firms, making sure that you disclose your role on that issue and that the issuer fully understands what side of the table you're on and what you're doing for them in that offering. Do we want to pause there before we get into sort of forward-looking statements?
I think we can pause there. Michael, did you want to say anything about the OBAs and Form MAI updates? I think that was one of those areas you want to kind of put a plug in for as well.
Right, and going back just to conflicts, MAI, right, requires disclosures of outside business activities, and just be reasonable, right? And, you know, if you're on the board of an authority, I don't have that as a real example, right? But and then your firm's engaging in some business with them, that's a potential conflict that needs to be addressed and mitigated. And so going back to sort of the forms and the conflicts, OBAs is something that the regulators pay attention to because there can be sort of improper cross-pollination, if you will.
And so, Michael, I did want to kind of just circle back to, you mentioned G20 and being mindful of other state obligations. We had a really good conversation about even at the local level, there may be restrictions on gifts and gratuities, and also at the state level. And we start thinking through all these different state restrictions that are pretty, Florida, I know, Jerry, you said is pretty tight on gifts and gratuities. We talked about Massachusetts and other states, but that is a requirement under Supplementary Material Point 5 about thinking through the applicability of state and other laws. And so G20 does not supersede state law. So I just wanted to make sure that I deposit that with everyone as well. I did want to also go back to touch on advertising. That's an area that FINRA is looking at, or will be looking at. I know that's an area also too SEC is looking at. And Michael, you talked about the content standards and not being verbose and footnoting. I would say we've also encouraged firms to maybe source your information. So if there is a specific reference that you're taking and the statement is very specific, put a source your statement itself. I mean, I know Jerry wants to say he's the best in the South, but I don't know if he can actually source that statement. So make sure when you're listing detailed information that is a statement, a factual statement, it may be helpful to put a source reference in the footnote to that statement. So with that said, I will ask Scott and Jerry, let's talk about advertising. How often are you all reviewing your website just to make sure things like Michael said, the firm is not even able, or the person is not even at the shop that's listed on the firm's website as engaging in business. So thoughts on review of the website and how often you all are doing it?
I'm going to throw this one to Scott because we have aggressively avoided, to this point, it will change in the coming year, but we have aggressively avoided having a website.
Oh, okay. Scott, what are you all doing?
Good answer, Jerry.
Wait, I will say, Jerry, that may just mean you are the best in the South, or if you're getting that much business, not even having to have a website.
Am I allowed to say 19 out of 20 Ford Associates clients say they're the best?
Okay, Scott, go ahead.
Yeah, I mean, being a dual registered BDMA, we have a typical FINRA advertising supervisory processes in place. So everything gets pre-approved on our end, and we keep a copy of it. But when we talk about websites, we generally try to keep our website very vanilla. You know, it has, you know, services on there, and it has some, you know, lead-ins for different divisions within the firm. And I think the thing that firms should be not more concerned with, but concerned with and really look at is social media. So that's something that we spend a lot of time and effort, because there isn't a silver bullet out there. We use a vendor that helps us to monitor for social media. But like I said, it helps us. It doesn't do the job for us. So, you know, we take reviews of, you know, what's going on in, you know, Twitter, LinkedIn, and you know, those types of things, just to make sure we are not promoting things that are considered advertising. And if they are, the entanglement or adoption, we're trying to be very careful to make sure that they are being pre-approved or post-approved if need be, and retained. So it's kind of a hairy process, frankly.
All right, thank you for that. And just Michael, before we move on to touching on conflicts of interest disclosures with Scott and Jerry, did you touch on the G37 form filings, or do you want to cover that briefly?
I think maybe I don't know if I forgot or said earlier, but essentially just a reminder that for municipal advisor engagements, the requirement to file those engagements applies regardless of whether the sale method is competitive or negotiated. And similarly, the political contributions where required would need to be disclosed as well.
I think that's a good point, Michael, to marry up the two, because when we're talking about BDMAs, when you're thinking through your Form G37 filings, one of the obligations, of course, is to report any municipal securities business, but that is limited in scope to actually just negotiated and not competitive sales. So for MAs, there is daylight, because municipal advisory business is very broad under definition, under the definition of 37. So that would make that the MAs would have to disclose all of the business activities and not just specific to negotiated sales. All right, so Jerry and Scott, we've talked a lot about conflicts of interest, and I think it's just necessary for us to spend some time understanding the practitioner's perspective of how you all go about some of these things. So I want to follow up on Michael's comments, and there've been the idea of BDMAs and having the idea of some core pipelines between the MA business and dealer shop and being able to look across the business to make sure that there is that, although there's that walling off of the business activities, that information is flowing as necessary so that inmates can make the necessary conflicts of interest disclosure. So Scott, I will just ask you to briefly maybe speak to your thoughts on what are you all doing at Davidson to make sure information that does not need to be provided isn't provided, but that there's the sufficient information to inmates for purposes of conflicts of interest disclosures.
Yeah, always a hot topic at our firm. Some of the key tenets are privacy, confidentiality, trying to create information barriers so we're not overly disclosing material non-public information. So when those controls are in place and they work, generally speaking, trading, sales, banking, they may not be talking. There may not be information that is flowing back and forth. So I think what is very important for firms, and I've seen this at a couple of firms that they've done, is they've created an administrator that's kind of like a super wall approver, someone that sits above the wall that can see both sides of it, and then assess whether or not there are conflicts or whether or not, again, how would we know that we have, for example, an underwriter or, a public finance banker that's working with an issuer, and there's an agency or issuer alike that we have MA business and they're trying to engage there. How would we figure that out before it got too late? And so, I think the idea of having an administrator or some kind of a governance process that delivers that information properly, I think that is necessary in this day and age.
All right. I'm going to now go to Jerry. Tracy Palmer touched on panel 1 about evergreen agreements and reviewing for conflicts of interest disclosures by virtue of the fact that there is that very long and existing relationship. She mentioned that they're doing their conflicts of interest disclosures, I think, quarterly. How often are you all reviewing for conflicts of interest checks, understanding that you also too use evergreen agreements?
We do it no less than annually. We put out a new conflict disclosure to all of our clients. And then whenever we have a new client come in, we check and see if that client would create potential conflicts with existing clients. And if we do, we modify our disclosures there and send those out at that point in time.
Okay. And so, Jerry, understanding business is different at Ford & Associates than from a D.A. Davidson. Just thinking through policies and procedures to make sure you're adequately identifying the conflicts of interest and disclosing them. What are you all using? I know Tracy mentioned a deal tracker. Is Excel spreadsheets. What are you all doing at Ford & Associates?
We have written documentation. Basically, it's a matrix that's kept here in the office that identifies who the clients are, when those disclosures have gone out, what potential cross links there might be. And then we meet on a regular basis. Obviously, we're all very close to one another here. We meet on a regular basis. If anybody has been asked to step onto a board, asked to participate in an outside activity that may create a conflict there, we will document that.
Now, Jerry said every
process for us.
A simple process. As Jerry has noted, he said everyone's in the bird's eye view, so it makes tracking that information pretty easy for their firm. Scott, I think you've mentioned sometime about deal flow tracker. Can you talk about the policies and procedures that you all have in place to identify conflicts of interest?
Sure, yeah. Depending on the stage or phase of a transaction or an engagement, we have certain controls and checkpoints in place that, for example, if there were an opportunity, we would list it as an opportunity. And if it moved into transaction, that essentially means that it's past our conflicts check, right? So, it's not perfect, but in the aggregate, there are a lot of control points that are done throughout the transaction process. But we use a deal flow pipeline tool that helps us there. If you don't have that, yeah, I mean, a matrix or a spreadsheet can certainly do it. But, I think it is necessary. I think you need to list out and then date out of what it is you need to do and when.
Right. I think, Scott, you made an important point that you also detail at the beginning, just opportunities. The business that may generate some opportunities for the firm.
Correct.
All right. Okay, well, I'm going to now move away from examinations and observations to enforcement actions. I will say, of course, Mark needs no introduction. I don't think I'm probably going to ask a lot of questions, but I'm going to now turn to Mark to take it away to talk about some of those SEC enforcement actions.
Certainly, and thank you, Bree. I don't know if I really need an introduction or not. I will say this: I hope none of you have met me in my professional career, and as part of that, that probably means you don't quite understand what we do. Obviously, we're a division within the SEC. We're different than exams. We have a different worldview, for lack of a better word. And so what we do is we conduct investigations. Those investigations get sparked in part by enforcement referrals from exams, apart from whistleblowers, apart from competitors. Doesn't really matter, but if it looks like it's a serious violation of the federal securities laws, we get involved. Our investigations are extensive and painful, unintentionally, but recognize we are going to be taking sworn testimony in all likelihood, not just from you, but from your clients and from your colleagues and from anybody who has any information that might be able to help us determine whether or not there's a federal securities law violation. We make a recommendation to the full commission, and yes, the reason the word commission is a part of our title, we literally have 5 commissioners who vote on whether or not to accept a recommendation. It's a painful process, I recognize, but it's a necessary one, particularly for people who are, frankly, simply burning their clients. And unfortunately, there are a fair number of those in this area. In the last 5 fiscal years, the Division of Enforcement has recommended and the Commission has approved a total of 15 cases against municipal advisors. 5 of those were not registered municipal advisors, but municipal advisors all the same, and another 16 against individuals at those firms. So a total of 30 actions here in the last 5 years. In case the message doesn't get through, yes, misconduct by municipal advisors is a priority of our unit. So take that for whatever it's worth. Recognize, of course, that we really get involved when the wheels appear to have fallen off one of your deals. So hopefully you won't have any massive blowups or craterings or things of that sort that will bring our attention. But what I do want to do is kind of go through on a high level some of the takeaways from those 30 actions. As I say, some of the cases are just egregious. I really do hope that none of you will ever find yourself in these situations. But I should also point out that 4 out of those 30 are in litigation. That is to say, either the firm or the individual or both have disputed our allegations, and we are in the midst of going through a trial to determine what the truth is. When I mention them, they are allegations. They're not findings of the commission. But with that, let me give you what I think of as the critical points. And much of this has already been covered. You could actually summarize everything I'm about to say by the simple admonition: everything you've heard so far today, take seriously. So for example, don't try to conduct municipal advisory activities without first getting registered, fully registered with both the SEC and the MSRB, and have someone who's in fact taken and passed the Series 50. And in a few months, we'll add to that and the Series 54 as needed. Emily has done a great job earlier about going through what it means to be a municipal advisor and the exceptions to those. And they're valuable, but we've had to bring cases against people who simply have conducted full-fledged municipal advisory activities out to closing without ever being registered. That is not a good idea. Don't do it. Number 2 in my hot list here is take your engagement letter seriously. You've heard extensively about what should be in there. I will take the opposite view. Sometimes the most critical thing in your engagement letter is what you are not going to do, what you have not agreed to do. Almost 5 years ago, we brought a case against First Southwest as financial advisor. They, frankly, never entered into an engagement letter. There was no meeting of the minds, and there was, to some degree, a good faith misunderstanding. They were convinced, that's to say First Southwest, that they did not need to do an extensive review of some projections by the underlying obligated person. The issuer thought they did. Of course, the thing blew up, which is why we were involved, and it was painful to see an individual with a fiduciary duty not clarifying with their own client what they were and were not doing. First off, we had to pay close to $200,000 to get out of that snafu. So take it seriously. As I say, it really is your friend. It really is a help. I don't care how detailed it is, but I do care that you're doing what you said you're going to do and you don't do what you said you're not going to do. And that's for your own benefit. 3, don't hide how you got the business or how you're going to get paid. We brought a case against a firm called Keygen in California. They are doing a bang-up job getting business from various school districts. It turns out they were paying finders who weren't telling the school districts that they were the ones lining up Keygen. Not a good idea. Keygen got disciplined for that. Similarly, don't take money that isn't very clearly authorized by your client. I know this seems simple, and I think it is, but we had a case where a municipal advisor provided an invoice to the bond trustee for payment out of bond proceeds. The city involved had never seen it and never authorized it. As you might be able to guess, that's not just simply an Arbalowick. He was arrested, and his trial is coming up soon for the criminal charges with respect to that. And there are lots of ways of playing that game. Don't, please don't. 4, take your services seriously. If you are saying that you're going to assist in preparing the official statement, then assist in preparing the official statement. Make comments on it, raise issues, ask questions, probe a little bit. Be genteel about it. I'm not asking you to be adversarial with your own client, but you're actually in a unique position to make sure that all of the hidden skeletons in the closet come out and are described accurately and appropriately in an official statement. Many times your issuer won't even think about it. One of the best pieces of advice I did as a young lawyer is sometimes the most important thing you do as a lawyer is to protect your client against itself. And that's exactly what an MA often has to do when it comes to disclosure. The issuer knows, but the issuer might not appreciate it's important. The issuer might try to hide it a little because it's a little embarrassing politically. And that's all fine, but it still has to be disclosed if it's material. And if you don't, yes, you can be sued. Actually, it's interesting. One of the earliest cases we have in this area happened 25 years ago against a municipal advisor named Peacock Hislop out of Phoenix. They knew their client had serious financial difficulties and cash flow issues that were not disclosed in the audited financial statements because, frankly, the audited financial statements were stale. But they didn't feel a need to update the OS. That's what happened 25 years ago. So take that seriously. Similarly, and we've had extensive discussions about this in an earlier panel, if you are going to be recommending a transaction as presented by the underwriter, that means you're signing off on the pricing as well, that it's a reasonable price. And that means you've got to get in there. You've got to talk about it with the underwriter. The one thing I found the most astounding is situations where, in essence, we hear from the MA, oh, I've known that firm that's acting as underwriter for years. I know Tommy on the trading desk personally. I trust him. He would never burn me. Okay, that's great. I'm glad that you have friends outside your family, but that doesn't fulfill your fiduciary duty. You have to get in there and push. If you have comparables, that's great. If you're going to compare it to indices, that's great, but document it. There's an old adage, and Gail, I think, hit this nail on the head earlier. There's an old adage and the old question of, well, if a tree falls in the forest and there's no one there to hear it, does it make a sound? In this area, it's not a question. If you haven't documented what you claim to be doing, the presumption is, frankly, you're lying. That's why we take your testimony under oath. And if you tell us, oh, yes, I did a bang-up job with comparable 3 years ago. I remember checking like 3 or 4 comparables to make sure that the pricing was effective. Oh, you did. Name the comparables. people aren't able, and it's human nature, you're not able to remember the 3 comparables you had 3 years ago. Hopefully you're busy enough that was the second or third one that week you were doing. So give yourself a break, write it down, be able to be in a position that when we show up, you're able to say, oh, here are my records. Here's the name of the 3 comparables. Oh, and that's right. According to my notes, the term block on the comparable really wasn't on the right year, so we had to adjust a little here, adjust a little there. Makes perfect sense. But remember, your record retention requirements 5 years. You better have it 5 years after that deal closed. What else? Conflicts are a real problem. And a particular problem with MAs with underwriters. And it's a function in part of the fact that you are going to be butting heads. If you're not butting heads at some point, no matter how genteelly, no matter how bluntly with the underwriter, you're probably not doing your job, particularly when it comes to pricing. That's why you exist. You're supposed to be the one on the issuer side of the table that can go mano a mano with the underwriter, okay? So think about that. Be careful with that. The choice case we just brought in litigation in part is about a pair of people who came from one underwriting firm and in midstream decide they become MAs on the same deals. And it was an absolute horror show because they were not in a position to push back and go mano a mano with the underwriting firm. And they will.
I'm going to jump in here and ask you a question. Thank you for all those audience participants that sent questions over prior to the panel. Question is, can you elaborate on the advice or recommendation concerning the selection of underwriters with respect to the issuance of municipal securities and MA's responsibility in this regard, related to the type of sale method and the utilization? So for example, a number of MAs folks are really good about giving us examples when there is nefarious activities with their partner down the street. For example, a number of MAs in specific states have the tendency to, 1, recommend one underwriter more than 90 to 95% of the time for the underwriting of the issuance, which they are serving as the MA on. Would this trigger concerns, if any?
I've heard this before, you'll hear it again. Maybe, maybe not, facts and circumstances. There are situations where there are underwriters who have a specialty, a niche. And within that niche, they're truly one of the best. And so you can see logically why an MA in that area who also has expertise in that niche can appropriately say, I've dealt with all 5 of them. I know them. I've worked with all 5 of them, and I know the strengths and weaknesses of all 5 of them. In your case, you should be going with X. That is a perfectly appropriate, valuable role for MA to play. Or an MA to say, look, don't take it personally. You're a boring, straightforward school district issue. I think you should go competitive because you're going to get the best price. Had you been a story bond, had you had issues, there are lots of contexts in which an MA might be able to say, again, quite honestly to their client, no, we really think you need to negotiate here. So it really just depends. I appreciate that there are some relationships that's so close. They are interesting. They have been interesting to us as well. But that's different than saying that there's something nefarious going on or that necessarily violates the federal security.
And Mark, can you just touch on, I'm sorry, was Jerry, Scott, anyone else with a question? Okay. So Mark, could you just touch on, again, unregistered MA activities? I know Emily covered it on her panel. Can you just maybe pull the curtain back and explain a little bit more about how you all go about receiving referrals of that information, the process and actually to review for this activity? Because we oftentimes hear there's so much unregistered activities that's going on and no one's doing anything about it. So just pull back the curtain a little bit.
Sure, and be aware, we get referrals or tips of unregistered MA activity frequently. We got an awful lot of them a few years ago. They're dying off a little bit, or sloping down a little bit. And they come in different categories. As Emily was able to point out, a lot of times engineers or lawyers have exceptions that apply. And so we will get honest, well-meaning complaints that engineering firm XYZ is in the process of doing a rate study, conducting MA activity. And you spend some time seeing what they're talking about and you realize, sorry, this guy has an exemption. But there are also tips, and I realize that our tips system is very automated. It is anonymous. Just go to our homepage, sec.gov, and about a third of the way down that homepage on the right-hand side is how to provide a tip for a complaint. Write it up. And we do get a number of them. Some of them are from competitors. Many of those are anonymous, but when someone is citing specific MSRB rules, I figured that it's not a common member of the public. If you can cite an MSRB rule to me and you're right about it, that means you're part of the industry. But nevertheless, the point here is that we do get a lot of these tips. We do take them seriously. And that often is the start of a much bigger case. If you do have someone who is acting as an MA without being fully registered, that's usually an indication that they're sloppy and that they're cutting corners. And if they're doing it with something like that, they're doing it elsewhere as well. One of the things you might note in the choice litigation that we filed is we cited them for acting as an unregistered MA. And it kind of unfolded from there. Make sense?
Makes sense. Mark, just another question that we have. Could Mark comment on how many municipal entities or obligated persons have been involved in some of these enforcement cases in the last 5 years?
Oh, absolutely. I mean, we go across the board. We've sued 3 states, a number of large cities, and obligated persons. And I will tell you, knowing the pipeline, we have plenty of those cases right now, particularly accounting cases. Right now, accounting is a real issue as well in our pipeline. So yes, we are, how could I phrase this politely? We're happy to sue any and all participants in the industry, so long as they've been violating the federal securities laws. And let's face reality, there are bad apples in every barrel, whether you're talking issuers, underwriters, MAs, and our job, frankly, is to clean out those bad apples so they don't taint the entire barrel.
Okay, maybe Mark, take 2 more minutes to go through other things that you want to make the audience aware, and then we'll take 2 more audience questions.
Okay. I want to make sure everybody's appreciative of the fact, and again, you've been hit over the head by this the entire day, but MAs have a fiduciary duty. That translates to a duty of loyalty and a duty of care. And you can violate that in ways that we have yet to litigate. We have yet to bring a case on. So don't look at my takeaways as, as long as I don't do any of the following 5 things that Zainer went through, I'm home free. No, you've got to be a proactive, concerned individual trying to put you in the shoes of your issuer client or obligated person client and make sure you're doing the best you can for them, not just making money for you. That's my spiel. 2 more questions.
All righty. I think, let's see, this question probably goes to, this question's for Carla and Michael. Does the SEC and FINRA intend to perform examinations of municipal advisors in person in 2022? So who would like to take that? I guess folks are wondering, would you be knocking at their door versus exam staying remote?
I can answer first. The SEC will be conducting examinations of municipal advisors, whether that's in person or not. I can't speak to that, unfortunately. That comes from the home office and way above my pay grade. So I can only say that yes, the municipal advisor field is wide open. We will be conducting those exams, whether it's in the field or not. That will be determined by the home office.
I think my answer is the same as Carla's, and paying attention to the FINRA website, and I'm sure they will make announcements. And for the dual registrants, your risk monitoring coordinators will be in constant contact if there's an exam, and it will be on site. But at this point, I don't know if a decision's been made for 2022 in that regard.
Okay, thank you all. Going back to Mark quickly. So Mark, can you just give us some thoughts about infrequent issuers and MAs, we had a pretty robust discussion about this and the reliance on their MAs for those infrequent issuers with respect to the public finance, but also other related activities to the deal. So just general thoughts on that relationship.
Well, I think the answer on that one is it's a sliding scale, and you will find inexperience. It's easy to look to a new, never before issued bonds client, such as a charter school, in which very clear it's founded by zealous people really caring about the education of children. But that usually translates to weakness in terms of financial matters. You can do a financing with a group that's very, very large, but not necessarily sophisticated. I remember a certain county in Alabama, Jefferson County, that at one point had more interest rate swaps than any other issuer short of the states of New York and California. And they were very large as a county, but not very sophisticated. And I think we all remember what happened to Jefferson County. It ultimately had to file for bankruptcy. So I think you really have to gauge your situation and the people you're dealing with on a one-on-one basis. You can have a very large issuer with unsophisticated individuals in charge. You can have a very small issuer with very sophisticated people. I once did a deal for a very small private school in Pennsylvania. Its chief financial officer had just left JP Morgan. They knew what they were doing. I learned a few things from him. So it is whatever it is, but you have to gauge and calibrate what you're doing depending upon the individual in front of you.
All right, thank you for that. And just to touch on the last question that we received, this was related, and I guess I'll take this question. It was related to social media. The question was specifically about what is permissible related to social media. The questioner also asked if they could actually make particular statements about having some of their issuer clients and that relationship as part of their social media posts. I would say there is an FAQ regarding the use of social media. This is dated August 23rd, 2019. This is a really wealth of information out there. So first of all, when you are referring to the services of the MA, all right, or any type of engagements, that is deemed advertisement. Even if you're basically making the post on your social media website, that is deemed advertisement, which means it also needs to comport with the content standards, and it also needs to be subject to pre-approval prior to first use. Pre-approval has to be done by a principal. So I wanted to just make that clear that firms can use social media. It is permissible. Just be mindful of the content itself, and that the content itself may trigger the content standards by virtue of the fact that is now deemed an advertisement. I also did want to touch on as well, be mindful with respect to social media posts about adoption and entanglement, because part of the question was, oh, well, what if basically the issuer client says good things about what is on the dealer, on the MA's social media platform. It is perfectly okay for your issuer clients to speak positivity about the firm. Just be mindful about somehow preparing statements for the issuer client that's posted on your social media website, because then, as mentioned, I think Scott touched on earlier, you're then subject now to entanglement. What have you done? And so now that you've entangled yourself with that particular statement by your issuer client, now you're subject to the review for advertisement. So just wanted to make it clear, feel free to post on your social media site, and feel free to have your issuer clients, to the extent they say something nice, let them speak positivity without you interfering. Last thing, since I was plugging our resources, our Compliance Resource Center has a wealth of good information for municipal advisors. So I encourage you to review that and to take advantage of that information. And lastly, the MSRB is always available to receive questions, comments, MSRB support. The telephone number is 202-838-1330. Again, that's 202-838-1330. We want to hear from you. With that, I would like to thank my panelists. This has been a great discussion. It was fun working with you all, and have a good evening to everyone.
Please stand by for closing remarks from Yolanda Trotman Adewumi, Vice President, Specialist Programs, FINRA.
Good afternoon, everyone. Apologies for the technical difficulties. Thank you all for attending today's conference. I am Yolanda Trotman-Adewumi, FINRA's Vice President of Specialist Programs. We are happy to see such a strong turnout of market participants from throughout the country. I oversee the FINRA Fixed Income Specialist team that examines all municipal advisors that are FINRA members, so I'm especially happy to have the opportunity to speak to you and close out the day's proceedings. FINRA recognizes the important role issuers play in the U.S. capital markets and has devoted significant resources to ensuring our staff understand municipal advisors' obligations to municipalities. Today's panels covered a wide range of topics, from how to submit and update municipal advisor registration filings, to how to handle conflict of interest disclosures, to examination and enforcement findings. We have attempted to tailor today's conversations to address issues in the municipal advisor space that are particularly relevant to you based on what we've learned through interactions with municipal advisors and their clients. We encourage ongoing dialogue between regulators and regulated entities to address issues proactively and to ensure the industry receives the guidance it needs. I hope you leave today's event having learned something that you can take back to your firm. Please reach out to us at the SEC, MSRB, or FINRA if you have questions that we did not answer today or other questions. We are always happy to be of assistance. To our colleagues at the SEC and MSRB, thank you for partnering with us again to make this event happen for the 6th time since 2014. The planning team's hard work was evident in the thoughtful and informative panels that were clearly designed to help municipal advisors understand and comply with their regulatory obligations. Thank you to the panelists and moderators, especially those from the industry who participated today. We appreciate your insights and dialogue, which allow us to incorporate practical, real-world scenarios as we discuss the application of rules to often very nuanced municipal advisory activities. This creates a richer educational experience for everyone. Finally, we ask that you please complete a brief evaluation that will be emailed to you shortly. Your feedback will help us improve and develop content for future events. Thank you again for attending today's conference and have a great evening.